technical bid was open.
Huh.
And 3 persons who have no credential
Huh.
has been allowed to participate in the financial bid.
Huh.
I have challenged that order, my lord.
When the tender notice was issued.
Tender notice was issued on 2nd January.
Correct.
Financial bid open on technical bid open on 27th January.
Huh.
You
have participated?
Yes.
Yes. What is your grievance?
My grievance is 3 persons who have been allowed in the financial bid. My lord, they are not fulfilling the criteria of 5 years experience of running the same type of service. My lord.
So when it will finalize? It
My lord,
might be finalized by this time.
My lord, on 1st February, the position of the ghat will be given. My lord.
So once the tender is open, what remains?
But I am challenging the selection of those 3 persons who have no credential as per tender notice. My lord.
Okay. Issue notice. Come tomorrow.
Great.
Issue notice to the other side. Leave granted to file. Let matter listed tomorrow as new motion.
Great.
My lord, this I am the plaintiff petitioner, my lord. None.
Yes.
My lord, in this matter, my lord, in GA1, the affidavits are complete. GA2, my lord, is my learned friend's vacating application, my lord, where I have filed my opposition. They're yet to file their reply. And my lord, the interim order is expiring today. But I'm not aware, my lord, why this has come up as a to be mentioned, my lord. We have not mentioned.
My lord, I'm being for the defendants.
It was returnable today, my lord, after exchange of affidavits, but not under this heading.
To be mentioned में आया. Date हो गया. Yes, then.
My lord, I'm for the defendants. My request is that my lords may put up to 2 weeks for arguments, my lord, for the injunction application, because our grievance only is that in the meantime the construction is going on. Second, my lord, what has happened is, probably my learned friend will not dispute it, my lords had said that our amendment application to the change of premises
this is a defamation suit, my lord,
Yes.
in the city court.
Is
They
pending.
have filed.
Now, what is happening, my lord? The city court is not proceeding basis the matter is pending on the high court.
I already clarified with the city court is liberty to come proceed with the matter with regard to your amendment.
Absolutely,
We
my
did.
lord.
We made that submission. We made that submission, but it didn't
The
sail
scope
through in
of
the
this
court.
suit, my lord, is very limited. It's confined to the
I
defamation issue.
understand, but my
The
lord,
question that the construction is being still raised
Okay,
and all
you
that
have
does
not
not
filed the
come here.
affidavit.
my lord, we have filed at section 39(4). My lord may put it next after 2 weeks. In the meantime, if there is an affidavit, I'll file it and put it for arguments. We can argue about the injunction application.
My lord, sure.
But my lord,
Yes.
she is my colleague, my lord.
So appearing for the plaintiff. So appearing for the defendants. In both, what only one GA2? What about the
GA1 and 2, my lord?
GA1, my lord,
39(1) and 2 and my 39(4).
All affidavits are completed. GA1, my lord. In GA2, their reply is
I'll
left.
file a rejoinder, my lord, within a week's time, and my lord may put it after 2 weeks. I'll give an advance copy.
Being GA1 of 2024, praying interim order. Full stop. The defendant has filed an application being GA2 of 2024, praying for vacating the ad interim injunction granted by this court. It is submitted that as regards GA1 of 2024, pleadings have been completed, and in connection with GA2 of 2024, the counsel for the defendant prays for extension of time to file affidavit in reply to the affidavit in opposition filed by the plaintiff. In view of the submission, full stop. Let affidavit in reply be filed in connection with GA2 of 2024 within a week from date. Full stop. Counsel for the plaintiff submits that the interim order granted earlier is going to be expired today and paid for extension of interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till February 2025 or until further order, whichever is earlier. List the matter for hearing of both applications on 13th of February 2020.
13th of February. Deeply grateful.
Under the heading adjourn motion.
I'm grateful.
Deeply grateful.
My lord, I appear for the plaintiff in this matter.
Yes.
My lord will kindly see the last order. That is of, my lord, 16th January.
15 January.
15th and 16th January, my lord, the matter was appearing. This is a partition suit, my lord. There's an interim order that has been continuing since, my lord, January 2021. Parties have effectively settled the matter, my lord. There's a draft terms of settlement also that has been arrived at, but there are 62 defendants. My lord, they're scattered over the world, so it's taking some time to get them together and sign the settlement petition, my lord. That is one. And the other aspect is, my lord, we'll see from the order of 15 January 2025, my lord. Defendant number 15 has expired. His heirs are already on record, my lord. Department was directed to carry out the necessary amendment. That is all that is required, my lord. Amendment has been carried out, my lord. My lord, the interim order is still continuing to the 26th of February 2025.
Interim extended?
Yes, my lord. Lordship will kindly see the order of 16 January, my lord. It is extended the interim order till the 26th of
16 January.
My lord, I can hand it. In subsistence till the 26th of February, my lord. My lord may extend it further, my lord, to allow us to come back and, my lord, place the settlement before my lords.
Okay. So appearing for the plaintiff. You are appearing for all?
Defendants.
All.
No, your lordship, from 16 to 21. I'll write it down.
So appearing for the defendant number 16 to 21, 31 to 36, and 43 to 56.
Your lordship.
56. For the counsel for the parties submit that the matter is going to be settled between the parties and requires some time to file the deed of settlement. Full stop. In view of full stop. Counsel for the plaintiff further submit that the interim order granted till here is going to be expired. Is extended till 26th of February 2025. In view of the above, let the matter appear on 26th of February 2025.
Little more time may be granted, my lord.
Interim order is there. Come on that.
Very well.
If not, I will accept.
I'm grateful.
Grateful, your lordship.
Under the heading, new motion.
Your Lordship, I am appearing on behalf of the propound.
Yes.
Your Lordship, initially this probate application was filed stating that both the attesting witnesses had passed away. But thereafter, Your Lordship, pursuant to Your Lordship's predecessor, on
A special citation be issued upon the attesting witness.
Yes, thereafter it was modified by the order of 1st October as notice to the attesting witness. Now, Your Lordship, we have obtained a report from the department stating one of the attesting witnesses have passed away and the other person is still alive. Now, that attesting witness has come forward, and Your Lordship, he has already affirmed an affidavit of the attesting witness, declaration, and given vakalatnama. Now, Your Lordship, I am only seeking for leave to file the same, because initially the probate application was filed stating that both the attesting witnesses had passed away.
Both the attesting witness passed away. So you are not amended that?
Not yet, Your Lordship. Your Lordship, may I be kindly allowed to file this?
How?
Because Your Lordship, now after the why I am saying
that's correct. Now after the order passed by this court, notices were issued. After the notice, you came to know one witness died, one witness is alive.
Yes.
One witness has come to you, and now you are filing the affidavit of of the attesting witness.
And Your Lordship, thereafter I can amend the probate application.
Correct. You have to amend the probate.
Yes, absolutely. I have
before accepting this. How before accepting the before your amendment, how the
because
your
Your Lordship,
can be
if
accepted,
the attesting witness have been served by this honorable court to appear before this honorable court,
come the application today itself. So both can be done. Otherwise, how it can be? Whether horse will be first or the cart will be first.
Yes, Your Lordship, I appreciate what has fallen from Your Lordship. Your
averment is to be amended first, then your affidavit can be accepted.
I thought it could be the other way around also, because the attesting witness is coming on his own pursuant to this honorable court's notice.
It's not dispute. The court is not disputing to that. But once you have made an averment in your application, both the attesting witness passed away. on the basis of that statement, how this court can accept the affidavit of the attesting witness who died as per your submission?
Very well. I shall come
Suffering
back.
for the petitioner. Counsel for the petitioner submit that in terms of the order passed by this court, comma, the petitioner has taken appropriate steps for issuance of notices upon the attesting witnesses. Full stop. After issuance of the notice, comma, on the petitioner has received a report from the department wherein it reveals that one attesting witness of the will has already passed away and one attesting witness is alive. The said attesting witness has now come forward to file the affidavit in the present case. But full stop. It is fine from the record, comma, in the probate application, comma, the petitioner has made an specific averment that both the attesting witnesses have passed away. Now, from the report, it is revealed that one attesting witness is alive and the attesting witness is also affirmed an affidavit. In view of the above, the counsel for the petitioner prays for time for taking appropriate steps for amendment in the probate application. As per the submission made by the counsel for the petitioner, the case is adjourned for 2 weeks.
Your Lordship kindly keeps
For
it
2
for
weeks?
4 weeks.
Huh?
4 weeks, Your Lordship.
4 weeks. Let the matter appear on 3rd of March 2025.
The propounder does not stay within the limits of Calcutta, Your Lordship.
Next. Up to the
I'm on behalf of the petitioner.
Just a minute.
Lordship.
कितना बजे? 4:15. याद दिला देना. Nothing ही बैठे रहे. Yes.
Lordship, I am on behalf of the petitioner in this matter, and this is an application for letters of administration. Lordship, you on 10th of January 2025, this matter came up for hearing, and your Lordship was pleased to direct for issuance of citation, both special and general. And now the thing is, the petitioner is the only heiress of late Aurobindo Chatterjee, being the deceased, and she is the only heiress and only beneficiary. So apart from her, there is no other legal heir. So kindly, if you can direct that if the citation would be served on her at the said address, given address.
Given the consent.
Yes, she is a petitioner.
Where is her application?
Here.
This is an application for?
Letters of administration.
Letters of
Yes, Lordship.
She is the wife.
Yes.
She is the wife of the testator.
Yes.
What is the age?
Now it is 56. Now she is 56.
And husband died in 1967.
Nah, he died in 2021, 25th May 2021. Death certificate is there.
Father of the petitioner, Chatterjee died in.
Yes, and mother also. Yes.
This is the property from the mother side.
Father side.
Father side of the petitioner.
Father side.
Father side
of the deceased.
Father side of the deceased.
Yes.
The father of the deceased. Acha. Okay. So and so appearing for the petitioner. By an order dated 10th of January 2025, this court passed an order directing the petitioner to take appropriate step issuance of special and general citation. Special and general citation, full stop. When the petitioner has taken appropriate steps, the office has found that the petitioner is the only legal heir of the deceased, and as such, it is not possible for issuance of special citation and general citation. It is also found from the report that no prayer for issuance of general citation and special citation, issuance of general and special citation is prayed for. Considering the above, this court find that the petitioner is the only legal heir of the deceased who is claiming the letters of administration, and as such, there is no requirement for issuance of special and general citation. Accordingly, order dated 10th of January 2025 is accordingly modified. Let the matter appear. When? Tomorrow? Let the matter appear.
Tomorrow or next
Let
week.
the matter appear on 6th of February.
6th of February.
Under the heading testamentum.
Your Lordship, I am for the defendant number 1. I am opposing the extension of prayer for
GA2 is my application. My lord, firstly,
Yes.
my lord, I don't know why this has come up as to be mentioned. We have not mentioned it at least, my lord. Regardless, my lord, the interim order granted by my lord
Why
is
to be
expired.
mentioned again?
We did
Same
not
thing.
mention it.
कौन किया मैंने?
We did not mention it.
I think it's for extension.
We have not mentioned that
Because
much
they don't
is
want
my
to
instruction.
execute
We would have mentioned at the time of rising today, but my lord, it's come up as to be mentioned.
Yes.
My lord, the interim order is expiring on 29th. My lord, I'm enjoying an interim order in respect of GA2. In respect of GA2, my lord. That, my lord, my lord will kindly have my lord's last order of 13 December 2024. My lord, the defendant number 1 who's...
When the interim order was passed?
My lord, interim order was passed much prior. My lord, in July of last year. My lord. July of last year.
When it was extended?
My lord, extending from time to time. My lord, lastly on December 2024. My lord, by my lord. My lord, the last order is dated 19 December 2024. My lord, I'm seeking extension. My lord, will kindly see from that order the defendant number 1 who's...
the defendant number 2.
2.
Yes.
Defendant number 1 had sought time to file a
What is the
rejoinder.
stage of the suit?
My lord, is a testamentary suit. My lord.
Yes, what is the stage of the suit?
Well, it is nothing as yet. Well, it's just been declared as a
testamentary.
Contentious cause.
Contentious cause, my lord, so it's pending, my lord. And there's an application, my lord. For the time being, I'm supporting him because, my lord, I do not want the properties of the testator to be disposed of in any manner, and it is being disposed of. So, my lord, I will support this. At this moment, my lord, kindly extends the interim order. At least
And
the
I am opposing.
property should be protected.
I am opposing because the injunction is on the property which does not belong to
State
the
of the
testator.
testator.
That
And will be
if
decided.
Today they decide on that, my lord. Then, my lord, the property will be dissipated.
My lord, one more fact, my lord, I'd like to bring. My lord, 19 December 2024, my lord, the defendant number 1 had sought time to file a rejoinder. They had sought time, my lord, had granted them the time. We are not in receipt of any rejoinder.
No, they're
So-
not rejoinders. Sir, rejoinder, we have sought a leave. So I am only praying for it's ready, but the deponent who was supposed to sign is not in town. I'm just seeking a 7 days time to file the sir rejoinder.
Then in
Yes.
that even, my lord,
Yes. Extended.
But a date be fixed for the final hearing, Your Lordship.
yes.
Now, I wondered to what is the stage of the suit. That is the problem before this court.
Yes, my lord.
Only the advocates are interested with the interlocutory.
We have filed our
and all
affidavit
these
in support of caveat.
I will proceed with the matter. I will
Yes.
proceed with the-
We are ready. Even we are ready.
I want to proceed.
so and so appearing for the plaintiff, so and so appearing for the defendant number 1, and so and so for defendant number 2. Counsel for the defendant number 2 submit that the defendant number 2 has filed an application being GA2 of 2024, praying for interim order, and accordingly this court has granted interim order, which is extended from time to time and is going to be expired today, and prayed for extension of interim. Full stop. Counsel for the defendant number 1. Prays for extension of time to file rejoinder to the reply filed by the defendant number 2. Let rejoinder be filed to the affidavit in reply of the defendant number 2 by the defendant number 1 within a week.
7 days.
Within a week from date. In view of the submission made by the counsel for the parties, the interim order granted earlier is extended till 19th of February 2025 or until further order, whichever is earlier. Full stop. What is about the suit?
Testamentary suit, my lord.
Discovery and instruction
Not yet
completed.
done, my lord. My lord will pass
Full
that
stop.
on this elections.
The parties are directed to complete the discovery and inspection of the document within 2 weeks from date. Full stop. Reply. Full stop. Affidavit of admission. Affidavit of document be filed within a week thereafter. Full stop. List the matter on 7th. क्या डेट बोला? 2 weeks 1 week बोला है ना? आज कितना तारीख है?
1850
Then वो करो extension till 26 February कर दीजिए. 26 February. List the matter on 26 February. 26 February for hearing of the interlocutory application and for framing of issues.
Well, we'll bring our suggested issues on that day. We'll bring our suggested issues on that.
Issue.
The matter be listed under the heading testament issues. The matter be listed under the heading testament issues. Yes.
Well, in this matter, I am for the petitioner.
Item number 5.
6. Item number 6. Well, what has happened?
Yes.
Well, by order dated 21st of August 2024, His Lordship directed us to file the to submit the issuance of general citation and publication of the gist of general citation in newspaper, and that order was complied with. But my lord, by mistakenly, it was recorded that the matter is disposed of in the server. Well, it should be heard and final order should be passed. All formalities have been complied. No caveat certificate has also been issued.
Let me call the report how it has come as a disposal by the.
In the server, it is showing as disposed of.
That's why let the court ascertain how it has been disposed of.
Yes.
So what about the 21st of August 2024 your order
That has been complied.
So what has happened now?
My lord, we have published the gist of the general citation on special citation in newspapers, and we have also submitted that.
No caveat certificate is
no caveat certificate has been issued, my lord.
So and so appearing for the petitioner. By an order dated 21st of August 2024, this court has granted liberty to the petitioner for issuance of general citation and for publication of gist of the general citation in English newspaper, the Daily Telegram and Bangla newspaper, Ananda Bazar Patrika. Counsel for the petitioner submit that the petitioner has complied with the said order and publications have been made, general citations have been issued and publication has been made, but no caveat has been lodged, and accordingly the department has submitted no caveat certificate on 14th of January 2025. But it is fine from the record in the server, it is shown that the testament, the PLA number 105,
my lord.
Hey, filing number PLA 106.
That is the filing number.
PLA number 105 2023. क्या बोला? In the server, recorded that PLA number 105 2023 as disposed of. Is disposed of. Accordingly, the IT department is directed to submit report under which circumstances The status of the case has been shown in the process in the server as disposed of within a week from date. Let the matter appear on 11th of February 2025.
This matter has come in the list of my instance. Yes, yes. Yesterday I had mentioned the matter.
I appear
my
for the respondent, Administration General Office.
my lord, I had mentioned the matter because, my lord, your lordship has been pleased to pass a direction on 5th of December 2024. As the topography was not available, though everything was complete, but because of this, the deed of conveyance could not be executed.
Lord, possibly there is some misunderstanding.
No, it is not. There is no misunderstanding, Mr. Bose. Let me explain.
Yes.
My land friend had taken out an application that is
No.
different.
She has mentioned.
I
will hear you.
My land, thereafter, my lord, since the topography was not available and the area of the building constructed thereon was not available, my lord, the deed of conveyance could not have been executed, my lord. Thereafter, we mentioned the matter before your lordship. Your lordship.
So now, what is the problem?
Problem is this, my lord, that we have been informed by the Administrator General, my lord, that says there are a lot of encroachers at the property. So, my lord, until unless the District Commissioner Ranchi provides necessary assistance, my lord, it is not possible to take the measurement. Kindly take this letter, which has been given by the Deputy Commissioner to the Deputy Commissioner Ranchi.
Then now
Now, the Deputy Commissioner Ranchi says that until unless there is a direction from the Honorable High Court, the assistance cannot be provided.
Can I call the district collector? Whether the district collector is not an authority to take appropriate step for demarcation of the property in question, whether he is required the order from the court.
No,
He is the district collector.
Yes.
He is the whole soul in charge of the district.
But he says that necessary direction should be given upon us. This is what has been.
Let me come here before this court. I will say how the direction is to be given by this court to the district collector for the demarcation of the property in question.
We have.
So whether he thinks that the court is a tahsildar.
It should not be, my lord. In fact, he ought to have complied with the direction.
So why you are mentioning before this court? You could have been write to the letter to the district collector.
My lord,
this is not the way of the.
For the AGOT to write, my lord, I am the purchaser.
So you have mentioned the matter. AGOT has not mentioned the matter
because my conveyance has not been executed. For this reason, I had mentioned.
You are the senior advocate. You know what submission is to be made before the court.
Lord, my client is suffering for this reason.
Your client might be suffering, and you make any submission before this court. The district collector stated that take the demarcation order from the court.
No,
though the district collector is the whole soul in charge of the district.
Commissioner has said that direction should be given upon him to provide assistance.
What assistance? Whether he has written the letter to the police authority?
We do not know. We have been told by AGOT, my lord. I don't have.
Whether he has write a letter to the police authority for protection.
Have been given this letter, my lord.
I am not saying that. Whether the district collector has requested the police authority to provide the police for demarcation of the property in question.
Yes, my lord.
Where?
AGOT has written the letter to.
Yes, I am asking, madam, again, you're seeing.
My lord, I am not aware, my lord, that.
So why you are making submission? You could have been ascertain all the things.
My lord, I have ascertained, my lord, we have been informed, my lord, that survey could not be completed because the Deputy Commissioner Ranchi did not provide the assistance, my lord.
So you could, so what can be done? This court has already passed an order. Your auction has been accepted. It is your duty. The court is not nothing to do this. Whether you get the property, whether you will not get the property, you already inspected the property, you have came before this court, you have cited the amount, this court has accepted and the court has passed an order.
Yes, we have paid
this is your attack, whether you take the possession, you not take the possession. If you are not taking the possession, given right and the other party is ready.
We have taken the possession, my lord, we have paid the entire consideration money. Draft deed has been approved.
Mr. Bose, what is the contention?
Draft deed has been approved.
Yes, okay. Yes, Mr. Bose, what is the contention?
Lord, we've taken out an application which was considered on the last day, but Mrs. Manette was opposing.
Yes.
So she was on the virtual platform. So she sought for an accommodation on personal ground. So it was kept today. Lord, this is an application, Lord, by a third party.
Of GA1?
Lord, this is GA1.
Yes. Have you received the copy, madam?
Yes. The earlier occasion, Mr. Arindam Banerjee had given me a copy in the court, my lord.
So you want to file affidavit?
May I just take 2 minutes of your lordship's time, my lord? my lord, we seek to, my lord, pursuant to your lordship's orders, we've been able to ascertain, my lord, we are admittedly late in making our offer, my lord. Admittedly, my lord, this is a trust property. So lord, we wish to make an offer much higher than the price at which the sale appears to have been confirmed by this court by the order of 28th of August 2024. Now, my lord, admittedly from the orders, it transpires that the sale has not been concluded. It has been confirmed, but it appears from the orders even till December. Well, some survey is going on. Initial 25% of paid, but thereafter, at least orders don't reflect that the entire consideration has been paid. So, but if sale has not been confirmed or conveyance has not been, there has been no transfer of title. My lord, I, as a purchaser, as a prospective purchaser, my lord, I wish to make an offer higher than that made by, so my lord, higher in the sense of much higher than that. So, my lord, this actually it may prejudice the interest of the buyer, but definitely would not prejudice the interest of the trust, because naturally, the higher the offer, the better it is for them. So this is in effect, in substance, this is my application.
Let's see,
so I have brought a.
She will be there. No, let it be criminal. She will be the affected.
Yes,
person.
of
Let's
course.
see, file the affidavit.
And my lord, then in the meantime, conveyance should not be executed. If the title passes, then everything.
Finally, see the act.
Yeah, I can understand. My lord, let this act continue. Well, if this tehsildar business goes on, but in the meantime, my lord, kindly direct the official trustee not to execute the convey.
May I file my
Then my
minute
application
and
become
the
infraction.
documents in support of payment of the consideration? My lord, only photocopies for the records of the
What? This is the total amount.
lordship. The entire amount has now been deposited. This may kindly be kept to the records, my lord, and this is the minute of the Administrator General also may be kept to the records, my lord. No,
While placing the record, please see the
lordship,
record.
I just, my lord, I've been handed over just now, my lord. I apologize, my lord. Just now I've seen. No. আচ্ছা উল্টো করে লাগিয়ে দিয়েছি কি বলবো এরা না দেখেন না কিছু I apologize, my lord. And my report is there also.
So and so offering for the petitioner. So and so offering for the purchaser, and so and so offering for the intervener / applicant. Full stop. The petitioner has the Administrator General of Official Trustee West Bengal had submitted a report along with the copy of demand draft.
Lordship,
demand draft of rupees 5 crore 50 lakhs paid by the purchaser to the Administrator General of the Official Trustee West Bengal in terms of the order passed by this court. Let the report submitted by the Official Trustee be kept with the record. Full stop. The applicant has filed the present application offering the amount more than the purchased amount by the purchaser. Full stop. The purchaser intend to file affidavit in opposition in connection with the said application being GA1 of 2024. That affidavit in opposition filed within 2 weeks.
Within 1 week, I
Within 1 week, reply if any there to be
3
filed.
days.
Within 3 days thereafter. Full stop. Let the matter appear on
Now check the
13th of February 2024.
My lord, may I just, this is of course, my lord, this is my respectful submission. My lord, to test the bona fide of my client, my lord, allow me to deposit the 25% subject to the result of the application. Allow me to deposit then, so that they can't say that I'm a fly-by-night operator.
The court is here.
Yes, that's what I'm saying.
Decide
Allow
the
me to
court.
deposit
No, no,
with
no,
the without prejudice to the rights of the
Sorry, sorry,
parties,
sorry.
and
Let the
thereafter
matter
your
appear on
lordship.
13th
Very
February.
good, 13. Good.
Adjourn.
And my lord, in the meantime, the conveyance should not be executed. Money has come today, is as per the report.
It has been paid on 8th of January.
Nothing will be done, Mr. Bum.
Very, very.
What? Huh? अच्छा, appellate side.
For the response number 8, my lord.
Appellate side, then I will call.
I am for the petition. I am led by Mr.
Yes, give the file.
for the petitioner.
Yes. Who is for the Pradhan and Secretary?
Rajiv, that is item number 2.
Item number 2. Yes. Okay. One. Who is appealing for?
Different matter.
This is a new one?
Yes,
It's a different
Okay.
it's a fresh matter.
Okay.
That so we have participated.
Yes.
We have participated, Millet, in an auction process of a ferry ghat, conducted by Bolagor Municipal Panchayat Samiti by Hooghly.
Who is for the authority?
I have served.
Yes, I am for the state, my lord. কি নাম বলো তো?
এটা হচ্ছে
রাজেন্দ্র?
রাজেন্দ্র কুমার Shaw.
Yes.
Yes.
My letter is appearing for the state. The Panchayat Samiti has been served by mail because yesterday the leave was granted by your lordship. I could not serve them by post, but I have served them by mail.
Yes.
It's a very short matter. If your lordship takes up, paragraph 3 of the petition once. The case of the petitioner is that Bolagor Panchayat Samiti has leased out a ferry ghat starting from 1st of February 2023 to 31st of January 2025. But I am the highest bidder and I am running the ferry ghat without any problem. But the difficulty is, kindly turns to paragraph 5. There are two parts. First is that up to 31st of January 2025, the Bolagor Panchayat Samiti will have the control over the ferry ghat. And from 1st of February 2025 to 31st of January 2027, another Ranaghat 1 Panchayat Samiti will have the control of the ferry ghat. Now the difficulty is this tender notice, if your lordship kindly consider, at page 18, has been issued by the executive officer of the Ranaghat 1 Panchayat Samiti on 2nd of January 2025. Kindly turns to page 18 once.
Yes.
The publishing date is 3rd of January 2025.
Yes.
The document to be submitted by so-and-so date. And technical opening bid on so-and-so date, 27th of January. Financial bid will open on 27th of January. My lord, got it?
Yes.
Yes. Now the difficulty is why I am before your lordship. But this notice was never displayed at any public place, which is a mandatory provision.
Have you participated?
No.
How can I?
And, my lord,
I am asking the question to him. I will come to you. I will not pass any order without hearing you, sir.
I'm so grateful. Kindly turns to clause 93, procedure for tender. It is also good. It said that this notice, tender notice, has to be displayed at the public place. Left and middle portion 93.
Procedure for tender.
Yes.
স্টেপল করে দাও না কি সত্যি সেটা সব এমন ভাবে দেয় ওটা এগুলো কোথায় রিপোর্ট গুলো কোথায় একটা রিপোর্ট পেয়েছি বাকি
Yes.
রিপোর্ট গুলো কোথায়?
Now, this is a very short point. That matter whether this tender notice
So
at page
your
18
allegation that page 18, which is the tender notice, it is not published.
Absolutely. So we could not able to participate in
They have
tender
not
process.
complied with the provisions of Rule
Yes,
93.
this is number one. And number two is kindly have a look to page 17 was the earlier page. It's in Bengali for your lordship's convenience. I'm placing it. The earlier Panchayat Samiti on 31st of January 2023 has executed this agreement with me. So I am having the tender till tomorrow. So the next part is page 18, which I am placing before lordship. Whether this tender notice has ever been displayed to any public place or not, that is my case.
So first once the earlier agreement which was executed, you know that your tender is going to be expired on 31st of January 2025. Correct. And you sit quiet. Now at the last moment you are coming that the tender notice, because you have not paid for any application, that you are not published the tender notice, let I may be continue till the final. Have you make any?
No. But my case is something else. But I'm absolutely on the legal point that the respondents are duty bound because they are statutory authorities.
That is correct. That I have gone through. That I have gone through.
But if this would have been done, I could have participated. But I'm here before your lordship, with bona fide intention.
That's all.
That's it has already been published in 2 newspapers. 3 newspapers.
Show me.
Yes.
Oi, सामने देखिए ना.
3 newspapers.
अच्छा.
Anandabazar, Indian Express. Anandabazar Patrika, Bengali, famous Bengali Patrika, the Indian Express and Sanmad. And all the advertisements are annexed.
When it was published, sir?
It was on 4th.
4th of January.
4th of January. And he cannot claim monopoly on the business. It is e-auction, public auction.
Yes.
Open tender. E-auction tender. একটুখানি করে দেবেন আমার মনে হয় আমার সকালবেলা এমন এসেছে মানে আমি করতেও পারিনি
But has it been displayed in the public place according to law? Paper publication is not public place.
Once
Website.
it is published,
Website.
you know, once the tender notice is published in the newspaper. So, and you are already.
As per rule, it has to be done in the public place. I'm simply on that. Newspaper and public place. There is an and.
And website of the the panchayat, that is also been published. Website.
The tender notice shall be invited in the most open and fair manner, advertise the local newspapers, and by display the notices.
And
have you displayed?
My lord, kindly see, my lord, it has been displayed in the paragraph 10 in the website.
Website.
Yes.
Website is not a public place.
My lord, regular paper has been given, 3 papers.
Okay. So with the tender notice has been published, it was pasted in the notice board of your panchayat?
Yes, my lord.
Yes, where is that? Show me.
Now it is, my lord, e-tender, and according to the e-tender, 3 news, it should be published in the newspapers, and it has been done.
Let it be published in the public place. I will participate in the tender process.
How?
Have you given the
Yes,
this? Kindly come to your page 20.
Page
Your
20.
page 20.
Yes.
Last serial number 50. Notice board. Serial number 50. Notice board of the office.
Yes, notice board of the office.
Correct.
Yes.
That has been done.
That
That
has
has not
been
been done.
Not done, then that is the matter of the fact. You file the affidavit. Yes.
But, what is submitted before your lordship by the state. Well, at that notice board, no public notice was given.
Okay, deal with the affidavit. Deal with the affidavit. Yes.
Well, the entire purpose of moving the writ petition.
Yes, sir. Publication was made. 3 paper publications were made. You have not participated in the tender. You had the knowledge that your tender, your time period is going to be expired on 31st of January.
True,
Now,
that is
28 January, you came with an writ application, no publication, no paper. The notice has been pasted in the notice board. But the paper publication is much better than the notice board. And in the notice which you are relying upon, that notice itself shows that the notice of the office. Let they produce the
No. Well, at page 49 and 50, kindly have a look. Well, kindly give me 1 minute time.
Yes.
Well, at 49 is newspaper.
Correct.
Then notice board of the office. Where is the notice board of the office? No.
Okay, let
Let them.
the deal in the affidavit.
Yes.
Prima facie, there is no case, sir. So and so appearing for the petitioner. So and so appearing for the state respondent. The petitioner has filed the present application challenging the tender notice, tender notice, yeah. ये है page 18 e-tender 02/RGT-Roman 1/2024-25 wherein it is mentioned that ferry guards to be auctioned for a period from the month of February 2025, 1st February 2025 to 31st of January 2027. The counsel for the petitioner submit that at present, the petitioner is running the ferry in the said area, and the period of the tenure of the petition is going to be expired on 31st of January 2025. Counsel for the petitioner submit that the e-tender notice on the basis of which the tender has been called for auction of the ferry guard for a period of 1st February 2025 to 31st of January 2027 is not be placed in the notice board, and thus they have not complied with the provisions of Rule 93 of the West Bengal Panchayat. What is the West Bengal? What is the law?
It said
West Bengal Panchayat accounts and
Panchayat Samiti accounts and finance rules 2003.
Finance rule 2003. Okay. Full stop.
Paragraph 8, page 5.
Correct. The counsel for the petitioner submit that as the respondents have not complied with the said provision, and as such the tender notice, the respondent cannot act in terms of the tender notice and prayed for a stay of the said tender. Per contra, an advocate appearing for the state has produced the document showing that the tender notice were published on 4th of January 2025 in the English daily newspaper, the Indian Express, Bangla daily newspaper, Ananda Bazar Patrika, and Hindi daily newspaper, Sanmark. Counsel for the petition submitted the tender notice was also placed in the notice board of the office, but in spite of publication of the tender notice in all the 3 newspaper, the petitioner failed to participate in the said tender. Counsel for the respondent submitted as the petitioner is continuing the said ferry service and his tenure is going to be expired on 31st of January 2025, only to continue his service without participating in the process server has in the e-tender process, the petitioner has filed the present application. heard the learned counsel for the respective parties, produce the materials on record. The petitioner has filed the present application only on the ground that the e-tender notice were not published and not placed in the notice board in compliance of Rule 93 of the Accounts and Finance Rules 2003. Per contra, the learned advocate appearing for the estate has produced the document showing that the tender notice were duly published in the English, Bangla and Hindi newspaper and also in the website, but the petitioner has not participated in the said tender. Considering the above, this court finds that the petitioner has not made out any prima facie case to get any order of get any interim order. Accordingly, interim order is refused. Full stop. The respondents are directed to file affidavit in opposition within 3 weeks. 3 weeks. Reply, if any, they are to be filed within 2 weeks thereafter. List the matter before the regular bench.
Deeply obliged, my lord.
Thank you.
So great.
Take the book.
In this matter, the panchayat pradhan and the
Yes.
of the panchayat.
What has happened on the 9th of January?
No resolution was taken, and one thing, my lord. No,
I am asking from one person.
My lord, I want to, my lord, point out.
I will come to you, sir.
My lord, the
supposed to be
resolution.
All senior persons, you know how to place appear before the court.
Were supposed to be produced.
Yes.
This court has called the Pradhan. Let me hear the Pradhan and secretary. What has done in the what is the resolution on that day?
The original documents were supposed to be produced today before the
By
court.
the BDO.
This cannot
Where
be
is that? Show me. That's why I called the Pradhan and the secretary. Show me.
Lordship.
How the resolution can be cancelled by the BDO?
Where is the power? There is no power.
How the resolution can be cancelled by the
Panchayat, Gram
BDO?
Panchayat.
Resolution of the Panchayat.
The original documents were supposed to be produced. Let it be produced before the
And, my lord,
We have not got the petition copy, petition copy. Only yesterday at 9 p.m. we
The
have got
video.
the
Intimation from the
copy
video.
of the, petition.
No, only
We
I
have
wanted to, who is appearing for the Pradhan?
I am appealing.
Here. Only I want to know the last meeting when it was held on 21st of January.
No,
This was 9th of January.
9th January.
9th January. 9th
21st January, second notice.
Just a minute. 9th January. What has happened on 9th January?
If your lordship, my lord, I wanted to point out that in 32, after declaring the meeting ended, some line has been incorporated.
Lordship, original
That is, my lord,
documents were
that
supposed
is
to
the
be
fraud.
carried before this
Who?
court
Who
for
incorporated?
verification.
The Pradhan, my lord, kindly see page 32. Page 32 of the writ petition.
Kindly see
Where
the-
is the original?
Yes.
Then
Where is the original?
go to the jail.
Yes.
This is the
Pradhan
original.
Pradhan should go to jail.
Where is the original? That's why I called. After seeing that,
Original
that's
is
why I
yes.
called the original today, sir.
Yes.
Where is the original?
এই লাইনটা কি করে ঢুকলো সমাপ্তি ঘোষণা করার পর
He should go to jail. He has no authority.
দেখো তুমি পড়ে দেখো তোমার কাজ সমাপ্তি ঘোষণা করলেন
क्या लिखा है पढ़ो
Lordship also consider last two lines, the writings, the scribbled. সমাপ্তি ঘোষণা করলেন 2000
ना
Lordship,
मैडम
last
you can बुझे ना
two lines compare.
yes
no meeting was.
And my lord, I have got the instruction from the video which discloses with relevant rules.
And Lordship, the way the budget was being done, this is also not the proper way. I will demonstrate from the law if your Lordship wants.
Yes. Who is the Pradhan? Is present today. He will be sent to the proper place. Yes, what has happened on that day? Meeting, what has happened in the meeting? हिंदी जानते हैं आप? हिंदी जानती है? बोलिए क्या हुआ था? हाँ बोलो। हाँ हाँ। So what decision you have taken? आपने क्या? What you have written in the meeting minutes?
Lordship, he says that 13 members have signed.
I know. What is the decision I am asking? That is correct. 13 members appeared, they have objected, 13 members have boycotted. And what decision you have taken? You are the Pradhan. What decision you have taken in the minutes? How can you say Pakke? They are not appeared. They are not appeared, and who has appeared, they have objected for that. And somebody, 13 persons have boycotted, they have not appeared. So how it is? How you can say it is approved?
And my lord, one difficulty is this: unless the budget is approved, the functioning of the Gram Panchayat will stand still. That is the law, my lord. The meeting budget.
It is
budget must be
accepted now. BDO has pressurized Pradhan for calling this meeting.
No,
Now
that's
she
correct, but so budget has to be approved.
Budget has to
Once
be approved.
meeting it is not been approved,
right.
it can be placed in the second
That is
meeting.
the
There is
second
no,
meeting.
there is no bar. Where is
There
the
is no
bar?
bar.
No, I will come.
Show me the bar
Bar.
for calling the
There is
second
bar.
meeting.
My Lordship, kindly, for which we have to compare, Lordship, the West Bengal Panchayat Accounts Audit and Budget Rules 2007, Chapter 13, where Rule 35, it talks about preparation of the budget by Gram Sanshad. Now, this says, budget of the Gram Panchayat of any year shall be prepared on the basis of the budgets prepared by the Gram Sanshads within its jurisdiction first.
Correct.
Second requirement, for the purpose of Sub-Rule 1, the Gram Sanshad in its annual meeting shall hold discussion on the program schemes works included in its perspective plan and 5 years for the purpose of preparation of the annual plan for the coming year, which may be executed for such year shall access to the requirement of fund
Give me
and
the other
for
way.
said purpose.
You have any other book? Give the book.
না না আগে বাজেটটা 48 সেকশনটা আগে প্লেস করো সেকশনটা আগে প্লেস করো ঠিক আছে আবার বই দিচ্ছি দুটো বই দিচ্ছি আমি আগে আগে 48 সেকশন 48 প্লেস করো 48 সেকশন 48
945 for Lordship,
আগে সেকশন 48 প্লেস করো বলো দিস ইজ সেকশন 48 the budget
I'll place section 48, Lordship.
section 48
These are unexplored areas, Lordship. I will be dealing with, Lordship. One section 48 of West Bengal Panchayat Act.
Yes.
Lordship, kindly come. Budget of the Gram Panchayat. Every Gram Panchayat shall, at the time and in such manner as may be prescribed, prepare in each year a budget of its estimated receipts of disbursement for the following year. The budget prepared under subsection 1 shall be written in vernacular for the district and locally concerned, and copies of the budget shall be pasted in such prominent places within the Gram Panchayat as may be prescribed, inviting objections and suggestions by the members of Gram Sabha. Copies of the budget shall be forwarded to the Panchayat Samiti having jurisdiction over the Gram for its views, if any. The budget with objections, suggestions and views, if any, received from various quarters shall, within such period as may be prescribed, be placed in the meeting of the Gram Sabha for discussions proposing modifications, if any, of the budget. The Gram Panchayat shall, within such time as may be prescribed and in a meeting specially convened for the purpose and the presence of the at least half of the existing members of the consider the objections, suggestions and views, if any, and the discussions of the meeting Gram Sabha and approve the budget of the modifications, if any. A copy of the budget approved under clause D shall be forwarded to the Panchayat Samiti. No expenditure shall be incurred unless the budget is approved. Now, Lordship, kindly read it with West Bengal Gram Panchayat accounts audit rules, rule 35. Rule 35 it talks about the preparation of the budget. Here, Lordship, kindly come to rule 2 for the purpose
Where
of
is the book বইটা দিন আমার বইটা দিয়ে দিন না ঠিক আছে
my lord, Lordship, it's in page 945. For the here, Lordship.
Which rule you are harping upon? Which rule?
Yes, rule 35 onwards. This is preparation of budget. Lordship, here, Lordship, kindly come to sub rule 2, where Lordship will find after this Gram Unnayan Samiti shall hold as many neighborhood level meetings as may be deemed necessary for, and shall then prepare the budget of the Gram Sangsad in form 34 of the following. Then Lordship, kindly come to
39
Rule 39, approval of the budget by the Gram Panchayat. Now, this talks about single meeting. The Gram Panchayat shall, at a meeting specially convened for the purpose.
Which rule you are harping?
939.
35, then 39.
39.
Yes.
The Gram Panchayat shall, at a meeting specially convened for the purpose on or before the 31st January in each year, and in the presence of at least half of the existing members, consider the objections and suggestions in the meetings of the Gram Sansads, as also the Gram Sabha, and views of the Panchayat Samiti, if any, and make such modifications of the draft budget as may be considered appropriate, and shall finally approve and adopt the budget for the next financial year, provided that since Gram Sangsad budgets are the basis of the Gram Panchayat budget, and gross deviation in form of either addition or exclusion to and from such Gram Sangsad budget shall be justified with reasons and recorded in the proceedings of the meeting. Notwithstanding any law for the time being in force, if the attendance of the members of such meeting falls short at least half of the existing, so there is a requirement of quorum, the meeting shall be adjourned on fixed date. There was quorum in this meeting. So, in otherwise, if there was no,
Please
my lord.
continue.
Yes, place and time and adjourned meeting, and the adjourned meeting shall be held in presence of at least half of the existing members on the 7th day from the date of adjournment, provided that at least 3 days notice for the adjourned meeting shall be served upon each member, provided further that process shall be repeated until attendance of at least half of the existing members is obtained at the meeting. On or before 15 February in each year, a copy of the budget referred to sub rule 1 shall be published in all places, referred to sub rule 3 of rule 39, and forwarded to the Panchayat Samiti having jurisdiction and to the bank or banks where Gram Panchayat fund is lodged. Lordship, therefore, if there was the minimum requirement for having a quorum was present in that meeting, that has to be the test. The meeting, there was the quorum in that meeting, and that meeting was concluded that the budget placed by Pradhan was not accepted.
Please.
My lord.
You are 13 persons are present.
Yes.
You 13% have raised objection.
Yes.
What are the objections? Because
Objections?
unless the objection is raised, that objection is the modification.
Yes, my lord. The objection is.
Where is the objection? No objection.
Yes,
is on.
we have.
Where is the objection?
That was. Yes, we have replaced it. It's in page 38. The translated copy, lordship.
Your translation is very, very, very dangerous, sir.
Very dangerous thing, my lord.
Yesterday I have been confused from your.
Lordship, now I have prepared a better copy, lordship.
Lord, that is, my lord, wrong date, wrong.
No. Lordship, this has to be compared 22nd 1/2025. This petition for adjournment was made by these candidates. In Lordship, kindly see.
To whom you are given. Sir, this is a block development officer. What is the objection before the panchayat?
Yes.
It is the panchayat objection.
That minute has to be recorded by the secretary.
Correct.
He did not.
So what?
Our reasons was that
you are not made any averment. The objection is not recorded in the minutes of the meeting.
that is not recorded. But this is clear now that the budget placed by the Pradhan was not accepted in the meeting.
Not accepted because you have raised objection, but you have not given the objection, and other 13 were not there.
So
unless and until a specific objection is placed in the meeting, then the Pradhan will place that objection, record this objection, and accordingly it will be modified.
This was placed, but it was not recorded. The only thing is that we do not have any objections if the budget is done strictly in terms of Rule 35. This was not being done. What Pradhan was doing, Pradhan was arbitrarily trying to get her own proposal passed. It was not the proposal from the
Gram Sabha. Kindly see Rule 35. It has to be placed. It has to be served to
whatever is there in.
Kindly show me your application that you have alleged that the budget was not placed. That has not been served to you. You have raised objection that has not been considered. Show me.
Budget is annexed, lordship. What was there? Kindly come.
I am telling. See what the Rule 38 says, not 39 says. If you have any, the Pradhan has to first, the budget is to be placed in the notice board. It has to be served to all the members. Correct. Then all the members, if they are having any objection, they have to submit their objection. Then in the meeting that will be modified, and after the modification, it will be approved by 15th of February. That is the law.
Lordship, it is stated in the letter dated 21st. We have stated it clearly.
Which letter?
Lordship, page 38.
That the
Representation to the BDO. We have stated. Lordship,
what is the date of this letter?
This was 21st or 22nd January 2025. After the meeting.
Then
we
I
made
am
a representation
asking,
since it was not.
I am asking where is the objection before the Pradhan on that day?
That date was not recorded. Lordship sees the meeting. Pradhan was not cooperative. And the
what was the
secretary
objection?
was also not done.
What was the objection? Okay, why I am telling, have you received the budget? Have you received the proposed budget?
My lord, proposed budget.
Okay. Okay, I am passing an order. 3 days notice is required minimum. So you already given. What are the objection? By tomorrow you give the objection to the Pradhan.
Yes,
you give the objection to the Pradhan. Pradhan immediately issue the notice tomorrow, fixing a notice within 3 days after the notice. Then take appropriate decision. Nothing else.
And kindly keep
in compliance with this all. I am disposing of this.
Kindly keep it pending, lordship, for any.
Why? If no new cause of action, if tomorrow
I
anything of
understand.
new cause of action will arise.
These are done.
Please, who is appearing for the Pradhan? Please inform your Pradhans. Please inform a Pradhan. If she is a Pradhan, please follow the rules. What are the objections? Record the objection. And if you are satisfied with the objection, you satisfied with modification, modified, otherwise approved it.
Lordship, the Gram Sabha meeting was not held.
Whatever it may be, I know, sir.
Cannot be. This is the thing.
So and so appearing for the petitioner. So and so appearing for the state respondent. and so and so, so and so appearing for the Pradhan and Secretary of the said Panchayat. Full stop. In terms of the order passed by this court dated 28th of January 2025, the Pradhan Ferry, along with the
আমি তো
minutes,
কালকে ওই জন্য
original
বার
minutes
করে
of the
ভিডিওকে
book.
বলেছি যে খবর দিন আপনাকে জন্য মানে কোনো লয়ার এনগেজ করে
It is fine that
ও তো
altogether
কাকেও
there are
দেয়নি তো
26
আমাকে
members
স্টেটকে দিয়ে দিয়েছে
in the Gram Panchayat, but only 13 members have
ভিডিও দিয়েছি
attended the
আমরা
meeting,
ভিডিওর
and
সাথে কানেকশন রেখেছি
all the 13 members have attended the meeting and 13 members have not attended the
Because
meeting.
we attended everybody. 26 attended, 13 casted vote in against the proposal, 13 abstained from casting.
Abstain for casting vote.
Casting the vote, either favor or
13 casted the vote and 13
Okay, I'm gonna. No, 13 members who casted the vote by raising objection, and 13 members have neither casted their vote in favor of the budget or objecting the budget. But the Pradhan, full stop. It is fine from the minutes. The Pradhan has not recorded what are the objections raised by the 13 members. Pradhan has also not recorded whether the budget was approved or disapproved. Full stop. Now the petitioner claims that the Pradhan has not conveyed the meeting in terms of Rule 35 of West Bengal Panchayat within bracket accounts, audit and budget rule 2007, 35 and 39. 2007. Counsel for the petitioner further submit that the Pradhan has not taken any decision in the said meeting, and as such the budget cannot be approved. Per contra, London advocate appearing for the respondent number,
I am
the block development for the state of West Bengal, for the state respondent, submit that the block development officer has also not accepted the meeting. Has not accepted the meeting. Dated, what is the date?
9th
9th January 2020. Full stop. The Pradhan submits that as 13 members have raised objection and 13 members have neither raised objection nor accepted nor given consent, and as such the budget was not approved. Full stop. Section 48 of the West Bengal Panchayat Act 1973 reads as follows. Set out, huh? Full stop. Rule 35 and Rule 39. Rule 35 of the West Bengal Panchayat within bracket accounts, audit and budget bracket close rules 2007 provides for preparation of budget by the Gram Panchayat, and Rule 39 of the said rule provide for approval of the budget by the Gram Panchayat. By the Gram Panchayat. Full stop. As per Rule 39, the Gram Panchayat shall at a meeting specifically convened for the purpose on or before 31st of January each year, and in the presence of at least half of the existing member, consider the objections and suggestions in the meeting of the Gram Sansad as also of the Gram Sabha and the view of the Panchayat Samiti, if any, and make such modification of the draft budget as may be considered appropriate and shall finally approve and adopt the budget for the next financial year. It is also provided that if the attendance of the meeting, if the attendance of the members in such meeting falls short of at least half of the existing member, the meeting shall be adjourned on fixing date, place and time of the adjourned meeting, and the adjourned meeting shall be held in presence of at least half of the existing members on the 7th day from the date of adjournment. It is also provided that at least 3 days notice for the adjournment meeting shall be served upon each of the members. In the present case, this court finds that on 9th of January 2025, the meeting was convened for approval of the budget. But the Pradhan has not recorded whether the budget was approved or whether the budget was approved. Full stop. Accordingly, in terms of Rule 39, it is the duty of the Pradhan to, again, a place and date is to be fixed for a meeting by issuing the notice to all the members not less than 3 days. Considering the above, this court finds that this writ petition can be disposed of by passing the following direction. Semicolon. The Pradhan shall immediately, by 31st of January 2025, shall issue notice to all the members of the Gram Panchayat for convening the meeting for approval of the budget for the year 2025-2026.
Lordship, made in terms of this rule, made in terms of the Rule 39.
By complying with the provisions of Section 48 of the Panchayat Act as well as Rule 38 and 39 of the West Bengal Accounts and Budget Rules 2007. Full stop. The Pradhan is directed to take appropriate steps for approval of the said budget in conformity with the above said rules within a period of 10 days from date.
This earlier notice is satisfied.
As the Pradhan had issued the notice on 21st of September 21st of January 2025 by fixing the hearing of meeting on 31st of January 2025, the said notice has been recalled and the
29
that notice has been recalled and the Pradhan is directed to issue fresh notice and to conduct the meeting in terms of the above provisions.
Writ
petition is disposed of. Urgent certified copy.
My lord, the big book is necessary for another matter, my lord.
Take that. You are having the book. You take from my court officer subsequently. You give that.
Big book is what? Yes.
I'm giving my
48 and 39 and 35. No. 48. Only 48.
Resolution.
You take the resolution.
48 এখান থেকে নিয়ে
another thing.
The original minutes book is written to the Pradhan.
Lordship, in the minutes book, kindly see that resolution once. Lordship, this is my duty as an officer of the court. I found from the Xerox copy submitted. Lordship, kindly compare the resolution.
That I am not going into that. That's why I directed the new meeting. Nothing will remain there.
Lordship, that is the thing. There was attempt to temper. Should not be.
एक काम करो मनुतोष वो पंचायत एक मंगा के दे दो ना.
I've given my book ना. এটা দিয়েছি.
48 পেয়ে
এই তো আমি দুটো দিয়ে দিয়েছি. আমি বার করে দিচ্ছি.
Flap it. Yes, call the
There's to be mentioned matters are there, my lord. To be mentioned.
One more matter, my lord, item 8.
Yes.
My lord, I was appointed as a mediator by my lord. My lord, the mediation has failed. My lord, I am to file my report today. My lord, I'll just file it, my lord, and
But I
if
appear for
lordship
the
permits.
Yes.
Fix the matter, my lord.
my lord, I appear for the plaintiffs, my lord. Only two things, my lord, in this regard. Mediation has failed. We had tried, my lord. Now the mediation has failed. There was a subsisting interim order, which was there, my lord, till 5th of February.
That has to extend.
That has to be extended for some time.
So what is the stage of the suit?
My lord, we are at the ad interim stage, my lord, of our injunction.
Suit.
Suit, my lord, only thing, yes, with
Summons
regards
is
to
not
the
yet, sir.
suit, with regards to the suit, my lord, all parties have appeared, my lord. So summons may be waived, lord.
I don't know.
My lord,
I
am
am
suffering for the plaintiff.
my lord, may I just
Suffering for the defendants. Since and the mediator is present and has submitted reports, stated that the matter is not settled. Let the mediation report be kept with the record.
my lord, just
The
one-
mediator is discharged from this case.
My lord, may I just
My lord,
make one
oh,
submission?
Remuneration?
My lord, I have
Paid.
been paid.
my lord, the interim
My lord, I
order
have
is till
given the
5th.
Copy of the report, my lord, to the parties. My lord.
The mediator has already circulated the mediation report to all the advocate appearing for the parties.
My lord, may
Counsel for the plaintiff submit that the interim order granted earlier is going to be expired on
5th of
5th of
February.
February.
5th of February. Let the matter appear on 5th of February.
My lord, may I just make one submission?
No, sir, call the list.
I'll keep it very short, Lord. Lordship had given me half an hour, but perhaps I won't get that. I'll try and finish it within, Lord. But it's been a long time since your Lordship has taken the matter, so I'll take not 3 minutes to summarize, Lord. And there's only one clause which I think your Lordship will need to see, and Lord, I think it will come back to your Lordship. Lord, I'm for the defendant. Suit had been filed for enforcing a negative covenant.
Dry fruit.
Yes, dry fruit. That's the one. It looks like Diwali dry fruits are still.
Now Holi has come.
Not there, it's used in powdered form with other substances. But there's just that one clause your Lordship has to see, Lord, nothing more. Page 23.
Page 6.
We'll come back to your Lordship. Lord.
Page 6.
Okay.
Yes.
Page 23. Page 20.
Page 6.
Yeah, I know. Yeah, I dug the take a short. But clause 3, Lord, it is recorded that there are 3 rooms under the trade name Sindaram Savarmal.
Either under the trade name Sindaram Sanwan.
Or with some suffix which has been allotted to the first party, third party, and fifth party, and only the second party and fourth party can start only one shop room using trade name, etc.
Yes.
So this was the clause, Lord. I think the whole thing will come back to your Lordship. Lord, my arguments had been, Lord, I'll just tell your Lordship very quickly. I had taken 7 points. Number 1, I am not a party to the agreement. I am not bound. And I had cited judgments, not 2 judgments. If your Lordship wants, I'll just give your Lordship the 2 judgments also. But 1980 supplementary SCC 298 and 1972 for SCC page 1. I had cited 2 judgments.
1990 volume 2.
1980 supplementary SCC 298.
Yes.
Now, Lord, this was for the proposition that, Lord, even if it's a family arrangement, Lord, it can't be binding on the son without his signature. Now, my learned friend had tried to distinguish it, saying that it deals with a will and not with a family arrangement. My Lord, I had pointed out, and your Lordship will see, Lord, it also deals with a family arrangement fully, squarely. Lord, if your Lordship wants, I'll just show you.
Paragraph 18.
Yes. So, my Lord, same thing with 1972 for SCC, page 1, para 15. Here again, Lord, where the son did not participate, family arrangement not binding on him. So, my learned friend had tried to distinguish, not in a manner which I'll deal with. I'm just reminding your lordship about my point. So first point was, I am not a party, not binding. This was my first point. Not sorry, before that there was one point under the Commercial Courts Act, that this not relates to, this is a commercial matter. It has nothing to do with the family arrangement, because it not already says that everything is divided. It is to do with the marks and the franchisee. And what I had argued that this falls squarely within not section 2C, 21C1, 21C7, 21C8, and 21C8, 17.
21C?
1, 21C7, not immovable property used exclusively in trade and commerce.
Yes.
Not 21C8, franchise agreement, because he's now trying to say you couldn't have done a franchise. And my lord, trademark, which is 21C17. So squarely hit by Commercial Courts Act. This was my first point. Second is, my lord, assuming the suit is maintainable, Lord, I am not a party. And you cannot seek to enforce that clause 3 against me.
Yes.
Number 2, my lord, your lordship will remember I had pointed out his case in the pleading. His father had died in 2018 and I have been using it since then. Lord, we have disclosed the police complaint filed by him 2017 complaining of use of this. So he had knowledge all along. So, Lord, my next point here was limitation read with acquiescence. I had said not that limitation may be a mixed question, but acquiescence is good enough to not this delay of time from 2017 up to 2024 is good enough to deny him interim relief. But the next point I had was he is seeking mandatory injunction at the interlocutory stage and pointed out the reliefs. There is nothing else he has claimed. Now, the main point on the interim application which I had argued was you are seeking to enforce a negative covenant. You yourself have to comply with it. That's not section 42. A party in breach cannot. So my learned friend had given a legal answer which I will deal with. So that was the fourth point. Lord, the next point was I had showed your lordship I. Sikandar's case. There is no declaratory relief not asked for, so he can't get this relief. And last was, Lord, Lord, again to do with the law on negative covenants, balance of convenience, delay. These are all factors to be taken into account in deciding whether to grant injunction or not.
Only one thing, Mr. Bachha was on reply to a reply. We had given a reply.
Yes.
At last occasion, he said he will only have some points. I mean,
Yes.
he's again re-arguing his reply.
I'm not.
He's
I'm not re-arguing.
the same arguing.
I will only
recapitulating.
I will only. That's all right. So this was my argument. Now, Lord, my learned friend made the arguments which I need to deal with. Now, Lord, in reply, he came out with a new case. This is what I had argued. He had tried to distinguish my judgments on facts, not on law, which I had pointed out. Now, my lord, in his reply, Lord, he runs a completely new case. His argument was, number one, that what I have argued is a mutually destructive case. Why? Because he says that, look, you have acquired your rights under the agreement. Now you say you're not bound by the agreement. Therefore, please return the entire property, give back everything, appoint a receiver. This was not that extreme argument my learned friend made, my lord. I don't know, my lord, where he's claiming this right from, but it seems to be a little confused, my lord, basis of the facts and the law. Now, my lord, I'm dealing with this point that it's a mutually contradictory case. Number one, my learned friend, my lord, has not, my lord, got any factual foundation for this at all. Neither the praise nor the factual foundation is there. Number two, Lord, our case is that this particular property is my tenanted property from before my father died. And Lord, your lordship can see one annexure to my affidavit in opposition, annexure A.
Annexure
A to my opposition. I got nearly lost the
enlistment.
Page 22.
Yes, enlistment. Certificate of enlistment.
Yes.
Receipt.
Lord, your lordship will find name of the enlisted holder is my name, Lord Saurav Agarwal, seller, etc. of dry fruits. So, Lord, I have been there. Your lordship will find, Lord, And if your lordship turns the page, my lord, page 23.
Name is Sindaram Sanwarwal Meherwal. Yes.
So, not Saurav Agarwal. Saurav Agarwal, who is
Yes. Is issued on? What is the date of issue?
date is, I have the printing date. Receipt date is May 2023. There's an earlier one. Your lordship will find that page on the next page, which is 2022. Then there's one at 2021. This whole list is given, my lord.
So when it started?
Lord, we've been there from Lord some time now. Our case is there before the father's death. So, Lord, I can find 2018 there, page 27. 31st July, last date of renewal. So that was a renewal in 2018. So I've been there from before that. But page 29, your lordship will find GST 2017.
Yes.
So all these documents are there to show, Lord, I've been there for a long time. And this is, Lord, my... And he had knowledge of it, Lord, your lordship will find page 34. He filed a 144 in 2017. So, Lord, this factual answer which he gives, Lord, that I am claiming that this is joint property is wrong. That was my argument that, look, one, I am not bound. Two, even if you say that it is binding qua father, the fact is this is my individual. I have been paying the rent, I've been there. It was not my father's name or the joint family's name. So, Lord, without factual foundation, doesn't take care of it. And, my lord, from that police complaint, I show I've been using it from 2017 before my father's death. The name. He had knowledge, he has filed it. So, my lord, this meets up with my 2 points of limitation, acquiescence, and also that there is no mutually contradictory case. Lord, this is one. Now, my lord, on this side, the two judgments I had cited, my learned friend, like I said, he tried to distinguish it on facts. And he incorrectly said that it deals only with a will. It's a case of a will. Not both the judgments consider a family arrangement and say, because the document in consideration, one party argued it's a will. Even if not binding, it is binding as a family arrangement. So both arguments are considered in these judgments. So, my lord, that takes care of his first argument. Now, the second new argument which he made, again, my lord, which was completely contrary to the case he had run, was this new, my lord, interpretation which he gives to clause 3. Now, my lord, he says that under clause 3, there is no restriction on the number of shops that anyone can have. Because, my lord, I had argued breach by him. He has any number of shops and he says, look, as far as I'm concerned, he is complaining not only about my shop, which is not where there's a 1 kilometer restriction, but I'm saying that's not binding, but he's also complaining about some franchisee that I was running elsewhere, but he called it my shop, so he's objecting to a second shop by me. So now he comes up with a whole new argument that, look, the clause entitles him to have any number of shops. So, my lord, if for that, if your lordship goes back to, my lord, clause 3 once, my lord, page 23 of the petition. Of GA1, my lord.
Yes.
It is recorded that there are 3 shop rooms under the trade name Sindharam Savar, or with some suffix, which has been allotted to the first party, the third party, and fifth party. So, my lord, there are 3 shops as of now.
Correct.
And only the second and fourth party can start only one shop room. So, those 3 will have one shop. They already have one shop each, and only the second and fourth will have only one.
Second and fourth can start only one shop each using
The trade bar with some prefix or suffix. Now, my lord, how he can say that this permits him to have any number of shops, I don't know. However, no business, and this is the next part he tries to enforce against me. However, the business shall be started with these names within, no business will be started within 1 kilometer.
That is the only question here.
No, that's not but I am saying you are not complying with the earlier part. You've got multiple parts. I've annexed all his bills to show 4-5 shops. So you are in breach of the first part of the clause. Can you enforce the second part? This is the point I'm on. So now to get around it,
after reply, kindly see in September, this was Lordship's order.
The Lordship has kept it for this purpose.
No, he said he wanted to clarify. He
Yes,
can't re-argue. Just so much of time has gone, he'll re-argue again.
I'm not re-arguing at all.
Of course.
My learned friend made a new argument in reply.
Have you filed the written notes of
My notes are ready. I was waiting. He said on the next day I will clarify.
I will, yes.
Again, he's re-arguing.
I'm not re-arguing, Milord. I'm only taking care of this new argument. Milord, will my learned friend say he made this argument? Did he ever make this argument except in reply?
After rejoinder,
I have taken the notes of this. You are arguing.
Yes. So, Milord, he says that, look, this permits him to have any number of shops, which I show is completely contrary. This was a new argument made by him. This argument is also incorrect.
Yes, I have taken note of it.
No restriction on the number of shops.
Correct.
But there was another new argument made by him. I don't think anything turns on it, but I'll deal with it in one sentence. He says that the agreement does not permit any franchise. Not based on clause 4. That's correct. But the reasoning he gave was because not third parties would benefit from use of the trade name. Not that itself is against the concept of franchises. I tell your Lordship, what is a franchisee? I am the owner of a mark. I want to have 5 branches, so I give it to him to run it on my behalf. That is what a franchise is. No third party benefits because the trademark remains mine. This is the situation, but nothing turns on it. But he had made this submission. That's why I'm taking care of it. Again, in reply, one argument made by him was, because I'm complaining a party in breach of this agreement, he has never handed over so many properties mentioned in the schedule. If this case is enforceable, those properties should have been handed over to us, our branch of the family. To that, he says, we never demanded it. Now, number one, this argument was not made by him. It's not there in his petition or plaint that we never demanded it, so he's not given it. On the contrary, he now admits that the agreement has not been complied with because I've said that he has not handed over possession of different properties to different parties. So he admits it. Now, my Lord, going by this yardstick, your Lordship will see 2017 he filed a criminal complaint. Thereafter, 5 years, no letter by him. Or 5, not 5, 6 years. No letter by him at all between this time. But same thing will apply to him. And lastly, Lord, the legal argument which he now made, again, Lord, in reply, was based on section 42.
42, yes.
Now, the argument which he makes is section 42 is a standalone provision. Therefore, even if I cannot get specific performance, I am entitled to an injunction. Now, Lord, I can deal with it legally and show 5 judgments, but Lord, I have no quarrel with the proposition, but only just read that section with me once, Lord. Just read it. But I have already given the judgments to your Lordship. Please take section 42 once, Lord, and Lord, I think I can end my arguments. Of specific relief act. But his argument was, it's a standalone provision, therefore, I don't need to show readiness and willingness.
Yes.
This was his argument. He said, I don't need to show readiness and willingness at all. Therefore, breach and all these things don't matter. Now, I'm going to read it in conjunction with 42. Notwithstanding anything contained in 41E, where a contract comprises of an affirmative agreement to do a certain thing coupled with negative, express or implied not to do a certain act, the circumstance that the court is unable to compel specific performance of the affirmative agreement shall not preclude it from granting an injunction to perform the negative agreement. So he says, just because specific performance can't be granted, does not come in the way of grant. I agree with that. Now, Milord, and the reason I'll tell your Lordship in a second. Now, read the proviso. Provided that the plaintiff has not failed to perform the contract, so far is binding on him. So, my lord, breach on his part is not taken care of. If there is breach, he cannot get it. I have not. He will not get it. The court will not give it to him. I've not given your lordship the judgments. I've also given your lordship not Indian T versus Luba, which says that even though not 42 permits permits the negative to be injuncted, where the positive cannot be performed, even then readiness and willingness is necessary. I've showed that. Not I don't think I need to not get into it again. Not those are my submissions. But please give me 2 seconds. Anything else? Anything else? Just give me 5 seconds to reconsider if I've not, in trying to keep it small, I've missed out anything. Argument I think so my submission.
My notes are ready in course of the day. I was just waiting for him to conclude.
Give us 3 days, not we'll file. Or weekend is there. Saraswati Puja. So it'll have to be after. Not Wednesday.
Well, the only thing is, my lord, I had concluded in September. He has again.
Both parties give. I am fixing the commercial, non-commercial. 6th. I am fixing on 6th.
That was the point. But this should have been commercial.
Census and suffering for the plaintiff, census and suffering for the defendant. Counsel for the respective parties have concluded their argument in respect of GA1 of 2023. GA1 of 2023. Both the parties are directed to file their written notes of argument. And let the matter appear on 6th February 2025 as to be mentioned for filing written notes of argument.
Not obliged to your lordship. I'm sorry, not this.
It's okay, thank you.
Not, but I've tried to keep it as short as I could. Not.
Thank you.
Which I'm praying for a short passover.
Which one?
Shuddha Banerjee is appearing for
Which one?
the defendant.
Item 9. I am appearing for the plaintiff
Praying
petitioner.
for a short passover, your lordship.
What is the matter?
It is an eviction suit file. And
item number 9.
Today there are 2 applications on board. One application is the plaintiff's injunction application,
along with occupation charges.
where pleadings are complete. And one application is the defendant's application under Order 14, Rule 2, which is coming for the first time, your lordship.
A question of law has been raised. We will argue it out. If it's Passover, I'm being also led by Mr. Bose.
Your lordship, I'm praying for a short passover.
Who is appearing?
Mr. Shuddha Banerjee is appearing for the defendant, your lordship.
The only difficulty is we had prayed for occupational charges. Now, because this application is naturally to ensure that we don't get our occupational charges. So, this is an innocuous prayer.
Demonstrate that the suit is not maintainable.
Of course. So, every tenant says suit is not maintainable till they suffer the decree. So, that's fine. I mean, we are okay with that.
Okay, Passover. Then
Passover, yeah, because there's another matter. Let her start. I'm sure he'll come. He'll join.
Your lordship, I'll wait for Mr. Banerjee. Kindly praying for a passover. Short passover.
So, well, can I then place my application? So so by the time if Mr. Banerjee come, well, otherwise your lordship will entertain my application.
Let come.
The only difficulty is that they continue in possession, paying a rent. It's like a preposterous situation. You are sitting in the High Court area.
What is the ground of maintainability?
But they say that I had filed a previous suit before the City Civil Court before the Small Causes Court under the Rent Act, which is under the 1956 Premises Tenancy Act. Thereafter, they entered appearance, filed written statement. I withdrew the suit. Thereafter, I have filed the present suit on fresh cause of action, saying that this is our contention, that they are trespassers in view of Section 2G of the West Bengal Premises Tenancy Act 1997. Now, they say that since my previous suit was withdrawn without leave to file afresh, it is barred by Order 23, Rule 1. This is their contention. So there Mr. Gupta is there. Now he can address.
But this suit is not maintainable for 2 or 3 reasons, which I shall indicate. First is, which my learned senior friend indicated, without any leave to file afresh, that was done. Second point is, the plaintiff's purported cause of action in the present suit is that the defendant is a trespasser. Whereas in the previous suit, the plaintiff had already indicated that the defendant's father was there, and thereafter the defendant inherited the tenancy and the defendant has paid the rent. So once the landlord had acknowledged a particular individual as a tenant and has accepted rent, suddenly, he cannot say that I am a trespasser. So the entire basis of the plaint, in my humble submission, subject to my lord testing it, of course, is flawed. Now, if your lordship kindly takes the plaint once, but may I place from my application, because the plaint is annexed to GA3. GA3, my lord. And I believe my learned senior friend possibly will not be using any affidavit.
I will not. It's pure question. No requirement.
Kindly, my lord, takes a look at the plaint filed in the previous suit. Page 11 is, my lord, your lordship would see that this was filed before the learned small causes court. My lord will see the number. This is 890 of 2000.
Yes.
But it was transferred. It was filed originally in 1995. Then it was transferred to the small causes court, and it was, my lord, renumbered as, my lord, 890 of 2000. And I have pleaded that in paragraph 7 of my application. Paragraph 7 of my application. It was originally, my lord, TS number 346 of 1995.
What was the prayer in the earlier suit?
Yes. Now, before I take your lordship to the prayer, kindly seize the cost title once.
Cost title of?
Of the previous suit.
Correct.
Kindly
Page
seize
11.
page 12.
Page 11.
Yes. Kindly seize page 12. Kindly seize the defendant number 3, Ashok Bagaria, who is the defendant in this suit. So he was arrayed as a defendant in that suit.
So he was here alone.
Yes.
And
Here
now
is alone. In the previous suit,
there
two
are
other
three.
defendants were also there.
So who is the Bagaria company? He
Yes.
or the
Now
proprietor?
kindly seize page 12, paragraph 2. This is the plaintiff's case in the previous suit. Messrs. G. Bagaria and Company, a firm of solicitor, was the monthly tenant according to such and such, my lord, in respect of premises number 1B, Old Post Office. The original proprietor of the said firm was Gadadhar Bagaria, who was a solicitor. Upon the death of Gadadhar Bagaria, his son, Devi Prasad Bagaria, solicitor, carried on the profession as solicitor from the said room number 10 under the name and style of such and such. Then, my lord will kindly turn to, my lord, paragraph 5.
Yes.
Devi Prasad Bagaria died about 4-5 years back. And thereafter, his son Ashok Bagaria, also an advocate, is carrying on profession under the name and style of G. Bagaria and Company, and to pay rent in respect of room number such and such, in the name of G. Bagaria and Company to the plaintiff, Ashok Bagaria became the sole proprietor of G. Bagaria and Company. Then 6, since the month of September 1994, no rent has been paid for the said room number 10. So, my lord, from 1994, there is a default in payment of rent. By whom, your lordship? By, my lord, Ashok Bagaria, the defendant number 3, who was accepted as a tenant, because it's a plaintiff's case that 4-5 years back he passed away, and thereafter. Then kindly reads on, your lordship, paragraph 7. In or about October 1994, the plaintiff discovered that the said room number 10 was no longer being used or occupied by Ashok Bagaria or any heir of Devi Prasad Bagaria. Similarly, the plaintiff in that suit has run a case of unauthorized subletting and default in rent. These were the two grounds on which the previous suit was filed. Now kindly seize page 13 of the previous, page 13 of my application. No, this you're seeing GA1. This is good. Now your lordship will kindly have a look at paragraph 14. At page 15. The plaintiff had duly terminated the tenancy of G. Bagaria and Company on expiry of the month of July 1995
by a notice dated such and such, issued and served in accordance with section 13(6) of the Premises Tenancy Act 1956, the old act.
Correct.
The said notice has also been served by the registered post on Ashok Bagadia, the defendant in the present suit, as an advocate and sole proprietor of G. Bagadia after the death of Devi Prasad Bagadia. But in view of this cause of action, kindly now sees the prayers, my lord, which your lordship was, my lord, asking for. My lord, page 17. It's for decree of vacant and khas possession of the.
Page 17.
Page 17.
Yes.
Now, my lord, the cause of action is, kindly sees paragraph 21 at page 16. Is that at paragraph 21, that on termination of tenancy and giving notice under 13(6) of the West Bengal Premises Tenancy Act,
yes,
since the defendants did not quit and vacate, that is the cause of action.
yes.
So, my lord, two things really, my lord, flow from this plaint. First, the plaintiff has accepted that the defendant number 3, who is the sole defendant here, was the tenant. Was the tenant. Otherwise, my lord, those pleadings are there. Otherwise, the question of issuing 13(6) notice would not arise.
Correct.
The plaintiff had arrayed the defendant number 2 as an unauthorized sublessee whom the defendant number 3 had sublet. That is in that capacity, my lord, he was arrayed as a party. This suit was withdrawn without any liberty to file afresh. That order, my lord, may I humbly place for my lord's kind consideration. My lord, page 36. The completeness. Yeah. Only last portion, my lord, the ordering portion. My learned senior friend says it's undisputed, but just for the sake of completeness, my lord, I just show. It is same stands withdrawn. Then kindly sees the penultimate line. The suit is withdrawn without liberty to file afresh. That is the penultimate sentence of the ordering portion.
Without liberty, yes.
Without liberty to file afresh. Now, my lord, your lordship would kindly see, if a person having inherited the tenancy under the old act and who was recognized as a tenant by the landlord, and the landlord issues a notice under 13(6) and files a suit for eviction, the landlord recognizes this person as a tenant.
Correct.
Now kindly sees what is the cause of action in this suit. Your lordship will kindly see the prayers, or I'm sorry, the plaint that my lord will find annexed to the injunction application, GA1. Well, the plaint starts from, my lord, page 14.
Yes. Decree for recovery of possession.
Yes, kindly sees the array of parties. Only the sole defendant is the defendant number 3 in that suit, Ashok Kumar Bagai. Now kindly sees, may I, it's a very short plaint, may I just trouble your lordship with 4 or 5 paragraphs of that. Paragraph 3. Paragraph 3 kindly sees, originally Gadadhar Bagadia was granted a monthly tenancy in respect of this. Then Devi Prasad Bagadia, survived by his legal representative Devi Prasad Bagadia. Then Devi Prasad Bagadia, as the sole proprietor, continued the solicitor firm. The tenancy of Gadadhar Bagadia stood atoned in the name of Devi Prasad Bagadia. Devi Prasad Bagadia paid rent to the plaintiff. Then kindly turns to paragraph 4. It appears that the son, that the defendant, the son of Devi Prasad Bagadia, carried on his profession from the suit premises as proprietor of G. Bagadia. Now, then the plaintiff is silent and suppressing the fact that rent was paid and accepted by the plaintiff from the present defendant, which has been pleaded in the previous plaint. Now, straight away, in paragraph 5, the notice comes, that a notice under section 13(6) was issued against the defendant. That is paragraph 5. Now, may I humbly pause here for a moment with my lord's kind indulgence. So when a notice is issued under the Premises Tenancy Act 1956, he is a tenant. Now kindly sees how the cause of action now proceeds. Then paragraph 6, it was said that this was renumbered as 890 of 2000. Then the written statement was filed. Now paragraph 7. As the third defendant in the said suit, the present defendant filed a written statement. In the said written statement, the defendant unequivocally admitted and acknowledged that his father, Devi Prasad Bagaria, died in the year 1982, and the defendant has since been in occupation and has been continuing as a proprietor and paying rent. The paying rent has not been mentioned here, but it was mentioned in the previous suit, which has been suppressed. Now kindly sees.
That paying rent is not a
No,
part
that was suppressed.
That's why I'm searching where is the paying rent.
Yes. I'm saying that in the previous suit they have
Correct. I got your point.
Now, when the defendant, when the father of the defendant had passed away in 1982, the tenancy was governed under the 56 Act. Now, if your lordship kindly permits me to place section 2H of the 56 Act, which defines a tenant. But may I hand up a copy of the Act? Tenant means any person by whom or on whose account or behalf the rent of any premises is or but for a special contract would be payable, and includes any person continuing in possession after the termination of his tenancy or in the event of such person's death, such of his heirs as were ordinarily residing with him at the time of his death, but shall not include any person against whom any decree or order of eviction has been made by a court of competent jurisdiction. Two things your lordship would find from this provision, that the period of 5 years and the other ingredients which have been brought in by the 97 Act was absent. So here the tenancy was ordinarily heritable.
Continue.
Yes. So once a tenant is acquiring a tenancy by inheritance under 2H of the 56 Act,
Old Act.
he is a tenant.
Continue.
He is a tenant. So unless that tenancy is determined in accordance with law, he continues as a tenant.
So new Act is not applicable.
New Act is not applicable. New Act came into force from 2001 July. New Act is not at all applicable. Now the new Act, now the plaintiff has proceeded in this suit on the premise that after coming into force of the new Act, I am no longer a tenant. That is, in my humble submission, totally flawed.
Mr. Bose, have you gone through the latest judgment of the Supreme Court?
Yes. It is under review.
Under review?
Yes.
That is my judgment. He held that, and that was affirmed by the appellate court, but the Supreme Court has held what Mr. is telling.
No. So here the point is, my lord, what we've said is, we will do the suit, and our case in the present plaintiff is that you ceased to be a tenant under the 97 Act. The 97 Act came into force on and from July 2001. So you ceased to be a tenant on and from 5 years from the date the Act came into force.
That's the Supreme Court now. It has been.
No, my lord, that's what I'm respectfully submitting now. My lord, today I have filed a suit saying that you are no more a tenant, you are a trespasser under the provisions of the Act. Now, today if he asks for dismissal of the suit, he has to say that the suit is either barred or I don't have a cause of action. He cannot say at the demurrable stage or at this stage that you are not entitled to a decree, so your suit will fail. So what he's trying to say is that, where is the question of being barred? I can understand, my lord, what is falling from your lordship. Eventually, I may, if this law persists and if it is not subsequently, because there are several judgments which says that the Act will overrule, our division bench is there. But there is another view. Now, eventually, when the suit goes to trial, my suit may fail. But that doesn't mean At this
Suit- at
demurrer
this stage,
stage,
suit is not maintained.
he cannot say that your suit is not maintainable. Good, bad, indifferent, present suit is based on a fresh cause of action. Previous suit, rent suit under the 56 Act. So that cause of action was the 13(6) notice. Now here I say the act, because he himself said that he continued as a tenant. I say you, by virtue of the coming into force of the new act, you cease to be a tenant. So that's my cause of action.
Okay.
So my suit may fail. I may eventually fail. So I've taken the risk. So I'll suffer the consequence.
Whatever is being submitted, I'll try and establish that even if that is correct, then also it is not maintained. Okay, I'll show why I say. So, my lord, under 2H, my lord, the tenancy now devolves upon Ashok Bagaria. So once that is done, he becomes a tenant under 56 Act.
Yes.
Now the suit to evict him has been withdrawn.
Yes.
The plaintiff has abandoned that cause of action, qua the defendant as a tenant under the 56 Act. Now suddenly, and this was done in 2024, the new act came into force in 2001, 23 years before.
When the suit was filed?
But the new suit?
Earlier suit?
95.
And it was continued till 20...
It was continuing till 2024. He withdrew the suit in 2024. Not that he immediately upon coming into force of the 97 Act in 2001, he filed that. One fine morning, he thought that I am a trespasser. One fine morning, somebody wakes up, the plaintiff wakes up and suddenly finds that I am a trespasser. Whereas the suit was proceeding all these years, they were contesting and saying that I was a tenant under the 56 Act. So once that is there, the question of the new act being applicable to me, A, does not arise. And B, if I'm a tenant, then my position in law suddenly cannot be a trespasser.
Yes.
If the tenancy continues without being determined. And it's in a rent control act, even if a tenancy is determined, the tenant continues as a tenant, a statutory tenant. So now, apropos this, kindly sees what the cause of action in the present suit is. Kindly, comes to page 15, which I was placing, 16 of GA1. Now your lordship will kindly have a look at paragraph 7, which I had placed, that in 1882 passed away. So I continued from that. Then 1982, I'm sorry. The original tenant having died prior to coming into force of the West Bengal Premises Tenancy Act 1997.
Where from?
I'm sorry, paragraph 8 at page 16. The last two lines of that page. The original tenant having died prior to coming into force of the West Bengal Premises Tenancy Act 1997 and the present defendant being in occupation of the suit premises as a legal representative of the deceased tenant. May I pause here for a moment with my lord's kind indulgence? But this two lines is itself good enough to dismiss the suit.
Occupation of suit as a legal representative?
Yes. The original tenant having died prior to coming into force of the West Bengal Premises Tenancy Act 1997 and the present defendant being in occupation of the suit premises as a legal representative of the deceased tenant, the defendant is not a tenant within the meaning of 2G. Correct. He is a tenant within the meaning of 2H of the Premises Tenancy Act 1956. I agree. He is not a tenant within the meaning of 2G of the Premises Tenancy Act 97. He is a tenant under 2H of the 56 Act.
Yes.
Now, paragraph 9 makes a very interesting read. Now, kindly sees, in view of subsequent developments,
yes,
and the fact that the defendant is a trespasser, but from where is the plaintiff getting that I'm a trespasser?
As per 97 Act.
That is not applicable at all.
As per 97 Act, as per their case.
Even then also it is not applicable. Even then.
Yes.
In view of the, so this suit is filed for eviction of a trespass. Suddenly my right as a tenant vanishes. Upon them withdrawing the suit, my right vanishes suddenly. Then paragraph 10. For 10, I'm not troubling your lordship with. Then paragraph 11. Admittedly, defendant in view of section 2G of the 97 Act of 1997 does not qualify to be a tenant as an illegal wrongful occupation of the suit property. Kindly marks this. From 10 July 2006. Even if it is correct, they are calculating 5 years from the coming into effect of the Act. Even if this is correct, the suit is barred by limitation. If I'm in wrongful occupation, they have 12 years to throw me out. And I shall show that.
No.
Beyond 12 years, they cannot.
2G.
Then also they cannot.
5
if
years.
5 years. So they are saying that on lapse of 5 years from the coming into effect of the 97 Act, I have become a trespasser.
Correct.
So from 10 July 2006, I am a trespasser.
Correct.
So to evict a trespasser, one needs to file a suit within 12 years. That is not
Acha,
the,
that's
yes.
your thing. So
So even if this is
they
correct,
file 24.
24. Even if this is correct, this is barred by limitation. Now kindly sees how the suit is valued. And this is also incorrect. Kindly comes to page 19, paragraph 18 of the plaint.
Page 18.
Page
Paragraph
19, paragraph 18.
Yes.
For the purpose of jurisdiction and court fees, the suit is valued at rupees 1 crore 42. And the calculation is rupees 7,46,400 for annual rent towards the present letting out value of the suit premises and rupees 135 towards mean profit. So, my lord, if I may humbly pause here for a moment, but the Court Fees Act and the Suit Valuation Act are both silent on, my lord, valuing a suit for eviction on the present market value of the rent. Now, I could understand them valuing the suit as the present market value of the property. But then also Supreme Court and our High Court is clear that where the induction of the defendant was not wrongful and the defendant was a tenant at one point of time, but due to lapse, it's only a rank trespasser, then only it can be as a market value. Otherwise, 12 months rent.
That's right, 12 months rent.
12 months. My rent is 500 rupees. So total value
500
rupees. So the suit valuation cannot be more than 6,000.
It is not
The
under.
High Court cannot have a pecuniary jurisdiction. So it's legally barred by law. B, barred by limitation. C, barred by pecuniary jurisdiction, which is an inherent lack.
Yes.
Now, my lord, may I buttress my arguments, my lord, with...
Now you stop here. Come next.
Whenever your lordship is.
So and so appearing for the plaintiff. So and so appearing for the defendant. Defendant has argued the matter at length in connection with GA 3 of 2025, but due to paucity of time, hearing could not be completed. Let the matter up let the matter up tomorrow.
But may I file the affidavit in opposition to GA1?
I have already
filed. Sir, the reply has also been served.
Filed by the defendant in connection with GA1 be kept with that.
No, continuing. So it will appear in the usual course.
Yes.
Very good.
That's why I'm coming.
Better. Good.
I'm so grateful.
Prior to that, my lord, item number 10, my lord, this small application for extension written statement, my lord.
Come next time.
My lord, may I come at 2 o'clock, my lord, for that matter? For item number 10, my lord. Small application.
Testament. Let already 10 minutes is passed.
Please, my lord. My lord, may I mention one matter? That is item number 11 in today's revised list of business.
Sorry, testamentary matter is called.
Much obliged, my lord.
Yes, Your Lordship. I appear on behalf of the petitioner, Your Lordship. On the earlier occasion, on 10 January 2025, one affidavit of consent has to be filed.
Who?
One affidavit of consent of Rama Bhattacharya.
Press
has-
consent
yes, Your
affidavit and
Lordship.
press for time.
Your Lordship, I have obtained it. It has been notarized from Bengaluru, Your Lordship. But the thing is that it has been done in dummy paper, Your Lordship. I am seeking leave to file it in the dummy paper with this.
Yes.
I'm humbly seeking leave to file it in this dummy paper, Your Lordship. Kindly have a look. It is not stamped, Your Lordship. It is stamped, but it is not. Lordship, kindly give me leave to file it. She has given no. Yes, she has given no objection, Your Lordship.
Yes. Yes.
With regard to this only, kindly.
All formalities completed
Yes,
now.
Your Lordship.
Where is the will?
It is in page numbers.
Who is the testator?
Testator is
Testator, testatrix.
Testatrix. Your
Bela
Lordship.
Devi.
Yes, Your Lordship. Executor is Bhavani Prasad Mukherjee.
Bela Devi.
Yes, Your Lordship.
Where is the name of the executor?
Executor's name is in page number.
Upon Sri Bhavani Prasad
Bhavani
Mukherjee.
Prasad Mukherjee. Your Lordship. Page
Executor
number
of my
3.
list. Yes, where is the, what is the date of the will?
Date of the will is
28th August 2015.
26th August 2015, Your Lordship.
26th August.
Yes, Your Lordship. Kindly come in the first page, Your Lordship.
But your notary is on 26th.
No, noted. Yes, Your Lordship.
26th August.
26th August 2015.
But the notary is 28th August.
Yes, Your Lordship. But the date of the will is.
Where is the legal name? What is the date of the death?
Date of the death. Death certificate is in.
Bela Devi. 6th April 2020. And date of the will is?
Date of the will is 26th August 2015.
Yes.
Subsequent.
What about the legal heirs?
Legal heirs, each and everyone has given their.
Where is the legal heirs? 5.
Your Lordship.
Mother. All late. Mother, father, brother, sister, all late.
Your Lordship.
So, and brother, sister, these are the 4.
Yes.
4 are given legal, no consent.
Yes, Your Lordship.
Where is that?
Tarapada Mukherjee.
Tarapada Mukherjee. Where is the Tarapada Mukherjee?
Affidavit of consent. Tarapada Mukherjee. Then, Your Lordship, Arati Banerjee.
Arati
Banerjee. Then, Your Lordship, Rama Bhattacharya, I have just filed it today, Your Lordship.
Rama Bhattacharya.
I have just filed it today, Your Lordship.
Why today you filed?
It was defective, Your Lordship, and the second thing is that she was not there.
Huh?
She was in Bengaluru, so I have filed it today, Your Lordship. The notarized one.
No, kindly come to the page. Pagination is not there. Kindly come. Rama Bhattacharya affidavit of caveat. Affidavit consent is there. 22nd December 2020.
But since there was some defects, Your Lordship, it was from the department itself. They have
The
told.
police prior to under the made available and appointed by one execute. But consent is not there.
Yes, Your Lordship.
Consent was not mentioned. In
No, not mentioned. So I have to file it once more, Your Lordship.
Okay, then Rama Bhattacharya thereafter Bhavani.
Bhavani Prasad Mukherjee.
Bhavani Prasad Mukherjee.
Bhavani Prasad Mukherjee, the asset, Your Lordship. He has been.
Huh?
He has filed the asset.
He is the executor, no?
Yes, Your Lordship.
And what about that attesting witness?
Attesting witness is also here, Your Lordship.
Where is the attesting witness? Come fast. Otherwise, one matter I will take half an hour for the testamentary. You are coming without any pagination. Where is the affidavit of attesting witness?
Attesting witness is in the page in the previous page. Tarapada Mukherjee.
Tarapada Mukherjee is the brother.
He is the attesting witness, Your Lordship. Tarapada Mukherjee, page number 2. It is before the will use and annexure B. Annexure B, Your Lordship.
Yes, come to the affidavit of Tarapada.
Yes, Your Lordship.
Where is mentioned?
In paragraph number 4, I further say that signature of said Bila Devi.
Paragraph number 4
of the attesting witness affidavit.
Tarapada.
Yes, Your Lordship.
Where is that? But only 3 paragraphs.
No, Your Lordship. Page number 3. Fourth paragraph, Your Lordship.
4 paragraph, the statement made in foregoing are the true to the best of my knowledge.
No. Your Lordship.
So this
paragraph number. Annexure B.
ये सब मैटर को ना पीछे रखा करो.
Annexure B, Your Lordship.
You are not inspecting the file before coming to the court.
Yes, I have done, Your Lordship. Annexure.
Total 20 minutes are lost.
Yes, Your Lordship. Page number 3. In paragraph number 4, Your Lordship, I further say that the signature of said Bila Devi, the above named deceased appearing in every page of said will, is a true signature. The signature of myself and Sri Ashok Kumar Maji appearing in the said will are the originals.
So appearing for the petitioner. Police of the petitioner has filed the present application for grant of probate of the last will and testament dated 26th of August 2015, which was duly notarized on 28th of August 2015 by the testatrix Bela B-E-L-E Bela Devi, wherein the testatrix has appointed the petitioner as sole executor of her last will and testament in presence of 2 attesting witnesses. Police. The testatrix died on 6th April 2020, leaving behind 4 legal heirs, that is 2 brothers and 2 sisters, out of which the petitioner is one of the brother. The other 3 legal heirs have filed their affidavit consent, stating that they have no objection for grant of probate of the last will and testament. One of the legal heir, namely Tarapada Mukherjee, is also the attesting witness of the said will, and he has also filed an affidavit stating that the testatrix has executed her last will and testament in his presence and in presence of the another attesting witness while possessing good health and fit state of mind by appointing the petitioner as sole executor. Had the learned counsel for the petitioner perused the materials on record, this court find that materials on record. This court find that all the legal heirs of the testatrix have given their consent for grant of probate of the will to the petitioner, and the attesting witness in his affidavit has categorically stated that the testatrix has executed her last will and testament in his presence while possessing good health and fit state of mind. Considering the above, this court finds that the petitioner has proved the will and is entitled to get the probate. The department is directed to issue probate to the petitioner on compliance of all formalities. At the time of grant of probate, the copy of the will be made part of the probate. PLA number 55 is disposed of.
Your Lordship, the affidavit of consent.
The affidavit of consent filed by Rama Bhattacharya, Srimati Rama Bhattacharya is accepted. Let the same be kept in the record. এটা ऊपर हो गया. Beach moving.
Item number 48, one of the caveators has died recently, 26th of January.
Caveator?
Caveator, my lord.
An application for amendment has been already filed and retrievable on 31st of January. A amendment application has been filed.
I'll tell you what has happened, my lord. Wrong parties have been cited in the main probate petition, my lord. Deceased parties have been cited. One of my clients have been left out. So I filed GA1 for dismissal for not citing all the parties. Now they have filed an amendment application pursuant your lordship's direction last time, my lord. So correcting this mistake, my lord, so that the proper parties can be cited. Now one of those parties have again died, my lord.
So,
My lord, again, we
where is the
filed an-
application? Where is the application?
No, it is returnable on 31st of January.
GA number?
GA3
GA3. This is an application for
for amendment of parties.
where is the GA3? Can GA3 यही है? Master summon. There's no affidavit along with the master summon.
Yes, my lord.
Only master summon.
Master summon with affidavit.
Where is the affidavit?
We have filed, my lord.
So, who died now?
My lord, Shefali Rai, my lord. I am having the hospital death certificate. 26th of January, she died.
Where is the proposed amendment in the application?
Already annexure B, my lord.
Shefali died.
Yes, my lord. Shefali.
Now we shall file an appropriate application.
What will happen to this?
I'm not pressing.
Not pressing?
Not file a proper application as well.
And I inform him the legal age of Shefali Rai.
So-and-so appearing for the petitioner. So-and-so appearing for the caveatrix.
Caveatrix, my lord. And one caveat, Mr. Ashok Gupta, my lord, applicant in GA1, my lord. He has not been cited, my lord. At page number...
Okay. Caveator and caveator. You are appearing for the caveator.
Caveators, my lord.
Not for the Shefali.
No, also for Shefali, my lord.
Caveator and caveatrix. Full stop. The counsel for the petitioner submitted and the counsel for the caveator submitted. The petitioner has filed an application for grant of probate with PLA number 108 of 2021 without giving the details of the legal heirs of the testator or testatrix.
Proper legal heirs,
Proper legal
details.
heirs of the testator.
Testatrix.
And accordingly, now the petitioner has filed an application being GA3 of 2024 for amendment in the PLA application for recording the name of for bringing the legal heirs of the proper legal heirs of the testator in the present application. Full stop. Then a counsel for the caveator submit that after filing of the present application by the petitioner, the legal heir Shefali Rai also died on
26 January 2025.
January 2025, and the same was duly informed to the learned counsel for the petition. Learned counsel for the petition submitted that the Shefali has died. Now the petition has to take appropriate application. Accordingly, he is not pressing the application being GA3 of 2025 with the liberty to file a fresh. Accordingly, GA3 of 2025 is dismissed as not pressed with the liberty to file a fresh. Next. Yes. All formalities completed. So why you are not appearing in the court? 22nd May you are not appeared. Yesterday you are not appeared. Now all completed. You are waiting for the completion. Where is the will?
Annexure B, my lord. Page 18.
Who is the testator? What is the name of the testator?
Testator Virendranath Pal.
Virendranath Pal.
Yes, ma'am.
Will Virendranath Pal, yes. Where is the name of the executor?
Executor, joint executor, my lord, husband and wife, Niladri Naran Don and Bulbul Don.
Niladri Naran Don and
Bulbul Don.
Bulbul Don. Don or Don?
Don.
Where is the executor? Where is it is mentioned they are the joint executors?
Legal heirs, my lord.
Jointly executor, yes. Executor and executrix. What is the date of the will?
Date of the will, my lord, 3 April 2012.
Where we can get
3rd
the name? 3rd April 2012.
Yes, ma'am.
How many attesting witness? 3 attesting witness.
Attesting witness, one, my lord. One legal heir and daughter.
Where is the date of the death?
Date of
When he died?
That, my lord, September 30th. 30. 2019.
What is the date? 30 September 19.
Yes, my lord.
Okay. Where is the legal heirs?
Legal heirs, two daughter, my lord.
Priyanka Sarkar, Soma Paul.
Priyanka Sarkar, my affidavit,
Daughter.
consent and attesting witness.
What about the wife?
Wife died, my lord.
Where is that? Any death certificate?
Death certificate.
Wife death certificate is there?
Last,
Where it is?
last page, my 13/11/2021.
Huh?
13/11/2021.
13/11/2021. But there is no death certificate.
I have stated, my lord, paragraph
Which paragraph?
5.
Paragraph 5.
Yes, ma'am. Yes, ma'am. The person as named in paragraph 5 are sui juris. There is nobody else who can claim as such as the testator died 13 September 2000, and after his
Demise, his wife
Santa Pal
died on 13/11.
Yes, ma'am.
21. And when the application is filed? 24. Filed on December 21. Number she died. Sense appearing for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 4th April 2012 of the testator Sri Birendra, B-I-R-E-N-D-A, Birendra Nath Pal, wherein he has appointed. Both are the petitioner here? Both petitioners?
Yes, ma'am.
Both?
Husband and wife.
By appointing the petitioners as executor and executrix of a last will and testament. Counsel for the petition submitted, the testator has executed his last will and testament in presence of attesting witnesses while possessing good health and fit state of mind. He submitted the testator died on 30 September 2019 and his wife died on 13/11/2021, leaving behind two daughters, namely Priyanka Sarkar and Soma Paul. Both the. Where is the no consent? They are not given consent.
No, my lord. Priyanka Sarkar consent agreement, my lord.
Priyanka Sarkar has given consent.
Soma Pal, one of the daughter, my Soma Pal citation issue.
But the other daughter has not given consent. Accordingly, citations were issued, and in spite of the issuance of citation,
yes,
no caveat is filed.
Yes,
and the department has submitted no caveat certificate on 16th January 2025, stating that no caveat has been entered for grant of the probate. The attesting witness, who is the attesting witness? File the affidavit.
Priyanka Sarkar.
One of the attesting witness, who is also the daughter, namely Priyanka Sarkar, has also filed an affidavit stating that she has no object, stating that the testator has executed his last will and testament in her presence and in presence of other attesting witnesses while possessing good health and fit state of mind. Concerning the submission made by the counsel for the petitioner, peruse the original will, death certificate of the testator, affidavit of consent of one of the legal heir, affidavit, the no caveat certificate issued by the department, and the affidavit of the attesting witness. This court find that no caveat has been lodged, and one of the legal heirs given consent. The attesting witness has categorically stated that she has categorically stated that the testator has executed his last will and testament in her presence and in presence of other attesting witnesses while possessing good health and fit state of mind by appointing the petitioners as executor and executrix of his last will and testament. Considering the above, this court finds that the petitioner has proved the will and entitled to get the probate. The department is directed to issue probate on compliance of all formalities. At the time of grant of probate, the copy of the will be made part of the probate. PLA is disclosed. Yes, next.
At 50, I appear on behalf of the petitioner.
क्या GA? What is the GA? Where is he? What is the GA?
Procedural amendment.
So that is over. GA is already disposed of. It's already amended. GA already GA is also dismissed. GA also disposed of. Yes.
What is my application, my lord? The application, my lord, to bring the details, the particulars of the legal of the testator. My lord, what happened at the time of filing of this application, my lord?
Have you filed an application?
Yes.
What is the application for?
GA2, my lord.
GA2 is there?
GA1, sorry.
Hey.
Last occasion, my lord, the directors will take a step so that those details of the legal heirs can be in record.
So you are not made the legal heirs in the not declare the legal heirs in the application.
It's mentioned, my lord. In the mention, it says that the two brothers, two sisters, but the particulars in that not even given. That's the application, my lord, so that the details, the particulars of the legal heirs should be in the record, and my lord, and the prayer will be amended so the citation can be issued, my lord. Page 7, my lord, the order, last order, passed by my lord. Page 7 is the last order passed by this honorable court.
Only this two
That's it. That's all. Just to bring on records the legal heirs, two brothers, two sisters, and to amend the prayer, my lord, so the citation can be issued.
So appearing for the petitioner. The petitioner has filed the present application praying for amendment in the probate application by bringing the date of date of death of the testator testator as well as the details of the legal heirs of the testator as well as amendment in the prayer portion of the probate application. Consider the submission made by the counsel for the petitioner. Peruse the application. This court find that the amendment as sought for by the petitioner is formal in nature and will not change the nature and character. Accordingly, prayer
A to C, my lord. A, B, and
C of the present application is allowed. GA1 is disposed of.
I'm grateful, my lord.
51. 51, my lord. I am for the petitioner, my lord. My last occasion, my lord, the attesting witness are already deposed and the will has already been marked exhibited, my lord. Now, my lord, today executor is present, my lord. My lord, he can depose, my lord, executor. Executor is present before your lordship, my lord.
You want to examine witness? You want to examine witness?
I want to examine, but everything has been complied with, my lord.
Court cannot say if you want to examine, otherwise I will pass up order. What is your
actually in the order sheet it reflects that I want to examine one.
As you stated on that day, you will adduce further evidence that I fix for the further evidence. If you want to adduce the further evidence, it can be.
Yes.
If you not, then it cannot be. What you want?
No, ঠিক আছে করুন my lord I will adduce evidence, my lord. ওটা দাও exam ওটা কোথায় আসুন বাংলায় বলবো আমার পরে বলবেন
হ্যাঁ PW2
yes আমি এই মামলায় সাক্ষ্য দিতে এসে যা কিছু বলিব সত্য বলবো সত্য ছাড়া মিথ্যে বলবো না কোনো কিছু গোপন করব না আপনার নাম বলুন তন্ময় সাহু SHOW বাবার নাম
Late Fotik Chandra Shao. A T I C K Chandra Shao SH
আপনার এজ
46
কি করেন
business
অ্যাড্রেস বলুন
27/49
আচ্ছা ওটা সাথে আছে এই ডকুমেন্টসটা
PK Pal
এটা কোথায় আছে রিভিউ ডকুমেন্টসের সাথে আছে
Temple Road
কোর্টের কাছে কোথায় আছে অরিজিনাল পিটিশনের সাথে আছে
Post Office Belur PS Belur District Howrah
পিটিশনের সাথে দিয়েছেন এটা পেপার বুকের সাথে
7,11,202
এভিডেভিট অফ ডকুমেন্ট
11,202
7 লক্ষ
202
ও এটা পিটিশনে আছে তো বলবো আচ্ছা ডু ইউ নো ফটিক চন্দ্র সাউ এন্ড রেণুকা সাউ
হ্যাঁ উনি আমার বাবা মা
উনি আপনার
yes
বাবা মা।
they are my father and mother
আচ্ছা প্লিজ টেল মাই লর্ড the date of death of you of your parents one after another
আপনার বাবার ডেট বলুন তারপরে মার ডেট বলুন
বাবার ডেট আচ্ছা 25 আগস্ট 2020
my father died on 25th August 2020 মায়ের বলুন
আঙ্গুল দেখুন না
20 বলেছে মায়ের বলুন
মায়ের 13th মার্চ 2018
my mother died on 13th March 2018
আচ্ছা একটু এটা লাগবে পিটিশনটা ডেথ সার্টিফিকেট একটু ডেথ সার্টিফিকেট
পরেই আছে স্যার পিটিশনের কাছে
আচ্ছা look at this document look at this document please tell my lord what this document about
এই ডকুমেন্টটা কি দেখে বলুন
এটা আমার মায়ের ডেথ সার্টিফিকেট কলকাতা কর্পোরেশন থেকে দিয়েছিলাম
this is the death certificate of my mother issued by Kolkata Municipal Corporation
পিছনটা আছে ওটা কোথায় আছে তারপরেটা
পরের কথা
ওটা বাবার তো না
মায়ের
পরের পাতা কি বাবা
আচ্ছা প্লিজ look at this document and please tell my lord what this document about
এটা আমার বাবার ডেথ সার্টিফিকেট বালি মিউনিসিপ্যালিটি থেকে পেয়েছিলাম
how it has been used how it has been issued
of my father Bali Municipality Municipality
how it has been used
নরমাল প্রসিডিওর যেরকম করে হয় সেরকম করে
issued
usual course of business
sure when your grandmother died can you tell my lord when your grandmother died
in the year 1999
in the year 1999
do you have her death certificate with you
no it is not with me
no it is not with me
exhibit এটা একটু দেবেন উইলটা exhibit এটা
Death certificate be marked as exhibit. The original?
Yes.
Death certificate are original?
original my lord these are also
B and B by 1.
হ্যাঁ বলুন
death certificate
হ্যাঁ এটা অরিজিনাল
Yes, next.
এটা একটু দেখাবেন
B and B by 1. Yes, next.
উইলটা দেখাবেন উইলটা দেখাবেন exhibit A look at this document and please tell my lord what this document about
এই ডকুমেন্টটা কি আগে বলুন
এটা আমার বাবা এবং মায়ের তৈরি করা উইল
this is the will executed by my father and mother
please see the exhibit A1 to A10 whose signature is this
1 নম্বর পেজ থেকে 10 নম্বর পেজ অবধি দেখুন কাজ হয়ে আছে
A1 to A10
আচ্ছা A1 কোনটা?
এই যে সইগুলো
হুম,
আছে সেটা
হুম।
মাঝখানে অন্য পেজ ঢুকে আছে।
এটা আমার বাবা মার সিগনেচার। এইখানে যে ব্লু রঙের এই
These
দিয়ে
are the
মার্কিং করা আছে।
signatures of my mother and father.
Which are
Do you know their signature?
হ্যাঁ আমি জানি।
Witness identified exhibit A by 1 to A by 10. Yes.
Were you present at the time of execution of the will?
No.
When did you came to know of the will?
বাবা বাড়িতে এসে এটা আমাকে দেখায় এবং বলে যে এটা আমার সেফ কাস্টাডিতে রাখার জন্য।
My father came back to home and showed me this will and asked me to keep it in safe custody.
Have you read the will?
হ্যাঁ আমি পড়েছিলাম।
Yes, I have read the will.
What was the physical and mental condition of your parents at the time of execution
How
of the
you
will?
can say he was not present? He was not present. You put one question, he was not present at the time of execution. How he can say that he was
Immediately after execution of the will, they handed over.
He has not stated immediately. He has stated that the father came and given the will. Already come and the witness has stated that. Yes, next.
No. And petitionটা দেখাবেন তো ভেরিফিকেশন উনি যেটা করেছেন। At whose instruction this petition has been drafted? This probate petition?
আমি এই বিলের একজন এক্সিকিউটর হিসেবে আমি পিটিশনটা ড্রাফট করতে দিয়েছিলাম।
করতে বলেছিলেন।
হুম।
I being the executor of the will instructed to draft the application. Yes, next.
আচ্ছা, who is the other executor?
আমার এল্ডার ব্রাদার, বড় দাদা বিদ্যুৎ কুমার সাউ।
My elder brother Vidyut Kumar Shah.
Given consent?
হ্যাঁ উনি কনসেন্ট দিয়েছেন।
Yes, he has given consent.
Verificationটা কি দেখতে
Page 9.
Look at this page where have we verified the probate petition.
9.
Yes.
হ্যাঁ এটা আমি সিগনেচার করেছি।
Kindly tell my lord whether you have put your signature after understanding the contents of the page.
হ্যাঁ আমি সমস্তটা পড়ে বুঝে তারপরেই আমি সই করেছি।
Yes, I have signed after understanding the contents of the will.
Of the application.
Of the application, yes.
হুম।
Who explained the probate petition to you?
আমি নিজে পড়ে বুঝেছি।
I myself had read and understood the contents of the application.
How many brothers and sisters you have?
আমরা দুই ভাই এবং দুই বোন।
They all have given consent? আচ্ছা ঠিক আছে, sorry.
Two brothers and two sisters. এবার বল।
আচ্ছা, have all of them given consent?
আমার বড় দাদা বিদ্যুৎ কুমার সাউ এবং দিদি পলি রানা ওনারা কনসেন্ট দিয়েছেন। আর মলি সরকার উনি আমার দিদি হন, উনি কনসেন্ট দেননি এবং পরে মামলা থেকে উনি বেরিয়ে যান।
She has withdrawn from the case, my lord.
My eldest brother
বিদ্যুৎ কুমার সাউ
and my eldest sister,
not elder sister, younger sister
Polly Rana had given consent, but
Polly Rana
had given consent, but my
elder
sister
Molly
Molly Sarkar had not given the consent and later got out from the case.
Later, her caveat has been discharged. She has been discharged from caveat.
Discharged from the case.
What is your prayer before my lord?
কি চাইছেন আপনি?
আমি মাই লর্ডের কাছে এটাই প্রেয়ার করব যে আমার প্রবেটটা গ্র্যান্ট করা হোক।
I pray before this honorable court that my probate be granted. Application for probate be granted.
So applying for the petitioner. One witness is present. During his examination, two documents have been exhibited, being exhibit B and B by 1. Examination chief is concluded. Counsel for the petition witness is discharged. Counsel for the petitioner submit that he will not adduce any further evidence. Evidence on the side of the petitioner is closed. Let the matter be fixed for argument on 11th February. Next.
11th February, my lord. Grateful.
I appear for the executive.
She was supposed to file her affidavit in support of caveat by 10th of January 2025, but she could not file. We have filed an application for extension of time before the Honorable Division Bench that is pending for disposal, and that is returnable tomorrow, my lord. So kindly adjourn it for some time, my lord, so that
As per the prayer made by the counsel for the cavatrix, the case is adjourned. Let the matter appear on.
My lord, next week, my lord.
next week have an extension, my lord. It will be extended by the Honorable Division Bench.
But
if it is
how long will it?
What?
For my lord,
You have filed an application before the Honorable Division Bench extension, so you are praying for time.
Yes, my lord.
So what, you have not heard?
No, my lord, my lord.
So that's why when the court, before the court, please not to share the talk between you.
Apologies.
As per the prayer made by the counsel for the cavatrix. Cavator, cavatrix. Cavatrix. The case adjourned. Let the matter appear on 19th February.
Grateful.
But item number 53, I have
Yes.
to appear on behalf of the petitioner, my lord.
Yes.
My lord recollects that on December when
Appropriate
the
step
matter
for
was
bringing the consent from the other
Yes,
executors
the
so as to enable the
the
petitioner.
two executors, there are three executors to the will.
Hmm.
Two executors actually given a power of attorney to somebody,
Hmm.
and they have relinquished the right of the executor by giving an affidavit, which is not the procedure. So I took time for
time.
I want some time because New Zealand wants
As per the prayer made by the counsel for the petition, the case adjourned 4 weeks.
4 weeks at
Let the matter appear on 3rd March. Next.
Please, Your Lordship. Appearing for the intervener.
My lord, yes, my lord. In my 54, my lord, I am for the petitioner, my lord. My lord, there are three IAs, my lord. IA 1 has been filed after grant of probate, my lord. There was a mistake in the description of the one of the executrix. Now his husband's name has been wrongly written in 2 places of the will, my lord. My lord, if you are take a GA1, my lord.
Anybody is appearing for the bank? Yes. What is your instruction?
So far as the my lord, payment of the amounts, my lord, which we have not paid are concerned, my lord, we have to pay, my lord. There is no way, my lord, we can escape that. My lord, they have reasons, my lord, for not depositing it, my lord. They were not informed, my lord, about the probate. The probate, my lord, was not submitted to them.
Probate is not granted.
Probate, my lord, that has not been granted, my lord. In fact, in November 2024, my lord, there was a letter written by them, my lord, that order has been passed. My lord, we can deposit it, my lord. Only thing is, my lord, interest we will not be, my lord, liable to pay, my lord, because it is on their, my lord, informing us that these are the executors or these are the legatees in whose accounts, my lord, the rent has to be deposited. My lord, this lease, my lord, is being paid in 2 portions. My lord, there are 2 landlords. My lord, lease deed itself contains, my lord. On 1 portion, my lord, there is no default. We have been paying only because of the death, my lord, of the original lessor, my lord, that this has happened. My lord, in fact, the death occurred in 2017. We still, my lord, upon his wife writing to us saying that in terms of the will, I am entitled to get the income, my lord, we paid. But in 2021, my lord, the matter was reviewed by the bank authorities and found that till such time the probate is granted, we should not. Because ultimately, my lord, there will be proceedings for recovery. Somebody will say, I will not recover. The other person will say, why did you pay, my lord? That is why, my lord, we did not. Otherwise, my lord, we are, my lord, we have to pay, my lord. I won't say I'm ready and willing, my lord. We have to pay under law. We have to pay. We cannot default.
Yes. What is the GA1? What is the GA1?
My lord, GA1 is for correction, my lord.
What correction? Correction in the?
Yes.
Correction in
My
what?
lord, there is a mistake of the name of the husband of one of the executrix in 2 different places of the impugned will, my lord.
Okay.
The original will.
Yes.
If your lordship
And who is appearing for the others? Any?
My lord, I'm for number two, intervener. My lord, what I have submitted, my lord, that there is a portion which has been, my lord, included in the will, which is, my lord, not belong to the my lord, testator. That is, my lord, proceeding was going on, my lord, in the court. My lord, on earlier occasion, my lord has asked to produce the copy of the plaint, my lord.
Yes.
This is a copy of the plaint, my lord, from 1997, my lord.
So what is your prayer before this court? Why,
My lord,
why the GA2 is filed?
my
What
lord,
is the problem with the GA2?
my lord, only, my lord, want to intervene in this application
For what?
for, my lord, for expunging that, my lord, garage portion which has been constructed on a common, my lord, common area.
From the affidavit of asset.
Yes, from the my lord, from the will itself, my lord.
So
Will
how you can file an application, and on how this court can delete the portion of the property from the will?
My lord, proper.
Can I get the instruction from the upper stir?
My lord, what happened, my lord? This is, my lord.
You file the suit. You prove that, because see, if the probate is granted, probate is not a title. You file the suit, you are claiming the title of the property.
Yes.
You continue with your suit. Who will get the probate? The court cannot give the advice to you what is to be done.
My lord, we have already.
You are
filed,
not the authority here. You cannot pass.
We will not came to learn that this portion, some of the portion has been, my lord, included in the.
Maybe included, but this court only will grant the probate. Against whom you have filed this suit?
My lord, against this person, my lord, who has the testator himself.
So
He has, my lord, contested the suit.
So testator
There
died.
is an injunction order.
So testator died. So you made it legal heirs of the party.
Yes, my lord.
The executor is also one of the party who are there. So you proceed with that. What is the difficulty? How you can be if at all you have been added here? What relief can be granted by this court to you?
My lord, only to that portion, my lord.
Not
subject to that.
Cannot. How the portion of the will can be deleted?
My lord, this is the apprehension, my lord, to the.
Sir, this executors you have made, you have filed a suit against the testator.
Yes.
Correct. Testator died. Then you made a substitution application. Under the substitution application, the person who was claiming the probate is the executor. He is the son.
Yes.
He has been substituted.
My lord.
Correct.
My lord.
So the suit is going on.
My lord.
So if the probate is also granted, but you have filed the suit for a title,
for
tenancy.
For declaration that we are the common owners of that portion upon which the garage situated is a common portion of the common portion of the property. Also,
you get a declaration from the appropriate court. How the court can declare
my lord,
here?
My lord, that, my lord, observation, my lord, my lord, my lord passes an order in that, my lord.
What? You already filed the suit declaring,
Yes.
and they are the party.
They are the party.
Yes. And yes, what is the GA1? What name is required to be corrected? And from where the name is to be corrected? In the will itself?
Yes, my lord, in the will itself.
How the in the will the name can be corrected by the probate court?
My lord, it is not the name is of the husband of one of the executors, my lord. Now, my lord, as per section 76, my lord, it is a description of the executors, my lord.
Probate is granted?
Probate? Yes, my lord. Yes, my lord. Order has been passed, my lord.
Then?
Thereafter, my lord, I filed an affidavit confirming that
who filed the affidavit?
Both the executors, my lord. And thereafter, it was then detected that in two places of the will, my lord, will find it from page number 14 of my IA1, my lord.
Page number 41.
14, 1, 4, my lord.
Yes, 14. Yes, tell me. Which
14, my lord, third from last paragraph, my lord. Third from the bottom.
paragraph?
Soumitra Kapoor, wife of Mr. Rajiv Kapoor.
Correct.
And my lord, thereafter on the next page, my lord, page number 2, at para 3, my lord, daughter Mrs. Soumitra Kapoor, wife of Mr. Ranjiv Kapoor.
N added. N is added through pen.
Yes, yes, my lord. N is added through pen by the original original testator, my lord. And will was filed like this, my lord.
So where is
They
the
didn't,
probate? Where is the probate order?
my lord, it appears at page 29, my lord.
29. Yes. Probate is allowed, granting the order in terms of priori. Yes, then
Then, my lord, we applied for, my lord, it's engrossing in the stamp paper, my lord. But, my lord, the department could not possibly done this because of this mistake, my lord.
so what is
Then this application,
what is the prayer here? What is the prayer?
mistake in the description of the name of the husband of the executrix in the last will and testament, my lord, at page 11, my lord. The last will and testament dated 14th October 2016 may be corrected by a description of the husband of the executrix in terms of the affidavit affirmed by the petitioners on 11th July 2024.
Affidavit. Where is the affidavit?
Yes, my lord. My lord, that has been filed in the.
Where is your affidavit?
My lord, that is not annexed with this application.
So you're not annexed.
Yes,
Where is the affidavit?
yes, affidavit is at page 26, my lord.
Page 26.
Page 26, my lord. 26 to 28, my lord.
What affidavit is this?
My lord, this affidavit has been found by both the executors, my lord, confirming that Rajiv Kapoor and Ranjiv Kapoor are same and identical persons. And
Rajiv Kapoor is alive or not?
yes, he's alive, my lord.
His affidavit, I am Rajiv Kapoor and Ranjiv Kapoor are the same person. Where is that affidavit?
My lord, he possibly cannot use.
I can give an affidavit. Yes, your name is so and so, so and so.
No, my lord, from the documents it appears that Rajiv Kapoor and Ranjiv Kapoor are the same persons, my lord.
So and so appearing for the petitioner, so and so appearing for the bank. Which bank, sir?
Indian Bank.
Indian Bank, and so and so appearing for the intervener. The petitioner has filed the present application being GA1 of 2024, praying for correction of name of the husband of one of the executor as Rajiv or Ranjiv. What is the actual name?
Ranjiv, my lord. RANJIV.
Ranjiv Kapoor, but in one of the place, but in second paragraph of the page 1 of the second paragraph of the will, the name of the husband of the executor has recorded as Rajiv Kapoor. Rajiv, the petition submitted, both the executors have executed an affidavit stating that the correct name of the husband of Soumitra Kapoor, who is one of the executrix of the present will, is Ranjiv Kapoor and not Rajiv Kapoor. But the Rajiv Kapoor has not filed any affidavit stating before this court that his name is Ranjiv Kapoor and not Rajiv Kapoor. Accordingly, the petition accordingly, this application without the affidavit of the Ranjiv Kapoor cannot be decided. Accordingly, the petition is directed to take appropriate steps. Full stop. The applicant has filed the intervener has filed an application being GA2.
Yes, my lord.
GA2 of 2024. Praying for an order allowing the petitioner to intervene in the present application as objector on the ground that the applicant has filed a title suit for the London Court of Court,
Lord,
London Court of
Civil
Civil
Judge,
Judge Junior Division at Alipur Court, being title suit number 356 of 1997, claiming declaration of the property. Where is the schedule? Claiming declaration that the applicant is the owner of the property with respect of 8 feet wide common passage leading from north to south from the main entrance measuring 80 feet length, thereafter 12 feet wide common passage leading east to west measuring 55 feet length, having a garage, comma, a servant quarter on it, and an underground reservoir under it, and vacant space in between the building of 71B, Raspberry Avenue, and 12 feet wide common passage measuring 359 square feet, more or less 69A, 69B, 69C, 71A and 71B, Raspberry Avenue, within the police station, Tollygunj, Calcutta 26. This court find that the probate has also been granted, and the applicant is claiming the title over the aforesaid portion. Thus, this court did not find that the petitioner can be impleted in the present suit, as the petitioner already initiated a title suit and the same is pending before the appropriate court. Full stop. Thus, the application filed by the applicant is not maintainable, and all the issue which the applicant is raised in the present application can be raised before the appropriate court where the suit is pending. GS number 2 so is disposable. Let the matter appear on. How much time will take filing affidavit?
My lord, 1 week, my lord.
Appear on 6th of February. Yes.
My lord, GA3 is, my lord, is keeping pending, my lord. GA3, the rent for the bank, my lord.
The bank, what the bank?
Lord, it will be upon a lordship's order, my lord.
So I will pass an order to keep the whatever the amount in a separate account. That will be better.
Yes, Lord, because we do not know, my lord, who the actual Lord.
This will be completed, then he will be entitled to recover.
Yes, Lord, only thing, my lord, if your lordship is, my lord, willing to pass, my lord, orders on interest, my lord, then your lordship will, my lord, hear us.
I am not passing any order with regard to the payment from which date?
My lord, since
That's from, my lord, June 2021.
Filed an application being J 2025 by praying for an order directing the Indian Bank Baliganj branch to deposit the rent which was fallen due since June 2021 till date. Police landed so appearing for the bank. He submitted that the bank is ready and willing to pay the deposit the rent as paid for by the petitioner. In view of the above, the bank is directed to keep the rent from the month of June 2021 till today and to continue deposit the monthly rent in a separate account, and after getting the probate, after the probate proceeding is completed, the petitioner shall be at liberty to claim the said rent from the bank. The GA3 is disposed. Yes.
Hello.
My
Discovery inspection all have been completed. Lordship, our admission and denials will kindly go. That's not been affirmed. It's ready.
So what about the issues?
Issues
My
I'm
lord, I
carrying.
have my suggested
Even
issue.
my suggested issues are here. Lordship, we can file the suggested issues.
So appearing for the plaintiff, so appearing for the defendant. You are for the plaintiff, madam?
I'm for the plaintiff, my lord.
Plaintiff has filed the affidavit of document and suggested issues. Police of the defendant has also filed the suggested issues. Police of counsel for the defendant press for a day's time to file the affidavit of document. Police.
Affidavit of admission denial.
Affidavit admission denies the document. Police. consider the submission made by the counsel for the respective parties. Perused the suggested issues, peruse the pleadings and the suggested issues. Did the testimony capacity? Did the related validly executed? I am taking all. You are 3 or 4. The following issues are framed. This 1, 2, 3, 4, 5, 6, 7.
Your Lordship has
It's not over. It's not over. Full
stop. The
Lordship has
defendant
taken-
is directed to file the affidavit of admission denial of document within a week after serving the copy to the learned counsel for the plaintiff. Let the matter witness action. Judge's brief.
My lord, judge's brief.
Full stop. And the plaintiff is directed to file the judge's brief of document within 2 weeks. Within 2 weeks.
Lordship has
from date.
taken all the issues that are with the defendants as well as the plaintiffs. Great.
Because I
Mine
think
are very,
nothing is there, but
yeah.
let it be continued. Actually, only the 3 issue could be.
But my issues are very short.
Right, but he has,
because,
he
yeah.
has molded something.
I can see that he has very
molded.
very very specific issues in his. But anyway.
Lays the matter on. Give the witness action. You will 19th March at 2 p.m. for witness action.
My lord, only one thing. Between the same parties, there's another testamentary suit. Testamentary suit number 5 of 2021 is pending. My lord,
If the witness action was
witness
ongoing,
action was
that
on.
is our suit.
But an application on my behalf is pending, my lord, for appointment of an administrator pendent lite. My lord, let that testamentary suit also appear along with this on the same day, my lord.
So what is when the suit is pending? Where is the when the next date is that?
My lord, that is not in the
Which
list.
year?
Lordship, that is the problem. It's of a different year. It's not
It's
before the Lordship.
it's of a different year. It's
2020?
2021.
Although we would be very happy to bring it before your Lordship.
It's before 2021. It's before, my lord.
No,
yeah.
2021 is this.
2021.
That one is 2000.
22,
That
is 2021.
2021. It's a PLA 2021. That is PLA earlier. It's by the
The
PLA year.
testamentary suit is of 2021.
PLA is
PLA is 2017.
PLA would be
19 March for witness action.
my lord. My lord.
Next matter.
I'm grateful.
For extension.
Yes.
Item number 61.
Come tomorrow.
matter praying for leave for drawing up and completion of an order, Your Lordship.
Morning, all mentioning morning. Please.
So now,
Yes.
before I continue my arguments, I must answer the queries that the court had put me. So first of all, I'd like to take the court to page 49 of the affidavit reply to the affidavit in opposition. Just 2 points I want to clarify. One about the same address and also about when did we learn about the mischief, the court has said. So these 2 points only I'll clarify. The court may be pleased to turn to page 49, which is the copy of my SLP, just to see convey the addresses of all the parties. The Honorable Court has page 49. Page 50, court will see Jagrati is at 3A Shakespeare.
No,
What is at
this
3A Shakespeare?
against
This is
affidavit,
like,
affidavit in reply
in reply.
of the application to object.
In opposition, in this only. Page 49 is the SLP.
Yes.
Page 50 is the cost title.
Correct.
I'm just showing the addresses.
Hmm.
Jagrati is 3A Shakespeare.
3A Shakespeare Sarani.
Ascot is 3A. Neeraj is 3A. All three are the same address. And on the next page, reform number 5, Rajendra Sikka is the director of the judgment debtor on the board, representing me on the board of Ascot. Just to show it, and I've already pleaded Ascot was directly under their control because my directors went rogue.
Hmm.
So that is one query. The second query that's about the addresses. The respondent number 5 is the one who's on the board of Ascot as representative of JD. Other 50% Sharda Group, we are 50%.
Yes.
The second query is about the mischief. The court will just see the list of dates I gave yesterday. I'll show the dates. So the court will be pleased to turn.
Yes, no problem. Just started.
Just started. Fine. The court will be pleased to see on page 4, paragraph 15. We had asked the bank to freeze page 4, item number 15, the list of dates I gave yesterday. It's easier to take it through the pleadings, this will save time. On 15 July, we had told them, please freeze the bank account. The bank account is frozen on 29/12/2009, item 17.
Bank account of respondent was
frozen
frozen
by HSBC on 29/12/2019. Now,
2009 or 19?
2009. Now, in item number 19 on page 5, I've referred to the letter I'd read out. Page 5. The said Neeraj Kumar Pandey, who continued to masquerade as director of the respondent and purported to act of the respondent, sent the fraudulent and mischievous letter dated 11/10/2010, which I read out. That is annexure 54.
Correct, yesterday.
To the RBI to the fact that 2 checks of 15 and 5 have been issued by the infusion of minimum capitalization of $5 million in Ascot as prescribed in press note number 2 of 2005. The applicants, by this letter itself, where the court wanted to know, applicant by letters dated 15/10/2010 and 24/11/2010 to the said Neeraj Kumar Pandey reiterated they had no authority to present the represent or to bind it or to deal with a frozen bank account, and there was no requirement of the respondent to infuse a minimum of $5 million. I also wrote to the bank out of abundant precaution that they will not act. It was actually because of this reason, because the second authority was a 24 saying that you cannot act on page 7, item number 24, that they moved the Bombay High Court.
Yes, you have shown that.
I've shown that. Now, all this, because what fell from the court is what has happened. I'll take the court to the orders of the Bombay High Court, if I may just take that. That was in my objections itself, in my application itself, page 138.
Affidavit in opposition?
No, the objection application itself, main affidavit, which I filed in 26 December. Page 138, the Bombay High Court.
Yes.
Let me just read. The second respondent, HSBC Bank, this is the order of 24th November 2011.
Yes.
The second respondent, HSBC Bank Corporation, issued a communication to petitioners. Petitioners are the JD here and the directors.
Yes.
The second respondent
Augustus Land
is a JD out here, respondent.
Okay.
Second, and the rogue directors are also petitioners out here. The second respondent, HSBC, issued a communication to petitioners on 14th October 2010 that the bank has refused to honor two checks amount of rupees 15 crores and 5 crores respectively, issued by the first petitioner on the basis of certain instructions which were received from the two shareholders of the company. That is me. But I had written to them, please freeze. Before this code is not disputed by the council appearing from behalf of the second respondent under the present mandate of the bankers, petitioner 2 and 4 are authorized to operate the bank accounts. Since the bank has acted at the behest of the two shareholders, we have the view the interest of justice requires those shareholders are heard before final orders are passed. And so I was impleaded in this. The court may come straight now to the next page, which is page 140.
139.
140. In running sequence only, that's the judgment order dated 4 January 2012.
Okay.
This is the annexure A19.
Yes.
In these proceedings, under Article 2 to 6 of the Constitution, petitioners seek a writ of mandamus directing the first respondent of RBI to take steps against HSBC, the second respondent, for having frozen the current account of the first petitioner, and for refusing to clear certain checks issued by the first petition in favor of the JV company. Petitioners also seek a direction to a second respondent to perform a statutory obligation rising under section so-and-so. The consequential direction is sought against the second respondent to defreeze the account of the first respondent and to honor the checks issued. The account was opened by the first petitioner with HSBC on so-and-so date. The authorized signatures have been altered from time to time, and at present the second and third petitioners are, according to the bank, authorized signatories on this record. The third and fourth respondents are companies based in Mauritius. We had come on record by that time. We were impleaded. Are based in Mauritius, claim to have acquired 100% shareholding of the first petitioner. The bank has said in its affidavit it was aware of the change of shareholding because the funds for the purchase of shares were remitted by the two shareholders through the bank. The bank further stated it was required under the guidelines of the Reserve Bank to file an FCGPR return, setting out the purpose of which the funds were received. HSBC received a notice dated so-and-so on behalf of the two shareholders, informing it there was a dispute between the shareholder and the director of the first petitioner, and requesting the bank to stop operation of the account in order to ensure the funds were not misappropriated. The bank has stated that since this communication was addressed on behalf of the two holding the entire shareholding, the bank was not in a position to ignore the request. HSBC, by its letter dated 16 December 2009, informed the shareholder that they would obtain a court order from a competent court to enable the bank to freeze the account. On 21st December 2009, the bank was furnished the copies of the resolution revoking the authority of petition number 2 and 3 to act as signatories in respect of the accounts. On 27 September 2010, fourth petitioner made an attempt to deposit a check drawn in his favor and signed by the second and third petitioner on behalf of the first petitioner. The bank declined to accept the checks and informed the fourth petitioner accordingly. The bank therefore claims in its affidavit reply the petitioner was aware from September 2010 that the accounts of the first petitioner had been frozen. On 7 January 2011, the bank received a letter dated 24th December 2010 addressed by Ascot. My learned friend is presenting 50% on Ascot. The company in whose favor the check which formed the subject matter of the petition relate, making a complaint with regard to the dishonor by the bank. The bank received a show cause from the RBI, Reserve Bank, dated 8 March 2011, to which it responded. Initially, by a letter dated 13 April 2011, RBI, having examined the complaint, observed that the freezing of the account had been carried out by the bank on the basis of a board resolution. The Reserve Bank therefore expresses the inability to deal with the complaint. An appeal was thereafter filed against the rejection of the complaint in pursuant to which a further inquiry took place. The RBI has, by its letter dated so-and-so, intimated the complaint has been closed. This was their complaint. The petition was filed before this court without impleading the two shareholders, that is us, at whose behest HSBC had declined to honor two checks of 15 crores and 5 crores respectively. On 24 November 2011, this court recorded as interim order that it was in the interest of justice that the two shareholders be heard before final orders are passed in proceedings. While granting leave to plead the shareholders, this court issued notice. In response thereto, the newly added third and fourth respondents appeared through counsel. A scanned copy of the affidavit reply has been placed on record and taken to the council. The original will be filed in the registry of this court within a period of 2 weeks from today. In its affidavit reply, which has been filed on behalf of third and fourth respondents, reliance has been placed inter alia on the resolution passed by the extraordinary general meeting of the first petitioner held on so-and-so, by which the authority of the second and third petitioners to operate the accounts has been revoked. From the material which has been placed on record, it is evident that at least since October 2010, petitioners had been aware of the fact that the bank has declined to honor the 2 checks in the amount of 15 crores and 5 crores respectively. As a matter of fact, the bank has stated before the court that after it acted on the basis of the facts which were brought to the notice of the third and fourth respondent in December 2009, petitioners were aware of the position which the bank had adopted. Be that as it may, we are of the view that there is undoubtedly a dispute in respect to the regards of the first petitioner. The second, third, and fourth petitioners claim to be directors of the first petitioner, and the second and third petitioners claim to have a mandate to operate the bank account. Whether the second or third petitioners have a mandate which is valid and operative law is itself a matter of serious dispute, since bank has been informed of the resolution on basis of which the mandate has been terminated. In this view of the matter, we are of the view that the Reserve Bank of India was not in an error in declining to issue any directions to the second respondent, and the second respondent acted as a prudent banker. This court, in exercise of its writ jurisdiction, Article 2 to 6, could not be justified in entertaining the petition and in directing the second respondent to honor the checks in amount to 15 crores and 5 crores respectively, in the absence of the dispute between the parties with regard to the management of affairs of the first petitioner being resolved before a competent forum. The jurisdiction of Article 2 to 6 of the Constitution cannot be exercised to decide a dispute about internal management upon which ultimate authority to operate bank account must rest. We therefore decline to exercise the jurisdiction under Article 2 to 6 only on that ground, making it clear, however clear, that it will be open to the petitioner and for that matter to the third and fourth respondents, if they are so advised, to move the appropriate forum for appropriate orders. The petition is accordingly dismissed. There should be no orders to cause. So as far as we are concerned, we move the NCLT, is question management, and I'll come to that in a bit. As far as they are concerned, this order is dated, court will be pleased to say, is dated 4th of January 2012. Instead of going to the appropriate forum, they invoked the arbitration clause on 13 March 2012.
After this order?
After this order, because what they could not get,
yes,
they tried to do through arbitration fraudulently. So the court will be pleased to see they did 2 things. One, they invoked arbitration. One, they filed a review petition. That review petition order is on page 148, which was dismissed.
148 review?
Yes, is a review which was dismissed.
Yes.
Then they go to the Supreme Court. That order is on page 149. That was dismissed. If I may just read that order. Having heard Mr. So-and-so, we are not inclined to entertain SLP petition since the division bench of the High Court has already granted liberty to petitioners to approach the appropriate forum.
Yes.
They didn't go to the appropriate forum. They didn't go there. So this was also, that assumed finality there. In between, on third, coming back.
So Supreme Court order is 2nd July 2012.
Yes, but by that time, they'd already invoked arbitration. If the court comes back to my list of dates on page 7, I've given the 3 dates of the, in item 25, we've given the 3 dates of the order reviewed by
Bombay High Court
SLP.
dismissed
And
the petition.
it is on 13th March 2012, they've invoked arbitration. Basically, and here, if I may take the court directly to the last document to refer in this, the ward itself, which documents all this and shows how this has been invoked at what stage. The court may be pleased to come to the ward directly now. Because after this, they invoke arbitration to get that 20 crores exclusively, which has been declined by the Bombay High Court. The court may see this award, which is sort to be executed here.
Page?
Is it filed? They filed it with the execution application. Sorry, I just have a copy of the award. I won't. My learner friend can help me with the running page.
Yes. It's there in the
Yes, sir.
affidavit in support of the tabular statement.
Yes. It is with the execution petition.
Yes, it is. Now, immediately after the tabular statement, your lordship will find.
If I can just see
The
that,
original signed
I'll hand it
copy.
back to my learner friend after seeing the pages. Page 18. Page 18.
Execution है ना?
I won't read the entire award, but just read the relevant part. Court will see page 18 is the arbitration clause 16. We had already read this. so I won't read this. Clause 16 of the joint venture agreement containing the arbitration clause. I read that yesterday.
Correct.
So I won't read that, which is on page 19. That was, but except that this had to be done in Singapore. When we come to page 20, para 16.3, after that. As the disputes between the parties, a letter dated 13/3/2012 was written by Jagrati. Now, 13/12 was just 2 months after dismissal when the review order was still pending before the Bombay High Court.
13th March 2012.
But yeah. Court will just compare with the list of dates.
13th March, just review is pending, yes.
Review is pending. Written by Jagrati, thereafter the claimant company, to Augustus for appointment of resolution of the disputes and differences arising out of the joint venture agreement dated 12/7/2007. In that letter, it was made clear that the respondent company expressed the inability to have matters arbitrated in Singapore. So that was the requirement. As per the ICC rules, the claimant company waived the condition for the arbitration as stipulated by 16.2 of the joint venture agreement dated 12/7/2007 and would like to have the arbitration before the learned arbitrator under the provisions of the 96 Act at a place in India, and the claimant proposed my name as arbitrator in the matter. In all efforts to resolve the disputes amicably failed. As such, in the said letter, the claimant
Yes.
in such matter, the claimant, the company wanted to know the objection to any of the respondent to the said proposal. In answer to the same, the respondent company by letter dated 17 March 2012, that is after 4 days, gave the consent to the proposal put forth in the letter dated 13/3/2012 sent by the claimant company and wanted the arbitration to be held in India in terms of the Arbitration Act, 96 Act. Pursuant to the force agreement, a letter dated 21 March.
Consent letter.
I'm sorry?
This is a consent letter.
Yes.
17 March.
17 March, consent letter. Within 4 days. Between parties who are supposed to be litigating.
That is 12th and okay.
Pursuant to the first agreement, a letter dated 21 March 2012 was addressed by me to claimant requesting me to arbitrate the dispute rising out of the JV agreement, and the proceedings took place in Calcutta thereafter. I'll just read page 21 because here the reason of reading this is they refer only to press note 2 of 2005. They suppress press note 2 of 1999, and it is on that basis the arbitrator says that there is admission. I'll just read this. There's a factual background prior to the joint venture agreement dated 12/7/2007. We started with the execution of the joint venture agreement dated so-and-so between Starlight, that was with me, and the claimant, that is, Messrs. Starlight Real Estate Escort Mauritius Limited, which was then in formation as a special purpose vehicle set up by Messrs. Starlight Limited UK and Mauritius, and on the basis of the exercise, it entered into a joint venture with the claimant company and formed a joint venture company under the name and style of Messrs. Escort Realty Private Limited for making investment in the real estate sector. Then on 19/12/2006, Messrs. Escort Realty was incorporated in the Companies Act by so-and-so, that is Meher Karan Singh representing Starlight, that is me, and Jagdish Sharda representing the claimant company. Then, realizing the difficulty in administration and functioning of the joint venture company, the promoters of Messrs. Starlight Investment Limited UK, after holding a series of meetings with the claimant company, decided to form a wholly owned subsidiary in India through a special purpose, namely Messrs. Starlight Real Estate Escort Mauritius Limited and Messrs. Real Estate Mauritius Limited. An application was made to the Foreign Investment Promotion Board, Ministry of Finance, Government of India, to set up a wholly owned subsidiary in India for making downstream investment in the real estate project as indicated in press note 2 of 2005 issued by the Department of Industrial Policy and Promotion, Ministry of Commerce, Industry and Government of India. Pending such approval, seeking from the Foreign Investment Board, the respondent company was incorporated under the Companies Act on or about 3/5/2007. Respondent company is the JD. On or about 14/6/2007, the Foreign Investment Promotion Board conveys approval to Messrs. Starlight Real Estate Escort Mauritius for setting up the wholly owned subsidiary in India for investment in the real estate sector. After superseding the previous joint venture agreement dated 25/9/2006, the respondent company entered into another joint venture agreement on 12/7/2007 with the claimant company on the terms and conditions which are identical to those contained in the joint venture agreement for 25/9/2006. Now, if I may pause here. This records that an application was made under the press note 2 of 2005. this was not for automatic approval. We applied for approval and I've read out the approval letter. Approval letter says for finance, go to the 99 press note. For nature of construction activity, go to the 2005 press note. 2 of 2005.
Correct.
Throughout this award, I won't trouble the court by reading the entire award. There's not a whisper
About that.
of the 99. On the contrary, the learned arbitrator goes on talking about selectively what was placed before the learned arbitrator. Right up till page 23, the court may come to the second last para.
Yes.
Then on 3/9/2010, as the respondent company failed to fulfill the obligation of the joint venture agreement dated 12/7/2007 by investing a minimum of $5 million US in the joint venture company in terms of press note 2 of 2005, the claimant company lodged a complaint against the respondent company before the RBI. That's the letter I was reading yesterday.
Yes.
3rd September 2010.
Complaint. Yes.
So this was initiated by them saying 2005 when there is no requirement of 2005. Just to recap, there's no requirement under either of the joint venture agreements of 5 million. So it's not a contractual obligation. 10 million and 5 million are statutory compliances of Starlight with the government.
Correct.
Nothing to do with them. But they say that under 2005, you're supposed to bring 5 million. When
What
that
has happened to the complaint?
person to the complaint, the RBI wrote a letter to me, to Neeraj, the 2010 letter, and he said, I'm issuing these checks.
Given the consent.
And he issued the checks.
Correct.
Now, the court will be pleased to see, after that, it is just written, the next paragraph only, on 9/10/2010, respondent company, in compliance with the obligations under press note 2 of 2005, issued these 2 checks. Which then the court goes on to the dishonor, etc., Bombay High Court. The relevant part then the court may be pleased to see is page 25. I won't read this, but the learned arbitrator extracted press note 2 of 2005.
Correct.
And then the relevant part is straight away we may come to page 27, right till the end, page 27.
Yes.
The claimant company is that without any intimation, the said Donde have provided services. And the respondent company has also failed to fulfill under the joint venture agreement dated 12/7/2007 by investing a minimum of 5 million in terms of press note 2 of 2005. As such, the claimant company lodged a complaint against the respondent company on 3/9/2010. Thereafter, the respondent company issued 2 checks referred to above, amounting to rupees 20 crores in favor of the joint venture company. It appears from the fact narrated above that both the checks, despite presentation, could not be encashed. The stand of the respondent company that it has fulfilled.
बंद कर दिया हूँ गर्मी लग
Sir, fan will do.
इसी चला हाँ फिर भी तो गर्मी लग रहा है
I think he was under the impression your lordship wants it off.
Maybe we can need.
No, because at this time of the year, because there's no ventilation in this these rooms, so it becomes extremely claustrophobic.
Total knock.
Yes. Yes. So it appears from the fact, this is the finding of the learned arbitrator. It appears from the facts narrated above that both the checks, despite presentation, could not be encashed. The stand of the respondent company that it fulfilled its obligation under the joint venture company by issuing these 2 checks in favor of the joint venture company, and the respondent had no further obligation. The respondent had also claimed it had no knowledge of the fact that its account stood frozen since 29/12/2019. The banker also did not inform. Then about the same company submitted that the bank stand before the Bombay High Court was so-and-so, was not entitled, and so on and so forth. Page 11, from the aforesaid facts, it is clear that the respondent company is admitting its liability of investing the said amount of rupees 20 crores in the joint venture company, and its stand is it has carried out the obligation by investing said amount by the 2 checks. The stand of the respondent company is that the 2 checks were not in cash for reasons beyond its control. That was the Bombay High Court order. That's the way they misled the arbitrator. However, the fact remains that the company accepts its liability of investing 20 crores in the claimant company in furtherance of obligations under the joint venture agreement dated so-and-so in terms of press note 2 of 2005. In the instant case, then this liquidated damages not granted, and I award the respondent company to pay escort the JV that 20 crores. So the court will be pleased to appreciate that this finding is based on an admission by the JD, by the rogue directors, that we have to pay, whereas there's nothing in the JV. And in any case, the learned arbitrator has been misled into getting into arbitrating on a statutory compliance, which is non-existent, just outside the subject matter of the contract. The learned arbitrator does not anywhere in this award say that under the JV agreement, there was a contractual liability.
Yes.
The learned arbitrators proceeded on the press note, which is not applicable to me. So that is the way they obtain this award. I learn about it on 10 July by the letter which the HSBC sends me, Annexure P4, Annexure 24 on page 162.
Yes.
That in execution, there's attachment.
Yes.
And within 12 days, I'm before this court. Now, on this particular aspect, the court will receive what is the law. The court may come to my compilation, because this is what the Supreme Court says as to if the fraud is there. Please to see my compilation. This is case number
compilation
8. I'm sorry, not case number 8.
Yes.
Case number 13, which starts at page 85, 2007 4 SCC, page 221.
Page?
This is on page 85. The page 85 of the compilation. Supreme Court decision is 2007 4 SCC, page 221. The relevant part is on page 95, para 22. Let me just read.
Page 225.
This is on page 95 is the relevant part. 95, the relevant part.
Page 22. Paragraph 22. Yes, you pointed out.
I pointed out in the para 26 that this applies
Yes, that is
throughout. Now, on the and then on page 99, the court will be pleased to see. Or before I come to 90, is on the para 38 on page 100. I'm sorry.
Para?
38 on page 100. Let me just read that.
Yes.
The matter can be looked at another angle, because here the matter is come to the Supreme Court. Suppose a case is decided by a competent court. The word competent is important. After hearing the parties, an order is passed in favor of the plaintiff applicant, which is upheld by all courts, including the final court. Let us also think of a case where this court does not dismiss especially petition, but after granting leave, decides the appeal finally by recording reasons. Such order can truly be said to be a judgment under Article 141 of the Constitution applies, to which Article 141 of the Constitution applies. Likewise, the doctrine of merger also gets attracted. All orders passed by the court authorities below therefore merge in the judgment of this court, and after such judgment, it is not open to any other party to approach any court authority to review, recall, or reconsider the order. The above principle, however, is subject to the exception of fraud. Once it is established that the order was vitiated by a successful party by practicing or playing fraud, it is vitiated. Such order cannot be held to be legal, valid, or in consonance with law. It is non-existent and honest and cannot be allowed to stand. This is a fundamental principle of law and needs no further elaboration. Therefore, it has been said that a judgment, decree, or order of prima fraud has to be treated as nullity, whether by a court of the first instance or by the final court, and it has to be treated as non-honest by every court, superior, inferior. This is a case where matter has been decided up to the Supreme Court on merits.
Yes.
Even then, that is an honest.
Yeah.
In the present case, the Supreme Court simply says we are not inclined to intervene in limine with liberty to file this case. The import of what fell from the court yesterday is on page 99, para 36, where the court talks about different situations, and the part which is relevant to us is para 4. Para 36, subclause 4, in the extracted part. An order refusing special leave to appeal may be a non-speaking order or a speaking order. In either case, it does not attract the doctrine of merger. An order of special leave to appeal does not stand substituted in the place of the order under challenge. So the division bench order has not been upheld. all that it means is the court was not inclined to exercise jurisdictional discretion so as to allow the appeal being filed. So I'll touch upon this when I come to res judicata.
So an order refusing special leave to appeal may be non-speaking order or speaking. Either of the case does not attract in merger. That's okay. An order of refusing special leave to appeal does not stand substitute in place of the order under challenge.
And then the court, when goes further to see, is only when reasons are given.
Correct.
Then only that one can say it substitutes,
Interfere.
interferes. And there also, I'll show from the court, it has to be on the same ground. There's yet another decision when I come to constitutional judicial, I'll show that if it matters based on some other ground than what is before the division bench, even then it's not, res judicata will not apply. But here the proposition is very simple. In limine dismissal by the Supreme Court without giving any reason does not mean that the order of the division bench is assumed finality or is proper. All it means is we're not inclined to entertain leave, and I'll show why. Because at that point of time, we had filed the special leave petition first, then we filed the objections. In the counter, with my learned friend, they filed, they say that subsequently we have filed the objections, which is be treated like a suit, and we've also gone to the NCLT. In view of that, the Supreme Court took the view, because I had argued the matter for the Supreme Court. In view of that, that liberty was given. Pursue your remedy, because this is anyway a suit. Supreme Court has not approved the view taken in the division bench, because that is contrary to Dulabai, is contrary to Sukanya Holdings and all that.
Not taken, but fact remains the division bench order is there.
So to the extent that I say that I can challenge an arbitral warrant civil suit, I can't.
Correct.
To that extent. But only to that extent.
Because as per your case, what your case made out here, though you have filed this suit challenging the award under 34, they filed order 7 rule 11 only on the basis with regard to the 34.
No, not 34. I didn't go under section 34. A civil suit under section 9.
Now, that's why it is only the 34 civil suit will not lie.
That's a limited point, and I show that.
Court has held, this court has held, yes, part is allowed, part is not allowed. Some prayer is to be continued with the suit. Then in appeal, no, it cannot. That is
so only on the ground of want of jurisdiction.
Your answer, your submission is that the suit which was dismissed, which was upheld up till this, if you not go to the Supreme Court, if you go by the division bench, the appeal is upheld only with regard to the section 11, whether the suit was maintainable or not.
And that was those proceedings were only under Order 7 Rule 11, when one can't come into the merits of the case.
That's why the no merit is
without merit. When I talk about constitutional judicata, there are 2-3 direct judgments of the Supreme Court on this very point. So I'll come to that there. But here, this reason I was citing this to show that the consequence of fraud is to vitiate a judgment, because the court will be pleased to see my objections have been filed. Order 21 Rule 58 and Section 151, not read with Section 151. All the requirements of Order 21 Rule 58 are for the objections under that provision, which I've already satisfied on yesterday. Independent of that, my objection under Section 151, where the Supreme Court have cited the judgment yesterday to Arik Pandey that independent of all considerations, if it's fraud, I can maintain objections. This is the second judgment on that point. And because here, the requirements, for example, the court may see in this way judgment the requirement of limitation.
Yes.
When the case is there by fraud, the question of limitation does not even arise. That's the view taken by this court. This is on page 233 of this very compilation. For Order 21 Rule 58 is relevant, the time. But for fraud, there is no limitation. Page 33, that's the decision of this Honorable Court, para 7, in the center. The fraud on court, the fraud on court, this is, I'll read this judgment. This is 1967 lawsuit, Calcutta 255.
233.
Page 233. Page 233, para 7, about 6 lines from the bottom. That fraud on court admits of no bar of limitation.
Yes.
In the matter of granting adequate relief against it and the court's power to undo mischief caused by such fraud resulting from same, no application being obviously needed for the purpose of the law, and the only limitation such matter lies in the court's view of the justice or otherwise of the exercise of its inherent power to do justice between the parties concerned, or the exercise of discretion in that behalf. So limitation might be relevant from the point of Order 21 Rule 58. I have satisfied there was no delay, because immediately I got, if not only continuing, if I succeeded in my suit, I didn't need to file this.
Continuous.
So it's continuing.
That's I'm telling. It is if it is.
It is, so there's no
if it is
delay.
Continue, then it will.
So there's no delay. If the suit continues, yeah, the court is absolutely right. If the suit continues, then I don't need to file this.
Correct.
So that's the reason one can still talk about limitation. But when it comes to fraud, there's no question of limitation at all. So as far as coming on this point, if I may just, the court may, I won't take the court labor more on this point, but the court may see that if there's a fraud, what is the court supposed to do? Because one side they're saying we are a separate corporate entity. The court will recall what the division bench has said, that the funds may have been stolen from the accounts of JD, but that is a separate corporate entity.
Yes.
Now, my argument, which is there in my pleadings here,
Yes.
is that the court is then to lift the corporate veil.
Okay.
To see who's the entity. I've shown the court from the joint venture agreement. This Starlight has 100% ownership of Augustus. So for that proposition, when there's a fraud and the court has to lift the corporate veil, court may be pleased to see the decision, which is
With regard to the corporate veil.
Lifting the corporate veil. When there's a question of fraud, if I may just take the court directly to that decision. That is case number 21 on page 153. It's a Supreme Court decision, 1996 for SCC 622, Delhi Development. And the court may come to right from page 160 onwards, the court goes about the concept.
168. Yes.
The court goes on to talk about lifting corporate veil. The summary is in page para 28 on page 170.
170.
170. The concept, para 28, the concept of corporate entity
Yes.
was evolved to encourage and promote trade and commerce and not to commit illegalities or to defraud people.
Yes.
Where therefore the corporate character is employed for the purpose of committing illegality or for defrauding others, the court will ignore the corporate character and look at the reality behind the corporate veil so as to enable to pass appropriate orders to do justice between the parties concerned. And then the court on para 130, para on page 173, para 32, referred, of course, to Article 142, but this proposition is also applicable to this Honorable Court's powers under 226, para 32 on page 173.
Yes.
We are of the opinion that the holding in Amritlal so-and-so should guide us in exercising the extraordinary power of this court under Article 142. The absence of a statutory provision will not inhibit this court while acting under the Act, under this article, from making appropriate orders from doing complete justice between the parties. The fiduciary relationship may not exist in the present case, nor is the case of the holder of public office. Yet, if it is found that someone has acquired properties by defrauding the people, and if it is found that the person defrauded should be restored to the position in which they would have been but for the said fraud, the court can make all necessary orders. This is what equity means. And in India, the courts are not only courts of law, but also courts of equity. So that's the reason my objections are, I need the money to come back. This is my vehicle I had created. I had a direct JV with them to create, for administrative reasons, tax purposes, I created a vehicle. I park my funds there.
Yes.
The road directors, including with them, defraud me.
Yes.
So this is as far as the issue of fraud is concerned. I won't bother the court with all the other judgments, but just the court may please to see only the index. I'll just mark the cases where judgments have been given by the Supreme Court and this Honorable Court in context of arbitral awards. I've already pointed out that even estoppel, equity, etc. does not count.
That I put because you pointed out.
I pointed that out. So that's the judgments. Then I won't trouble the court with that. And I'll quickly straightaway go into constructive res judicata defense. Now, my learned friend has taken the plea that this matter is barred by res judicata. When I filed the suit, they filed Order 7, Rule 11 to non-suit me on that ground. we'll go to what the judgment says. When I'm filing Order 21 Rule 58, this is treated like a suit. We are again in the realm of Order 7 Rule 11. And now they're saying res judicata. There are several reasons why res judicata is not applicable. First, I've already read from the judgment about in limine dismissal. I'm here by virtue of the liberty given by the Honorable Supreme Court to pursue this case. So that's the reason, and I'll refer to the liberty judgment also to show that is actually in my favor. What my learned friend had given the liberty judgment. But the Supreme Court has expressly given me my liberty to pursue this case. The question, that's a final court. What was a challenge was the order of the Honorable Division Bench judgment. In that, the court says, go and pursue their objections there and raise all your grounds there. The question of anything being binding on me does not arise. That's first part.
So that's why, see, with regard to the Supreme Court given liberty, their contention is that whether this is the liberty, whether you can maintain the application, that is the objection.
Yes, and now that also I'll show from the judgments that this was a liberty, because this is in view of the counter affidavit. I'll come to the facts and to show not only was this the liberty, in law that application doctrine does not apply. For that, may I just first cite two judgments of the Supreme Court, the index I gave yesterday, and then I'll take the court through in light of the case law, what has actually happened. The court may just see the citation I gave yesterday. The first case I like to seek liberty to refer to.
Judgment. Yes.
Shodhan Singh versus Daryao, it's a landmark judgment on page 8 of this compilation. I'm sorry, page 9 of this thing, and the relevant para is para 9. The court will be pleased to see. After extracting section 11, the court will be pleased to see para 9.
Yes.
A plain reading of section 11 shows that to constitute matter res judicata, the following condition must be satisfied. The matter directly and substantially in issue in the subsequent suit issue must be the same matter which was directly and substantially in issue in the former suit. In this particular case, there we had Order 7 Rule 11 on the issue of civil court. Here is a question of fraud. Here is a question of lifting corporate veil. None of those are cases were even issues aren't even argued or considered.
Yes.
The second is the former suit must be the same parties and between the same parties. They must be under the same title. For the court which decided the former suit should be a court competent to try the subsequent suit or the suit in which such issue is subsequently raised. The Division Bench, a single judge says we are not the competent court. There's want of jurisdiction. Civil court is not competent.
Yes.
For res judicata reply, both the courts, first and second, must be courts of competent jurisdiction.
Correct.
If either one of them is not, there's no question of res judicata.
Yes.
Then fourth, the matter directly and substantially in issue in the subsequent suit must have been heard and finally decided by the first suit. Now, will that Supreme Court decision be a final decision? For that, the court may come to para 16 of this very judgment of another case, which is illustrative. Page 17.
Yes.
The next case to which reference has been made is Asghar Ali Khan versus Ganesh Das. In that case, the appellant in pursuance to a deed of dissolution partnership executed a bond for payment of some money to the respondent. He is sued to set aside the bond on the ground of problem misrepresentation on the actual amount due. The trial court and on appeal, the district judge held that the alleged fraud was not established and dismissed the suit. On further appeal to the judicial commissioner, it was held without entering into the merits that the appellant could not avoid the bond as he did not claim to avoid the deed. The final court appeal thus refused to determine the issue of fraud and dismissed the suit on the other ground. In a subsequent suit by the respondent on the bond, the appellant raised a defense, the same case of fraud. It was held that the issue raised by the defense was not res judicata since the matter had not been finally decided by the final court of appeal. That case also had no application to the facts of the present case. For in that case, the final court of appeal did not decide the question of fraud and dismissed suit on another ground. In such cases, well settled, there can be no res judicata where the final court of appeal confirms the decision of the court below on a different ground or on one of the several grounds but does not decide the other ground.
Yes.
Even in so here, even in here, this is not the facts in this case. The Supreme Court did not get into it. Even if the Supreme Court had got into it and decided on some of the ground, even then there would be no res judicata. But here the position is, what if I may respectfully submit, the issues which are raised here of fraud, lifting corporate veil, have not been even considered either by the single judge or the division bench. No question of the Supreme Court getting a finding on that. So this matter is not, these issues have not been finally heard in the first place. The real proposition laid down by the Supreme Court is in paragraph 14 of this judgment.
Yes.
Paragraph 14, reliance in this connection, I'm reading about 6-7 lines from the bottom. Reliance in this connection is placed on the wealth cell principle, that in order that a matter may be said to be heard and finally decided, the decision in the former suits must have been on merits. My case was not disposed of on merits, where, for example, the former suit was dismissed by the trial court for want of jurisdiction, or for default of plaintiff's appearance, or on the ground of non-joined parties and misjoined parties of multifariousness, or on the ground that the suit was badly framed, or on the ground of a technical mistake, or for failure on the part of the plaintiff to produce probate or letter of administration or succession certificate when the same is required by law to entitle the plaintiff to decree, or for the failure to furnish security for cost, or on the ground of improper valuation, or for want of payment of additional court fee on a plaint which was undervalued, or for want of cause of action. This is where the division bench says there's no cause of action.
Yes.
Or on the ground that is premature and dismissal is confirmed in appeal, if any, as in this case. The decision not being on merits would not be res judicata. This squarely applies to this case.
Yes.
Now, this is one aspect of the matter. The second aspect of the matter is, can I be non-suited? Well, we are still in the realm of Order 7 Rule 11 right now for these objections. They're to be treated as a suit. They have to be treated as a suit. Is the Supreme Court has laid down that even the question of res judicata is a matter of trial. That's the next judgment, which is on page 22, 2021 9 SCC, page 999. If I may just read just the head notes and then maybe one paragraph from inside. Sri Hari Hanuman Das.
Yes.
Order 7 Rule 11, rejection of plaint where suit appears from the plaint statement in plaint to be barred by any law. Applicability of the bar of res judicata. Held cannot be determined at the stage of rejection plaint. The same can only be determined upon merits on the trial of the suit. Plaint in subsequent suit cannot be rejected on the ground that it is barred by principle res judicata, as the same will require production of pleadings, issues framed, and judgment in the previous suit to compare it with the present suit. And that cannot be done for deciding an application under Order 7 Rule 11, as only the averment in the plaint itself may be considered at that stage. And in this case, there was no res judicata, had not be rejection of plaint, applicability of bar res judicata, held cannot be determined at the stage of rejection of plaint, as my learned friend is saying. The same can be determined, can only be determined upon trial of the suit, as only the moments on the plaint itself may be considered at this stage. The court may be pleased to see inside. Not just to sum up, first suit gets dismissed on the ground of Order 7 Rule 11. I filed objections which will be treated like a suit. That was the consideration for the Supreme Court to relegate me to this court. Here they are saying again Order 7 Rule 11, argument, res judicata. Supreme Court says that itself is a matter of trial. You have to, what my learned friend has done is he's read chunks from the DB judgment. He's not read my pleadings in my objections, which I will read, to show that none of those issues arose in that case, and they got nothing to do with that the principle does not apply. So I'll read that. I'll read the DB judgment, where the DB's division bench says, we are not getting into the merits. This is a frontal assault only in arbitral award. And my pleadings on the objections which talk about this fraud, which we argued yesterday.
Yes.
So none of that, one has to read both pleadings, but that also has to be done during trial.
That's why their case is that in the suit, what you have pleaded with regard to the fraud, what you are submitting before this court now also, that is your pleading before in the suit. In the suit. But that's why they are taking the plea. This court has dismissed partly. Then division bench has totally dismissed one. It has been totally dismissed, so it was with Broadway. So your question is no, it is not. It is a Order 7 Rule 11 only with regard to the maintainability of the suit, whether the 34 is without going to the 34, whether the under the by a suit, the award can be changed.
Yes. Now,
We also said that division bench dismissed it because they don't have a cause of action.
And the cause of action is because I'll take the courts to the different judgment where they say, why don't they have a cause of action? Because they cannot challenge the arbitral award in the civil court.
That is
So that I'll take the court to that. But the point out here, which the para I'd like to draw the honorable court's attention is para 12 of this very judgment, because even this exercise of res judicata or otherwise has to be done only. The court will give me a minute. Para 12.
Yes.
Yes, if I may just read. I'll just read para 12 and I'll read para 19. That's all. I'm reading out here for the proposition that what is the approach to be taken when somebody pleads res judicata. The appellant filed a revision petition with the High Court assailing the order dated so-and-so of the trial court. The High Court dismissed the appeal, upholding the reasoning of the trial court on all three grounds raised in the Order 7 Rule 11 application. On the ground res judicata, the High Court placed reliance on the decision of so-and-so and observed that the learned trial court correctly came to the conclusion that the application filed in Order 7 Rule 11 on the ground res judicata could not be decided merely by looking at the moments in the plaint. In view of the High Court, a plaint could be rejected under Order 7 Rule 11 only if it was not maintainable on the basis of the moments contained in the plaint. In the present application, such a determination would require production of pleadings issues framed in the judgment in the previous suit to compare it with the present suit. This exercise, the High Court held, could not be undertaken merely by looking into the plaintiff moments. So merely by looking at my objections,
Yes.
the court cannot determine res judicata. It has to go for trial. And the reason for that is in para 19. I'll just read this one para. At this stage, it will be necessary to refer to the decision that particularly deal with the question of whether res judicata can be the basis or ground for rejection of a plaint. In this case, my objections. In Kamla so-and-so, the trial court allowed the application of rejection plaint in the suit of partition. This was affirmed by the High Court. Justice S.P. Sinha J. speaking on for the two-judge bench examined the ambit of Order 7 Rule 11D and observed Order 7 Rule 11D has limited application. It must be shown that the suit is barred by law. Such a conclusion must be drawn from the moments in the plain different clauses of Section 11 sections Order 7 Rule 11 and opinion should not be mixed up. And I'll just read the italics part. Absence of jurisdiction part of the court can be invoked at different stages and under different provisions of the code. Order 7 Rule 11 of the code is one. Order 14 Rule 2 is the other. For the purpose of invoking Order 7 Rule 11, no amount of evidence can be looked into. The issues and merits of the matter which may arise between the parties would not be in the realm of the court at that stage. All issues shall not be the subject matter of an order under the said provision. So the Honorable Division Bench, the learned single judge, Honorable Division Bench, when they're dealing with the Order 7 Rule 11 application, are not going to go into the merits of the case by law. That can't be looked into. They have to take a call based on the moments on the plaint only, and then the matter in the subsequent suit is filed. In this case, these objections, that comparison has to be done not at the upfront. It has to be done during trial.
Yes.
So the entire approach of what my learned friend was doing is just reading few orders. Now, if I may take the court directly to what has the division bench said, if I may take the court on that point. The court may be pleased to turn to the division bench order, which is with their reply.
The page where
it is with their affidavit in reply. If I may just take the court directly to that. That is
affidavit in opposition.
It's their affidavit.
Page 67.
Page 67. So the court may be pleased to turn first to page 71. Para 71, para 6.
Yes.
The rest of what is stated in the plaint makes for interesting reading and may even arouse suspicion of the court. This was that plaint, or evoke sympathy for the plaintiff. But when the action cannot be entertained, the merits of the matter cannot be addressed. The division bench itself says they're not getting into the merits. And the court may further see page 85, para 35, page 85. My learned friend read the judgment, but in bits. So I'm just reading the other parts.
Yes.
Page 85. The plaint is fashioned as, I'm sorry, page 85, para 35.
Yes.
The plaint is fashioned as a frontal attack on the arbitral award, and all relief so and so pertain to the arbitral award and arbitral award alone. After saying this, the Honorable Court on page 88, para 38. In the last three lines, if I may just read that, the authority of a court to receive and try a suit of a civil nature, the Honorable Court has it, under Section 9 of the Code is tempered by the caveat in the last limb, except for of which a cognizance expressly impliedly barred, in a remedy against an arbitral award being exclusively covered by Act of 1996, which is the complete code as it regards arbitration law in the country. A challenge to the arbitral award, the Hose Act of 96 has to be regarded as impliedly barred within the meaning of the relevant expression on Section 9 of the Code. In light of the above, it is completely unnecessary in the present context to embark on the exercise to whether it is permissible to partially reject. The plaint in this case cries out to be rejected in its entirety as being an animal not known to legal science. Whatever other remedy may be available to plaintiff or against the defendants, plaintiffs are not entitled to release claim in suit, even if all the allegations of the plaint are accepted at face value. Expressed another way, the plaint plainly does not disclose a modicum of cause of action. It is for that reason the court says there is no cause of action.
Yes.
The court may be pleased to see para 41.
Now the allegation expressed in the another way, the plaint plainly does not
Disclose any cause of action, because we can't even get into that question, because you cannot entertain a suit challenging an arbitral award. The court may be pleased to see this clarified in para 41. And this is then, since the plaint pertaining to present suit is not found to disclose any cause of action, and the plaintiffs are not found to be legally entitled to any release claim, the plaint is liable to reject it as a whole. The reference to cause of action is in context of you cannot file a suit. It is not, because the court says you're not getting into merits, and even assuming everything is correct. But since you can't file a suit to challenge an arbitral award, that's why you don't have cause of action. Okay. Not because there's no grievance. Because that grievance has been even mentioned on page 84, para 31 for that matter. The Honorable Division Bench took care to mention this on page 84, para 31.
Yes.
Para 84, page 84, para 31 of the judgment. On a plain reading of a plaint, since a more searching reading of the plaint is unnecessary in the present case, this is page 84. The Honorable Court did not even go into the entire plaint. On a plain reading the plaint, since a more searching reading the plaint is unnecessary in the present one, the wrongs alleged to have been committed are wrongs committed qua the company. It is true that the plaintiffs parked their funds in the company. But upon the company receiving the funds, they became the funds of the company. And the allegation plain that defendants may marry the funds that the pro forma defendant have to be seen legally to be monies apparently stolen from the pro forma different company and not the plaintiffs. Here is the argument of lifting the corporate veil. The court did not even get into this whole issue. The court records that the money had been stolen.
Yes.
Even so, at the end of the day, what they say, I have parked my funds in my subsidiary. Correct. That becomes the money of the subsidiary. Correct. My respectful submission is lift the corporate veil. It is my money. So that is some respectful submission in context of res judicata. The matters have to be same. But this judgment has gone on the premise of civil court has no jurisdiction because the frontal attack on the arbitral award, and hence you have no cause of action, even if what you're saying is correct.
Okay.
that will not amount to have a satisfaction of section 11 of the CPC to invoke res judicata. Now, I'd like to, it's 3 o'clock.
How much time you further take?
And you've got to bring that order to the NCLT, because what has happened of NCLT and make a couple of arguments my learned friend has raised of the doctrine of election. Can I file a suit and file objections? That direct judgment to say I can. And NCLT is that they can't get into fraud. So I will probably need it. Court bench has fixed 2 dates again, and maybe hopefully conclude on those dates.
Consistent suffering for the plaintiff. Consistent suffering for the defendant. Exactly execution.
Oh, yes, of course. I'm so sorry. Thank you.
Award holder. Consistent suffering for the award. Consistent suffering for the objector. Counsel for the objector has argued the matter at length, but due to paucity of time, hearing could not be completed. Then again, that it will go for 2 months.
You will any date in February, March, convenient to the owner.
March you will get that. That is only a date which hai dekho.
March. I'm saying February. I mean, whatever's convenient to the court, I can come.
If February, then my lord, since your lordship has
That
heard
is
it
the problem.
extensively,
March
and I am sure, my lord, this has been marked as a part-heard matter.
I mean, it is part of it. Yeah, it's been allocated to all the judges.
Oh, sign.
Sign. Sign matter.
No,
Sorry
then-
about that.
then-
If 11th, 12th February, if that's convenient.
18th and 19th February at 11:30.
18th and 19th
19th
February.
11:30.
Very well. Very well. At 11:30? 11:30. Deeply obliged.
11:30 to 12:30 you will get one hour only.
Well, I'm deeply obliged. 18, 19, I'm at the just as a little bit confused on it. But I just had to do it.
17th, I mean, Rachi.
18. Very well.
Doesn't
Deeply obliged.
18-19 না এই আমাদের রাঁচিটা কবে আসবে?
Yes, call the man.
Item number 1. আপনার 1 ডেকে নিয়েছে
3 PM.
2 বার थे
क्या है? Hearing?
আমি বলছি আপনি রেসপন্ডেন্ট
তুমি ওদিকে কেন আমি ভুল বলছি you on my side.
Yes.
Don't change side. You're not fair.
Huh.
You said that you have a suit fixed.
Finished.
Finished.
Elephants, Parsis.
Sorry.
अरे देखे नहीं क्या मैटर है? ठीक है चलो देखते हैं।
Yeah,
My lord, my lord, in this matter, my lord, I am being led by Mr. Thakkar. My lord, he's on legs before court 32, praying for a short fast.
Continue.
Nana, I
He'll
think
come.
they-
We have to submit anyway.
In any case, the defendants have to submit because the question of vacating has to be considered.
My lord will take my matter later. The GA2 is for orders, section 45.
Yes.
And GA10 is my application for extension of time to file the written statement. Written statement has been filed in the department. It's only subject to your lordship's leave. But since we are pressing the 45, that can be heard after 40.
Yes.
This pen is well. My lord, may I? My lord, I appear for the respondent number 6 and 7.
So far as defendant numbers 11 and 12 are concerned, after my learned senior friend has made
Have you filed the affidavit?
Yes, I have already filed my opposition. Reply has been filed. So I'll just supplement his submission.
No, but he cannot supplement at this stage because my lord, now the hearing is restricted to whether pursuant to the appeal court's order, my lord, if your lordship recollects, I placed yesterday, whether the injunction should continue
Against
7. Submission. You go file an appeal.
Take the shelter as a
Shelter, no shelter. I don't want anybody under my umbrella.
Not a 6.
But I appear for the defendant number 10.
Order which you obtained.
No, whether the only difficulty I'll tell you, whether this shelter will extend the interim order because they'll keep making submissions. So this
No, my lord, I am defendant.
My
number
agony
10.
will-
I am a
my
sister
agony
concern of Mr. Moinak Bose's client. The goods are lying with me, and that has been there is an injunction on my goods.
He's in a car.
As well as my bank account.
He's shaking in a car.
No, let Mr. Bose submit. I will, whatever supplement I need to add, your lordship will give me 15-20 minutes. I will conclude.
Total body is shaking.
So let Mr. Bose complete. After that, I will.
Let the respondents not fight on this. Let the injunction continue. Let them decide what they want to do.
See,
That's what Mr. Thakkar
Mr.
would now.
Thakkar has done his job.
Yeah, he makes merry out of it.
Then you all
Decide what they want to
what
do.
is to be done.
I am ready as far as the matter is concerned.
Yes.
May I place my case? May I place my case?
666.
I am the petitioner. Now this is final hearing of the injunction application.
Yes.
Then Mr.
Kindly see the order.
Then Mr. Bose will say, then he will argue the matter with regard to that.
GA1 is.
See, Mr. Thakkar, let what is one thing
Order
to be
the
clarified with regard to the section 45. What will happen?
Yes, I can clarify that.
Yes, because defendant number 10 is the party.
Defendant number?
No,
One.
Sorry. Defendant number 1 is the party to the agreement.
Yes.
And arbitration clause is there.
Yes, my lord.
And other defendants are not the party.
Yes, my lord.
So what would be the fate of the section 45?
The section 45 has to be rejected.
Has to be?
Has to be rejected. Because the plaint has to be read as a whole. There cannot be bifurcation of reliefs. There cannot be bifurcation of cause of action. That is the settled law. And I am supported by that by Supreme Court authority fairly recent. That where there is an overlapping of cause of action between a defendant who's party to an arbitration agreement and a person who's not party to an arbitration agreement, reference to arbitration is impossible.
Okay. Okay, then
If he wants to press his section 45 now, he can press it. I have no difficulty. We can hear GA2.
Yes, continue. You come. Let Mr.
May I start with GA1, my lord?
First, I will hear you. First, he complete his agreement. Because he is a plaintiff.
Yes.
Now,
GA1,
the
my lord,
affidavit is completed.
No, my lord, I can understand, my lord, since I'm suffering an order.
That's why.
Yes.
So my lord, now today.
So now with regard to let Mr. Thakkar, I will only put the question, what is the liability of the defendant number 6?
Very well, very
First
well.
you
Very well, my lord, only 6.
Yes.
No, my lord. Also defendant 10. My good.
I will take all these things. Let first I have to go by the division bench order. Division bench order clarified that. Let first Mr. Thakkar specify with regard to the defendant number 6.
Grateful, my lord. Yes. Now, my lord, may I start with only defendant number 6? My lord, I am not addressing your lordship on the other defendant.
Correct. Because it will be shorter.
Have your chair. Papers are voluminous. Before I trouble your lordship with the documents,
It is GA1, na?
GA1, please, my lord. We give your lordship an overview of the matter and then trouble your lordship with.
Yes.
WS ka kaagaz hataao. And this I am saying only apropos, my lord, I am addressing your lordship only apropos defendant number 1 and defendant number 6.
Yes.
Because no submission can be made apropos defendant number 6 without, my lord, showing your lordship the link between 1 and 6.
I think whatever your case, that is already recorded in my earlier order.
Yes, my lord. Now I want to, my lord, just refresh your lordship's memory and then take your lordship with the document. Now, my lord, my specific case before your lordship is this. Apropos defendant number 6 and 7, the defendant number 7 is not represented before your lordship. He has not used any affidavit. Why I say this is, first, kindly take the affidavit in opposition purportedly filed by defendant number 7 or on behalf of defendant.
Defendant number
7.
6 not filed.
Yes, affidavit in opposition of my lord Saugata Banerjee. Because today, my lord, your lordship is concerned with affidavit evidence. We don't have the witness on the box. So whatever said in the affidavit, your lordship has to believe this way or that way. Now kindly see, so much is said about by Mr. Bose, and kindly see how they deal with this matter. What is the seriousness? Actual, rather than what is portrayed. Kindly see. Paragraph I, Saugata Banerjee, son of so and so. So he is not the defendant number 7 in person. Now he says, I am the legal officer of the respondent number 6 above named and a principal officer thereof. I am competent and duly authorized to make and affirm this affidavit for and on behalf of the respondent number 6 above. No difficulty, my lord. He might have a board resolution.
Yes.
He might be authorized. Now, can you see the next sentence? I further say that I am the authorized representative of the respondent number 7 and I am competent to make and affirm this affidavit on and behalf of the respondent number 7. My lord, my attorneys have taken inspection in the department.
Best point.
Yes, we have called for notice to produce the documents, my lord, by which he claims to be the authorized representative. Number 1. So, my lord, let them show whether how he claims to be, the deponent claims to be the authorized representative. Now, second, what is my case, my lord? Let me just tell your lordship what my case is. Apropos defendant numbers 1, defendant number 6, and defendant number 7. My case apropos defendant number 6 and 7 specifically is, my lord, that defendant number 6, defendant number 7, representing himself to be a director of the defendant number 6, represented to my director, who has affirmed the plaint and the petition, that they with the defendant number 6 will supply goods to the plaintiff, but through the defendant number 1. They will not enter into a direct contract with me. The contract will be between me and the defendant number 1. And for payments which I make to defendant number 1, defendant number 1 will make payments to them and the goods will be distributed. This is my simple case. The defense here is that there is no privity of contract between D6 and D1. I am sorry, D6 and the petitioner. The contract is placed only on D1. So there is no privity of contract. That is his first defense. Second defense is that whatever monies I have paid, you have paid only to defendant number 1. I may have received monies from defendant number 1, and he's admitting that he has received monies. Defendant number 1 also shows that he has paid monies. But whatever monies I have received from defendant number 1, goods for that amount I have already supplied. These are the two lines of defense. One is a purely legal defense on whether there is any privity of contract or not. Second is a factual defense. Now, the first issue which I raise is, kindly see the petition once, please. My pleadings apropos defendant number 6 and 7. Kindly have the petition once, please. There are 8 contracts in all between the parties. Now, kindly see paragraph 13 on. 13 on. At page 11.
Yes.
This is after I had entered into the first contract. Sometime in the first week of June 2020, the plaintiff entered into discussions with the defendant number 6 for purchase of bulk quantities of 1,000 metric ton and above of high carbon ferromanganese through a common acquaintance, Mr. Patik Batra. Plaintiff was informed by Mr. Batra that the defendant number 6 had quoted a price of about $900 for supply of bulk quantities. Plaintiff was surprised to receive this offer as the defendant number 1 was supplying a lesser quantity of the same product manufactured by the defendant number 6 at a price of €795.78 under the first contract. The price of high carbon ferromanganese is substantially discounted when purchased in bulk quantities. Further, the market price of the product had also fallen and was in the range of $700. Similar, D1 is supplying products manufactured by D6 at a price lesser than what D6 is quoting to me. So in these circumstances, the plaintiff informed Mr. Batra that the price quoted by the defendant number 6 was unrealistic and that it was expecting a price in the range of €600. It transpired that Mr. Batra informed the counter offer of the plaintiff to the defendant number 6, who responded by an email of 8 June 2020 to Mr. Batra saying that it would rework its offer. Now, this email is at page 149. Your Lordship would have the email at page 149. Is the email from Batra which has the trail mail of the defendant number 6. This is in volume 2, please, my lord.
Email of the defendant number 6.
Yes. Email of the defendant number 6.
$149.
Yes, please, my lord.
Yes.
This is the defendant number 6 writing to Pratik Batra.
Who is Pratik Batra?
Pratik Batra is my acquaintance, my lord, who was negotiating on my behalf with the defendant number 6. These are, my lord, these facts are not.
Middleman.
He's a middleman. Grateful.
Yes.
With kindly see paragraph 3. Coming to the price mechanism, I wish to inform you that if you see, the offer is almost now over 2 weeks old, and the dynamics of our products prices keep changing a lot within days, and same thing happened to this case as well. There has been some correction, and we can surely work out on the same. Saying price might have come. There's some correction. Although we are sure the mention of 30% above pricing from the market is a bit tough thing for us to accept as per current pricing line of Indian ferroalloy products, that still we can definitely rework on the same as you mentioned, keeping in mind the bulk quantity and repeated long-term relationships. It will be very useful if you can kindly confirm, check with them at what levels and terms they are firm in buying and let us know so we can rework the entire thing and get back to you at the earliest. Now this is the email. Then kindly come to the next page, which now Batra writes on my behalf to the defendant number 6. Euro and USD are primary currencies we are dealing with. However, Euro for all our future communication is preferred since we deal primarily with European market. Unless otherwise, if ever, I'll inform you accordingly. Quantities remain as stated above, with sole perspective of increasing than latter, but the target prices for the composition remain as stated. Accordingly, you can revise and reshare the quote. Moreover, I would also like to use this opportunity to schedule an introductory Skype call tomorrow with Mr. Ali Mahabadi, reading in copy, being party from Italy, joining us currently from France due to the lockdown. Please let me know if it is convenient, etc., to schedule a call. And your lordship will find in the copy field, my email address is given there, info@dv-x.com. This is the plaintiff. And Ali Mahabadi, my lord, is the director of the plaintiff who has affirmed this application and the plaint. So, my lord, this is Ali Mahabadi informing who is marked in copy and with whom a meeting is.
Ali Mahadi
is the director of the plaintiff who has affirmed this application. Your lordship will find, and the plaint, page 122 of volume 1, application is affirmed by Ali Mahabadi.
Yes.
So is the plaint.
Yes. Yes.
Now kindly see paragraph 16 and 17 are very. A virtual meeting on the Skype platform was held on 10th June 2020. So the virtual meeting was requested and a virtual meeting was held between the plaintiff's director, Mr. Ali Mahabadi, Mr. Shayan Chatterjee, Senior Manager Sales and Marketing of the defendant number 6, and Mr. Pratik Batra. In course of such meeting, it was represented by Mr. Shayan Chatterjee. The defendant number 6 was a part of the Shyam group of companies, which included the defendant number 10 and Shyam Metallics and Energy Limited. Mr. Chatterjee claimed that defendant number 6 and 10 could single-handedly meet the plaintiff's requirements of all kinds of ferroalloys. The parties discussed about the procurement of bulk quantities of diverse ferroalloys over a long term. In course of negotiation, the defendant number 6 stated that it was aware that the plaintiff had bought a consignment of 216 metric ton of high carbon ferromanganese manufactured by the defendant number 6 through the defendant number 1 at a price of $875 per metric ton. However, the defendant number 6 declined to disclose the price at which the defendant number 1 was purchasing the materials from the defendant number 6. The defendant number 6 also declined to reduce its offer price below $800 per metric ton for sale of bulk quantity directly to the plaintiff. However, the defendant number 6 confirmed and assured the plaintiff that the defendant number 1 was associated with the defendant number 6 and 10, and the said defendants would perform and deliver all orders placed by the plaintiff on the defendant number 1 provided they receive full payment before loading containers. This is the representation which was given. Now, whether this is sufficient to bring out contractual privity or not, I'll show your lordship from the case laws. Then, my lord,
So this is the averment.
this is the averment.
On the what basis of what? On verbal.
On the basis of the Skype meeting. On the basis of the Skype meeting. Now, my lord, this is one averment. Because when they are talking of contractual privity, now, my lord, this was with Sayan Chatterjee, who was, my lord, who was a manager, who represented himself as a manager of the D6. Affidavit is not by Sayan Chatterjee.
Correct.
The gentleman who has affirmed, he is not Sayan Chatterjee, affidavit is not by him. Now, this is by a manager. Now, what is more important is the representations by the director D7. That your lordship will kindly come to paragraph kindly come to paragraph 16. Kindly come to paragraph 66 at page 39. This is after I come to India now.
Yes.
I'm sorry, kindly start with 65 once, please. 65 once, please. Kindly come to 65. Thereafter, in or about the 3rd week of January 2021, Mr. Ali came to India. Mr. Ali was taken to the factory of the defendant number 10 at Durgapur outside the aforesaid jurisdiction by the defendant numbers 2 and 3. At the factory of the defendant number 10, the defendant number 7 introduced himself as a director of the defendant number 6 and 10. Now 7, Mr. Ali saying that I met defendant number 7 personally, in person. Mr. Ali also met Mr. Joydev Majumdar, who was introduced as the head of marketing. The defendant number 7 informed the plaintiff that the defendant number 1 had placed an order for supply of 1500 metric tons of medium carbon ferromanganese and negotiated rates for another consignment of 4500 metric tons of medium carbon ferromanganese. These are all, my lord, what defendant number 7 told me. The defendant number 7 also confirmed that the defendant number 1 had placed an order of 1000 metric tons of high carbon ferromanganese on the defendant number 6, for which part of the consideration had been received by the defendant number 6. The defendant number 7 requested Mr. Ali, and this is very important, the defendant number 7 requested Mr. Ali to make payment in advance to the defendant number 1 in case the plaintiff placed an order on defendant number 1 for supply of 4500 metric tons of medium carbon ferromanganese, so that the defendant number 1 could forward the same to defendant number 10, and on receipt of such advance, defendant number 10 would give delivery of the goods to the plaintiff through defendant number 1. So this is talking about defendant number 10 because these are direct in defendant number 10 also. Now kindly see the next. The defendant number 7 also assured the plaintiff that the defendant number 6 would give balanced delivery of the 189 metric tons of ferrosilicomanganese, of which inspection was taken by SGS during December 2020. So inspection had already been taken, balance quantity was to be delivered. And these are all, my lord, statements which D7 made in person to the plaintiff's director. Then kindly see 66. Sometime in the 4th week of January 2021, the defendant numbers 2 and 3 took Mr. Ali to visit the factory of the defendant number 6 at Jamuria outside the aforesaid jurisdiction. In course of such visit, Mr. Ali was given a tour of the factory and of the defendant number 6 and shown that 500 metric tons of high carbon ferromanganese was being manufactured for delivery to the plaintiff. Similarly, I went to the factory, I saw the director. Director told me that you have to make this payment. Now these facts, whether they are sufficient to constitute contractual privity, I'll address your lordship. But these facts remain uncontroverted.
What is the reply?
Yes, the reply is a denial. But yes, your lordship, now kindly see the reply once, please, my lord. Bare denial. Kindly see the affidavit in opposition of respondent number 6 and 7. Paragraphs 34 onwards, 34 and 35.
Affidavit in opposition. Page
30, please, my lord.
Yes.
Kindly see paragraph 34.
65.
Yes, 65 deals with 34, it deals with 65.
Yes.
Say what are matters and of record, what would appear therefrom. Allegations made in 65 are denied and disputed. At the outset, it is stated that the respondent number 7 is the director of the respondent number 6 and has no connection with the respondent number 10 herein. This, I'll show your lordship, is false. Because respondent number 10 is also part of the sham group. I'll show your lordship this. Now, although the respondent number 6 and respondent number 10 are part of the same group, respondent number 7 has no ties or association with respondent number 10 and is not authorized to make any representation on behalf of the respondent number 10. It doesn't matter because that is what for Mr. Bhattacharya to deal with. Now kindly see, it is denied that the respondent number 7 was present at the factory of R10 or is the director of R10 or had introduced himself in that capacity as alleged or at all. Now, I'm pausing here for a minute. It does not lie in the mouth of the constituted attorney, if at all he is the constituted attorney, because he claims to be a legal representative, to make statements apropos the what has transpired between the respondent number 7 and the plaintiff's director. He has no personal knowledge of these facts. Even in the trial, I'll show your lordship, even in the trial of a suit, such statements are not accepted. Far to speak of now affidavit evidence. So all these denials.
You mean to say the defendant number
7
has not filed the affidavit
grateful
and through the manager or representative. So this affidavit cannot be said that the affidavit.
Yes.
It is the denial.
This denial is no denial at all because it was a legal representative. Even if he were a constituted attorney, the law is Mala that a constituted attorney can depose only on facts which are to his knowledge. Even in the hearing of a suit, these cannot be considered. And an interlocutory application of such seriousness is sought to be dealt with in this manner. Yes. Defendant number 7 does not deem it necessary to swear these things on oath. Then, my lord, kindly see. It is also denied Ali met Joydev Majumdar. Now, he is not even there when I met Joydev Majumdar. So, these are all bare denials.
What about the 67?
Then 66 is in 35.
Yes.
With respect to the content stated in paragraph 66 of the said application, the answering respondent states that in the course of business, several interested parties visit the premises of the respondent number 6, but no specific records of the visits of Mr. Ali along with R2 and R3 exist with the answering respondents. However, assuming such a purported visit took place at the factory of R6, it is an admitted fact that there was no contract. He comes back to this, my lord. It is an admitted fact that there was no contract for sale, supply of goods at any time between plaintiff and the respondent number 6. And thus the answering respondents are not bound by any contractual. This is the common refrain that there is no contract and therefore we are not liable to do anything. Then kindly see, it is stated are no way connected with R2, R3 and etc. etc.
What about the paragraph 16, 17 of the D6?
Beg your pardon, my lord?
Defendant number 6.
16, 17. Yes, 16 and 17, your lordship will find at paragraph 14.
Yes.
It is paragraph 14 at page 18. It is stated that given the answering respondents in the course of business have numerous meetings and negotiations with interested parties towards procurement of goods, the answering respondents cannot specifically recall any such Skype meeting taking place between plaintiff, petitioner and R6. Now, my allegation was very specific. It was a meeting with Shayan Chatterjee. Shayan Chatterjee has not stepped into or has not sworn an affidavit saying there was no such meeting. The contemporaneous documentary evidence would show that there was a request for a meeting and he says, I don't remember. I don't remember is not a denial. And that too not from Shayan Chatterjee. Now he says, however, assuming such purported meeting took place between the plaintiff, petitioner and R6. Now he says, however, assuming such purported meeting took place between petitioner and R6, it is an admitted fact that such initial discussions did not result in any contract for sale or supply of goods between plaintiff, petitioner and respondent number 6. It is denied that during the course of alleged negotiation between R6 and the plaintiff petitioner, respondent number 6 stated that it was aware or that everything is denied.
Yes.
Then kindly see about paragraph page 19. It is denied that R6 purportedly confirmed or assured the plaintiff that R1 was associated with perform. So this is a denial of the representation. Again, the representation made by Shayan Chatterjee on behalf of R6. Malad, there is no averment here. Your Lordship will go through entire paragraph 14. Your Lordship will find there is no averment here that Shayan Chatterjee was not competent or authorized to make this representation.
Yes.
Now, the only person who could have denied that I never made this representation on behalf of R6 was Shayan Chatterjee. Affidavit is not affirmed by Shayan Chatterjee.
Yes.
So we are dealing with affidavit evidence now, and your Lordship sees there is no evidence at all on affidavits as on date. So what the Honorable Division Bench was confronted with, that you have not filed any affidavit dealing with this allegation, that position remains the same today. Even after filing an affidavit, they choose not to deal with these allegations. Now, Malad, kindly see how he affirms these paragraphs. Kindly come to his affirmation. Very interesting. Kindly come to the jurat of this affidavit. Which is at page 57, please, my lord.
Yes.
The statements made in paragraphs 1 and 2 of the following affidavit, of the foregoing affidavit, are true to my knowledge.
Yes.
So nothing else is true to his knowledge. Now, my lord, kindly see, and those made in paragraph so and so, we are concerned with, my lord, paragraph 14. He says partly, and then we are concerned with paragraph 65, 66, 67. I'm sorry, paragraphs 34, 35.
Yes, 34, 35, partly.
Partly are based on records that I verily believe to be true. What records? He has not referred to any records. He says, I have no records. And then he says, my humble submissions before this honorable court. The rest of those paragraphs are humble submissions. He does not say what of the records, what part of 34, 35. Which part of 34, 35 is based on record? Which part it is submission? There's no clarity. If there was anything, he had to have clarified. The Civil Procedure Code provides that you have to say specifically what part is true to your knowledge, what part is true to what you believe on records, and what part is your submission. Keeps it deliberately vague. So this is the affidavit they file after taking directions from the division bench.
Yes.
Now, Malad, the second limb of the, so no, I'm not on the legal part now. I'll show your lordship the decision. Now, Malad, kindly come to the documents which they rely on. Because my endeavor to before your lordship will be to say that this is no affidavit, the position remains the same. Now, the documents which he relies upon are at pages 86 onwards. 86 to 120. Kindly see the documents at pages 86 to 100. These are invoices which D6 claims to have raised on D1.
Yes.
These are invoices which he claims to have raised on D1. They refer to a purchase order and date, and the purported purchase orders are at pages 79 onwards. 79 to 84.
79 to?
79 to 84. These 6 79 to 84 are the purported purchase orders which D1 has raised on D6, and D6 says that in terms of these purchase orders, I have supplied goods under these invoices, which are 86 onwards.
It's a D1's purchase order.
Yes, well, purported purchase orders, I would say, because I would say that these are all fabricated. 79 to 85.
Yes.
Down.
To D6.
Yes.
To D Shamsel.
Yes.
Yes.
Now, 86 to
120.
120 are the purported invoices
Yes.
which D1 has raised on D6.
Yes.
Now, on the basis of these documents, D6 would have your lordship believe that for the orders which D1 placed on me, I have supplied goods. Whatever payments I have received from D1, against those payments, I have supplied the goods. I have nothing extra, surplus which is left with me, and I am not liable to pay anything or refund any monies to the plaintiff. This is his contention. Now,
To the plaintiff.
he's not liable to refund any monies, whatever is received from D1.
But the D1 has, as per this document,
Yes.
the D1 has purchased the order.
Yes, my lord.
Purchase order.
Yes, my lord.
Placed the purchase order.
Yes, my lord.
And as per the purchase order, he has supplied the materials and raised the tax invoice.
Yes, my lord.
And he has received the amount.
He has
So
received.
there is no further
There's
amount
nothing
pending either to give to the plaintiff or to the D1.
I'm grateful. For that, your lordship kindly takes page 78 once. He's also disclosed his purported ledger. Kindly see page 78. This is his ledger with D1. Exactly what your lordship is saying. I'm just telling you, your lordship is, your lordship's understanding of D6's case is what D6's case actually is. Kindly see page 78. He shows a ledger. This is his ledger between D1 and D6. Account ledger starts at page 71. The relevant portion, I'm just showing your lordship 78. He says whatever money is debit, credit is the same. Balance nil.
Yes.
Whatever payments here, these include payments other than, they have dealings, other dealings than my contracts also. So whatever he says, nothing, all squared up.
So these are D1 and D6.
D1, D6 ledger starts at 71.
Yes.
So whatever money is received from D1, goods have been supplied, balance is nil. This is his case. What fell from your lordship? This is what he writes. Now, my lord, since these documents seem to be the bulwark of his defense, at least what I understand, he may have another case. I call upon them to give inspection of the originals. This is my notice, my lord. A reply. I gave them two notices, my lord. One was.
It is the D6 or D7? D6.
D6. Because they are common solicitors for D6 and D7. Uska reply. Uska reply kahan hai? The first is an email of 17th January, where I seek inspection of the original of Annexure B, which is the documents which I showed your lordship, my lord, the so-called purchase orders and the purchase invoices. To that, the response is, there's a refusal. I'll just show your lordship. And then while I take out the letter, kindly see the next document there, 27 January. I give them notice that very well, you don't give me inspection, you produce the originals in court for the honorable court to take. That also I don't think they are complying with. Now they stand in the reply.
Mr. Bose.
Oh, it is annexed to my reply. Kindly see.
Mr. Bose, I think I will remain in this division.
Well,
I will be.
It is the order of Mr. Thakkar. I comply. There is no order. And unless, of course, it's his order, where's the question of complying?
I am nobody to give an
He
order.
has given-
Unfortunately, the law gives an order.
The law, according to him, that's what the law says. According to me, the
Yes.
law says otherwise.
Well, we'll understand what the law is. I am not nobody here to
Waiting
give
to
an order.
understand.
I only take orders from the court, not from Mr. Bose.
Yes.
Kindly see my reply, please. One of the letter is annexed to the reply.
Reply.
In the supplementary. Can I hand over the supplementary? So anyway, Mr. Bose has made it clear that they will not give inspection. Kindly see Annexure E, please, my lord. At page 100. Page 100, please, my lord. 101 is my letter of 17 January, which I handed over.
100.
101, lordship kindly has. 101 is my letter of 17 January, which I handed over to your lordship. Please give inspection. 100 is their reply. We are in receipt of your email whereby you have requested our client to provide inspection of certain documents as mentioned in your mail.
Yes.
Such documents being annexed to the affidavit in opposition filed on behalf of our client to the captioned application. In this regard, please know that our client is not liable to provide inspection of any document at the interlocutory stage.
Yes.
These are lawyers writing.
Yes.
If the suit progresses to trial, you may seek inspection of documents referred to or relied upon by our client in pleadings filed on their behalf at the appropriate stage and pursuant to directions of the Honorable Court, which may be passed. So they are not liable to answer my requisition. Kindly take the Commercial Courts Act now. And the CPC and the Civil Procedure Code.
Yes. Which provision of the CPC?
Kindly take order 11. Your Lordship, I'm grateful. My order 11, rule 15, please. Order 11, rule 15 of the Civil Procedure Code.
Yes.
Inspection of documents referred to in pleadings or affidavits.
Yes.
Order 11, rule 15.
Yes.
Every party to a suit shall be entitled
Yes.
at or before the settlement of issues, that is, before the suit progresses to trial. You'll kindly see what his lawyer has written. After it progresses to trial, to give notice to any other party in whose pleadings or affidavits reference is made to any document, or who has entered any document in any list annexed to his pleadings. This is a commercial suit. I am covered by both. He's filed his written statement. These documents are referred to there also. To produce such document for the inspection of the party giving notice, such notice or of his pleader, and to permit him or them to make copies thereof.
Written statement filed.
Yes, these documents are referred to in his written statement also. And he says, I will not give you inspection. I will not produce before court. Then my lord kindly says, and any party not complying with such notice shall not afterwards be at liberty to put any such document in his behalf in such suit unless he shall satisfy the court that such document relates only to his own title, he being a defendant to the suit, or he had some other cause or excuse which the court shall deem sufficient for not complying. So today there is no affidavit. These documents cannot be looked into. I have given him notice. He has refused to produce.
Yes.
And your lordship has seen the letter. He says that when the suit progresses to trial, I will give you inspection. Not before that. Our client is not liable to provide inspection of any document at the similar. This is an order 11 of the Civil Procedure Code, not my order. Now kindly see the Commercial Courts Act once, please.
Yes.
Kindly have order 11 of the commercial, where the Civil Procedure Code is modified by the Commercial Courts. Kindly come to inspection. Order 11 as modified 3. Inspection.
Yes.
Sub-rule 1. Written statement ka date bolo. Kindly see sub-rule 1. All parties. 3.1. Inspection.
Yes.
All parties shall complete inspection of all documents disclosed within 30 days of the filing of the written statement or written statement to the counterclaim, whichever is later. The court may extend this time upon application, but not. So it is filed within his written statement. Also, I am entitled to inspection. It has to be completed within 30 days. Then any party to the proceedings may seek directions from the court at any stage. Now kindly see, my lord, at any stage of the proceedings. This is even before. At any stage of the proceedings for inspection or production of documents by the other party, of which inspection has been refused by such party, or that the documents have not been produced despite issuance of a notice to produce. This is not before filing, after filing, nothing, at any stage. Order in such application shall be disposed of within 30 days, including filing replies and rejoinders. Now, my lord, if the above kindly come to 5. No party will be permitted to rely on a document which it had failed to disclose or which inspection has not been given, save and except with leave of court. This is unfortunately the law. Now his whole defense, there is in my respectful submission no affidavit worth its name in this affidavit. Now I'll deal with the law. So much for the facts.
From 19 December.
The written statement was affirmed on 19th of December.
19
December. 30 days gone. Now, so affidavit, the power of attorney, law देखो.
Fix it. Yeah.
The lordship has another fixed matter. Kindly give us tomorrow, my lord. Then Mr. Bose is in a hurry, so I'll finish off defendant 6, my lord.
I heard to. tomorrow क्या 11 बजे फिक्स है ना? Actual 9 the
Whatever little is left of it.
कल क्या है? कुछ भी नहीं है.
Well, any day convenient, your lordship.
परसों Monday Tuesday तो छुट्टी है. कब है? देखो कुछ नहीं है. 11 बजे को 11 साढ़े 11
12th or 3rd.
से पहले नहीं. 11 बजे ये तो कमर्शियल है ना?
This is commercial, my lord.
टॉप में रखो.
On, my lord.
11th 10th
Yeah, any day.
10 में कुछ दिया था लगता है.
10, 11th.
10 तारीख को कोई मैटर रखा था नहीं.
और petition time किया रहेगा.
साढ़े 11 बजे. So and so appearing for the plaintiff. So and so appearing for the defendant number 1. 2 is nobody is appearing.
Hello?
My lord,
Nobody is appearing for the 2.
1 and no, 1 to 5 are
Mr.
together.
Bose is appearing for
1
only
to 5
one.
is together.
By cases 2, 3, and 4 are the by directors. They are not 5.
Achha.
So 1 to 5.
1 to 5. So and so appearing 1 to 5. So and so appearing for the defendant number
3 and 5.
1, 2, 3 and 5. Huh? Not 4. So and so appearing for the 6 and 7.
6 and 7.
Who is appearing for the 8, 9? Nobody. You are 10.
11 and 12.
10 is Mr. Bhattacharya.
So appearing for the 10. So appearing for the 11 and 12. 11 and 12. Police counsel for the plaintiff.
13 and 14.
So appearing for the 13 and 14. Police stuff. Now the Supreme Court has the cause title. The advocate's name should not be go beyond the half page. So counsel for the plaintiff has argued the matter in connection with the applicant in connection with the injunction against the defendant number 6, but due to 6 and 7, but due to time hearing could not be completed. Fix 10th
11 না 10 কি বলছেন?
of February 2025 under the heading adjourn motion at the top.
Can it be on the 11th, please, your lordship? Instead of
11. 11 kar do.
Great. Well, the order I'm told is expiring on the 10th. May it be extended?
10th of February?
Yes.
You mention it.
Expiring on 10th, 11th.
10th of February, na? 11th is to you mention on 11th. 10th I will extend it because 10 days is there.
Yes. Right. Grateful.
11.
No, mention করলে না তো যাবে। লাস্টে থাকে। I'm told my lord the matter has to be in the হ্যাঁ? No. Wait. List না থাকে। 4 সময় mentioning এ করে দেয়। Grateful.
I think I will continue this original jurisdiction and I will become a businessman.
Yes.
Absolutely.
There'll be more lucrative post-retirement. Grateful, man.
Your lordship will gather these experience, utilize post superannuation. My lord, in this matter, if your lordship recollects, and I'll just give your lordship the brief background. It may come back to your lordship. It's been a while since we last addressed your lordship.
Yes.
Here, what happened, my lord? Suit.
Acha, that.
My lord, your lordship. Yes. Your lordship was prima facie of the view that because of section 34, no ad interim order could be passed. There was an appeal. There was an order. Thereafter, on remand, your lordship was pleased to hear. Let's continue. I'll just.
But Mr. Bose only will get 20 because 410 I have to 45. 415 I have division bench.
I very well. Wait, just give me 10 minutes, man. I'll just quickly at least get the facts in order today. Will kindly take the cause title. That's sufficient. Well, I'll be able to, should be able to explain to you, man. Kindly take the cause title. My lord, plaintiff number 1 is the corporate guarantor. Plaintiff number 2, a company, was a borrower. Plaintiff number 3 was also a borrower. My lord, defendant number 1 is the non-banking financial company which had granted credit facilities to the borrowers, out of which the 2 plaintiffs are borrowers. Now, your lordship will see defendant number 2, 3 were also borrowers. My lord, 2 no, they were borrowers as well. Who were the other borrowers? So, my lord, I stand corrected. My lord, defendant number 2 was also a corporate guarantor and had also given collateral security. Now, defendant number 3, if your lordship see, is the owner of the property and was a personal guarantor, and D4 is a third party company. Now, my lord, admittedly, I'll tell you, one document and everything will come back to your lordship, my lord. There was a settlement agreement which was entered into on 30th of January 2020. My lord, there were total, if your lordship kindly turns to page 197, which would be part of the volume 2 of the paper book.
Yes.
Everything is in extenso.
Yes, you have already submitted.
Correct, correct. My lord, just, my lord, kindly see. Now what had happened is all these borrower companies defaulted. All of them defaulted. Now, once they defaulted, there was a settlement arrangement. It was a composite settlement. Now, this is the settlement which is at page 197. My lord, kindly come to page 201.
201, first paragraph, second.
Yes. 201, your lordship will see 27 crores, 87 lakh. This was understood under the settlement was the amount which was due and payable. Now, how was this due and payable? By whom? Now, there were 5 total separate principal borrowers. So, whose outstanding was to what extent? It is mentioned here. My lord, first, number 1, your lordship will see Mohan Motors Distributors. His outstanding on the right-hand side column is 16 crores 37 lakhs. Similarly, if your lordship turns to the next page,
202.
2, 3, 4, and 5, the outstanding amounts are indicated. Now, your lordship has also taken note of one fact also when we had initially submitted. Out of these 5 companies, 2 companies went into corporate insolvency resolution process, and subsequently CIRP having failed, they went into liquidation. Now, the 2 relevant dates according to us is the date when the corporate insolvency resolution process commenced. Yes. These 2 dates are very relevant. My lord, if your lordship, I think, has already taken note, I will once again give your lordship the dates. The CIRP dates in respect of the serial number 1, which is Mohan Motors Distributors. The CIRP date of distributor is 24th of February 2020, and your lordship will find the order at page 216. Just for your lordship's record. Then this same company went into liquidation as well, and the liquidation order is at page 222, and the date of liquidation is 3rd of August 2021.
Yes.
What is the first date? Just give me the first date. CIRP date.
24th February 2020.
Similarly, your lordship will see 3, borrower number 3, which is Mohan Motor Udyog Private Limited. That also presently in liquidation. This also went into CIRP.
228.
Yes. It is at 228 and 237. Lordship may just record the date, yes, because the date is the relevant issue here.
17th March.
17th of March 2020. And then the liquidation order, these 2. And 8th of October 2021. That was the liquidation date. Now, my lord, if your lordship will kindly turn to the page 204 once. top of page 204, borrowers have failed to repay the financial facilities to KMPL, and hence the accounts of the borrower were classified as non-performing asset, the top of page 204.
Yes.
In the records of KMPL as per the guideline issued by RBI on dates such and such. Now, Mohan Motors, these are the dates of respective dates of
Repayment.
no, my lord, these are dates of NPAs,
Yes,
NPA dates.
And
Then, my lord, 5, KMPA has initiated legal proceeding. My lord, kindly make a note of that. Against the borrowers and the guarantors before various forums. However, out of those cases, by dint of these letters of understanding, KMPL shall only withdraw those legal proceedings with the time frame as stated in the schedule annexed. So, my lord, there is a schedule by which they agreed how these proceedings will be withdrawn based on this settlement. Now, your lordship will kindly see para 6. They agree that the 13-2 proceedings initiated by them shall be kept in abeyance.
So
Which
as per your case, your clients have been overpaid.
Overpaid. Now, I have not overpaid. In terms of the settlement, they have been overpaid. Overpaid. Now, how overpaid? So, if you have overpaid, now the question is what? What is your right to proceed? So, now I need a declaration to that extent. Now, if your lordship will kindly take once, paragraph 10 at page 205.
Yes, I am there.
And my lord, based on that affidavit, now the situation has become clear because there, according to us, there is an admission to the extent they have collected through this settlement arrangement. And we've given a chart. If your lordship will adjust that with the chart, then that also shows that payment has been made in excess. My lord, kindly take clause 10 once, my lord, paragraph 10 at page 205.
Yes.
Guarantor number 1 and 3 have approached KMPL and requested KMPL is the defendant number 1, NBFC, to provide consent to lease out immovable property, more particularly mentioned in Schedule 2, annexed here to one Narbeham Leasing Corporate, which is the defendant number 4, for a period of 99 months, and further agreed to provide consent to appropriate the monthly rent, maintenance, facility charges, receivables towards part payment of the outstanding amounts due and payable. My lord, this is my case.
Yes.
Kindly make a note of that. Towards part payment of the outstanding amount due and payable to KMPL. What is due and payable to KMPL? 27 crores. You said that. So the money that you will get, you will adjust against this 27 crores. Very well. Now, my lord, now what happens is, if your lordship will take para 11 and this Schedule 2 property is released, and my lord, kindly take the first bullet point at page 206.
Yes.
The lessee Narbeham shall pay an amount of 80 lakhs as an interest-free non-refundable deposit by way of demand draft to such and such, shall be transferred to KMPL. So this will go to defendant number 1 and shall be treated as a non-refundable consideration for improvement, maintenance, such and such. Then, my lord, the initial amount, next bullet point, initial monthly lease rent and maintenance facility charges period such and such will be 10,79,000 net of TDS, and the same needs to be deposited in the escrow account of the lessee. Now, my lord, kindly see, then the lease rent increases from 10,79,000 to 12,47,000, and then the next page it increases to 14,40,000. So the last paid rent on and from the 73rd month becomes 14,40,000. This is what is being paid now, today, as on today. Now, then if your lordship will kindly take once Roman V at page 207.
Monthly rental.
Yes, monthly rental as stated above shall be first utilized for repayment of the outstanding amounts due and payable by the borrowers and guarantors. So, my lord, there is no separation. So, will be adjusted due from the amount due and payable by the borrowers and guarantors. So, that includes all 5 borrowers and the guarantors who are jointly liable to the extent that they've given. Now, my lord, kindly now turn to page 208, top. About 3 lines from the top, there's a sentence, there's a paragraph starting with, we hereby agree.
Yes.
and confirm that upon payment of entire lease rent,
Yes.
upon the scheduled property to KMPL as per this present, the scheduled property will be released to the respective owners, such and such, will release a personal guarantee to such and such. However, the case in event of default, whoever in terms of this settlement and therefore financial statement executed. Now, no case that there has been default of the settlement. Now, the settlement arrangement says, I will release the property and that property will be leased to the defendant number 4. Lease rent, the manner it will come to me, I will adjust. Now, there is nobody's case, they have never issued any notice saying that I am not receiving the lease rental, so there is a default, so I am not being able to appropriate the lease rental towards the outstanding dues. So your only cause of action, if any, is if there is a default of the settlement agreement.
Yes.
Now, my lord, your lordship will kindly come to one chart. I'll show your lordship, my lord. Kindly have take, my lord, volume 3. Before that, my lord, kindly, before your lordship takes that, kindly take their opposition ones. I have one more. I've got 5 more minutes to trouble your lordship, or maybe.
Affidavit in opposition?
Yes, my lord.
Yes.
I will address the liquidation part, my lord, on the next day. But today, my lord, allow me to, my lord, place this what they have agreed. My lord, kindly, I'll just show some of the paragraphs where there is an acceptance by them.
What is their defense? What they say against you?
My lord, they have said 2 things. They have admitted that there is a settlement. We said you have received 4 crores. Well, extremely nice on their part. They said that no 4 crores, they have received 5 crores from the settlement. But the appropriation,
total,
they don't agree. They say that I am entitled to, because we say that those 2 companies which went into CIRP, you could not have appropriated the money against their outstanding. By operation of law, the outstanding of the 2 companies which entered into CIRP as on the date of admission or as on the date of commencement of CIRP, no further appropriation could have been done in law.
So they are taking the burden of that company
Yes.
upon you.
Yes. No, not on me. From the total outstanding.
From the total outstanding.
Correct. So those two accounts of those 2, if your lordship
Their
will
accounts
see.
have already been segregated.
Segregated. I have segregated because based on operation of law, I have segregated that you could not have appropriated because there cannot be any recovery of a company which is in CIRP. Well settled. I'll show your lordship the judgment. Then what they say is that no, I have a right to recover. I will continue recovering. So those are big accounts. So if that adjustment comes, so according to them, still there is large outstanding. I have a right to proceed. Now, there are twofold argument that we have on that. Before that, allow me to show your lordship the fact that they have admitted the settlement and they have also admitted the to what extent they have received under the settlement. If your lordship will kindly take page 13, paragraph F. Well, this is where at paragraph F they accept the settlement.
Yes.
F. But I don't want your lordship to get delayed for the division bench.
Hey,
I think today we should stop here.
So appearing for the plaintiff, so appearing for the defendant, counsel for the plaintiff has argued at length in connection with GA1 of 2024, but due to paucity of time, hearing could not be completed. Let the matter appear. Commercial है ना? Non-commercial है. है. कब है? February. नहीं उसे बीच में रहने दो.
My lord is fixing up next date, my lord, I believe. Time.
I am not fixing the time.
My lord, kindly fix up a time.
Time, then it will go to the March. That is the problem.
My lord, let it be. Otherwise, my lord, the matter will not reach.
दो डेट दे दो.
At
19 March at 20 March at 2 p.m. to 3 p.m.
Can I make it, matlab, can I make it on, matlab, 2 p.m. matlab?
2 p.m. फिर आगे जाओ.
Give my lord, my learned friend 10 o'clock.
Matlab, otherwise, matlab, the thing is
2
that
p.m. 2 p.m.
2 p.m. matlab.
20 and 21st March
Matlab.
at 2 p.m.
Let that it be, my lord. Otherwise, my lord, what is happening, my lord? Mr. Bose is, my lord, addressing to your lordship. And again, my lord, Mr. Bose is starting from the beginning. And then, my lord, my counsel will come, my lord. Again, my lord, the same thing will repeat.
My lord,
Let it be completed, my lord.
my lord, with regard to item number 19 of today's list, the interim order is
Give.
expiring today, my lord.
Who is for the
My
other
lord,
side?
my lord, Fox and Bundle, I have
So appearing for the plaintiff. So the counsel for the plaintiff submitted, though the matter is
Mr. Item number
at
19.
serial number 19 of the today's list, but due to paucity of time, matter could not be taken up for hearing. He submitted that the interim order granted earlier is going to be expired today and paid for extension of the interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till commercial, non-commercial?
Non-commercial, my lord.
Till 20 February 2025 or until further order. Let the should be remain in the list. Matter remain in the list.
My lord, this is for item number 130 of the list, which was fixed at 4:15 p.m. today. This is also for extension of interim order, my lord.
Give. Immediately give. I have no time. So appearing for the plaintiff. You are for the plaintiff.
I'm for the intervener in GA 17 and 18 in this matter.
I'm for the defendant number 2.
So what you want?
We are praying for the extension of the interim order.
Interim order?
Yes.
Intervener wanted?
Extension was
The
given.
extension was.
So, extension of interim order?
Interim order.
Of interim order.
Who is for the plaintiff?
Lordship.
So appearing for the intervener. He submit that the interim order granted earlier is going to be expired.
Lordship, it was modified by the Honorable Division Bench on 18th April 2024, Your Lordship.
So?
That should be the extension, Lordship.
Where is that? This is not of my court.
No, Your Lordship. This is before Justice Vivash Patnaik.
This was before Justice Vivash Patnaik.
Where is the last order of the interim order? Extended till last week of January 2020.
Yes, madam.
नहीं concept अरे वही है going to excite today and paid for extension of the interim order. In view of the submission made by the counsel for the intervener, the interim order granted earlier is extended till 20 February 2025 or until further order.
Extension of interim order, it is expiring on 5th of February, but since there is a holiday.
Appearing for the plaintiff. Counsel for the plaintiff submitted the interim order granted earlier is going to. No, it is on 5th.
Yes, below 3rd and 4th is a holiday. Below.
On the 5th only. 5th is a working day.